All right, we'll get started. You'll please excuse me today with my voice. I feel fine, but Ron might have to tap in for me at some point. But we're excited to come back today for what's scheduled for a two-day meeting. We're going to try to knock through it today, and we'll see how exciting the discussion gets. But there's been no shortage of excitement in our industry lately with a lot that's going on, both internally here at Trek. And I was glad to see the building wasn't completely on fire this morning. I can tell you, we know they're working very hard behind us in this room to get all the new upgrades smoothed out and to work on that. So I can say I know personally everybody's working very hard to get that done. We have a bit to discuss today. We have a lot of changes that we're going to circle back through that we've made, and we have some new stuff to go over, some exciting things. But like usual, we'll go around and start with introductions.
Can I just find out who's the absence right now? I'm showing absent is Mary Minor. Is she?
I haven't heard. I know.
Kenneth All.
I have not heard either.
Latra.
I think Latra was going to join online.
Yes.
And Darlene.
And Darlene is here.
Darlene's online.
Yeah.
I'm here, but my camera is malfunctioning. I don't know what's going on, so I'll work on that. But I'm here.
And who else do we have online? Okay, so we'll start. If you'd like to introduce yourself for your first in-person meeting, I'm glad that you could join us in person today.
I'm Kristen Porter. I'm an attorney in New Braunfels.
Okay.
Of course, Ron Walker. I'm sitting next to Christian now.
Christy Tatum Jansen, broker member.
Diane McCoy, broker member.
Tony Malley, attorney member.
Melissa Haley, broker member.
Candy Lindsay, broker member.
John George, attorney member.
Brian Watts, attorney member, except Tony wrote my visitor thing and it says old Brian.
Separate y'all. All right, and our visitors.
Kirsten Crawford, broker. Becca Cantu, agent.
Lori Levy, general counsel with Texas Realtors.
Corey Connor, senior associate counsel with Texas Realtors.
Leslie Vasco, broker.
Bernita Ramirez, assistant general counsel for Trek.
Abby Lee, general counsel for Trek.
Right, and online we have a ghost.
That'd be me, Darlene Fairchild, public member.
Right.
Still working on the camera.
And who else do we have here?
Commissioner Lowe.
Commissioner Lowe's on with us, one of our liaisons to the committee. We're always appreciative for joining us every time.
Rest of staff.
Okay. So we'll jump right into the materials here. First, I don't know if you have any public comment on non-agenda items. Any public comment on non-agenda items? No? Okay, so we'll go into the next one, discussion regarding the contract forms. And let's see here. So what this is, oh, go ahead. So we have some old technology that's being shuffled out. Hey, and we have Mary Margaret.
An hour and 10 minutes.
What?
Never has been an hour and 10 minutes.
Well, we're glad you're able to join us. We're getting worried for 10 minutes. So Mary Minor, broker member.
Hi.
We just got done with the introductions. And so the next thing Abby would have for us is some technology is no longer available with how we used to produce our forms. This is separate from all the other Trek upgrades. This is just a software issue. So
Yeah, so it's sort of a blessing and a curse, but we currently use Publisher, Microsoft Publisher, to produce all of our forms. That program is going away soon. I think October is the end date for that. So we are in the process of figuring out what platform we want to switch to. I think we've identified that, and basically changing all of our forms to that particular software. What I wanted to sort of take the opportunity to ask you all is, in the process of doing that, I think we can get very close, if not identical, look and feel of the new program. But it does present sort of a unique opportunity that if there are look changes, feel changes, format changes that you have been dying to tell us, please change this. This is a really great opportunity for us to kind of be able to do that. So I wanted to kind of throw that out there. no one has to have any ideas thrown out today. You can always just let us know, but just wanted to bring that to your attention. And then kind of the second part of that, in the event there would be any change we would need to make to the look, which I don't anticipate, but if there would need to be any change, if there was just a couple of you that we could run that past before we made any change like that. We would present any change to the committee, but just kind of getting a sense before we do that of is this okay or not?
Awesome. So I'm real big into nostalgia. So I love the look of our contracts. I think they are very readable, especially if you look at some of these other states. And my litigation practice, when I have all these other states that have numbers on their lines, and it can get very hard to read, at least for what we're used to. But it is an opportunity for us to look at this as a whole. We don't have this type of opportunity many times to do changes like this. So I thought it was going to recommend forming a subcommittee working group to look at this and to work with Abby and to see if there are any changes we want to make. And this can go from, with this opportunity, not only to the overall look, but to this general formatting. Maybe it's a bigger opportunity to look into that. And so I would like to form a working group, especially with brokers that are using these forms, on how it would look. So I don't know if I have any volunteers that would like to do that. I don't think it'd be a lot of work.
Way to volunteer, Diane. Way to get in there.
She volunteers for everything.
Always have
I was letting, Diane helps move these working groups and keep us on track, and I hear she's a blessing to have on that. So that's so you have Diane, Mary,
I'll work on it
Christy.
with her as well.
So we have Diane, Mary, and Christy.
And I think this is more of a visual thing, so I'm not sure we want to come up with the terms to go on there and say to do this.
Did you say that? I did say that. I heard it. I'm sure it's recorded in the minutes.
Absolutely.
You know, we had a,
New Roman, man.
I can't tell you how many at my old firm, we had a meeting on,
There you go.
I don't know how many lawyers were in there on whether you italicize a period and whether there's one or two spaces after a period. So,
Are you serious?
yes.
What was the answer on the spaces after the period, by the way?
It was not answered at the end, but the two spaces won that meeting, but it was close.
The two spaces
My kids
was
mock me.
way on back in the day, but they don't do it anymore.
I'm going to reserve comment on what I think because that, I don't want half the room to hate it.
Abby, does this change affect the vendors?
Just have that whole handout on popular comment here.
It shouldn't. We produce, once we produce it in Publisher, we transfer it to PDF, and that's what they use. We would do the same thing.
I do have a question on the transfer, and I'm not sure this was correct, and actually Kirsten brought this to my attention. The IBS and zip forms had dudes in it?
Dudes instead of duties, yeah.
Where would that issue arise? Is that something that was at the form and was in there, or is that,
That's.
and how we can prevent that? Okay.
So Texas Realtors sends the forms, including track forms, to, actually, they get your forms themselves too. So I don't know if they got it from you or us. The key thing to know here is that Zip Forms is the only vendor that retypes all the forms. They don't just upload the PDF. So we have to proofread every single form we send them. But this time they posted the track forms without our proofreading, and then it was caught after that. So it should be fixed, if not yet.
It is.
It's fixed.
Kinda
But
like
that's what
dudes.
happened there.
I'm glad people are reading
Brokers
those to point
dudes.
to pick up on
The
that.
brokers
That's,
dudes.
And the Texas Realtors hotline is key in all of this, because that was the first place we heard about it.
Oh, wow.
Awesome.
So, yeah.
Well, that's a little scary that they're retyping everything. So now I have on my agenda to go look at what's actually going out there. But that's good. So a good opportunity. So we have Christy, Mary, and Diane, right? Okay. So next we'll go report by the BLC working groups. The backup, I had a pretty substantial discussion to go over with the backup group. So I kind of want to reserve that to the back. We start with Farm and Ranch. Is there any meetings at the Farm and Ranch?
There was not.
Okay. Then the disclosures group, we have the disclosures. And I believe that might be it then, that we come down to any other working groups besides backup.
The only other one we were gonna talk about was the buyers thing, and we never did anything with that. The buyers rep.
The buyer's rep, right? I think with the timing, that, and then we go into our paragraph 12 farm and ranch discussion coming up here. Let me see. So we met as the backup working group, and the backup working group is a little bit of a misnomer because it was expanded to look at the notice provision, and it's also expanded to look at the ordering of the addenda. And so the notice provision being paragraph 21 and the addenda being in paragraph 22. And to give you a brief idea of, as I go through this, where our thoughts ended up is we believe that paragraph 21 should be revised to provide better clarity, to better reflect the actual practice in the field, while at the same time addressing the legal concerns. Paragraph 22, we looked at from a couple different angles, and whether the ordering of all the addenda that are kind of thrown in there, and also the duplication notes between paragraph 6, which lists all the title notices, and then paragraph 22 that had some that were duplicative of that. And is there a way that we could clean that up so there's not two places to look, and so to make it more streamlined? And so we ultimately arrived at, let's put everything in 22 with a new way to order the addenda. And so we'll present that today. And then with the backup addendum itself, we look at it from the earnest money receipts and the additional option fee language. And we have a recommendation on where to put the receipts, which is subject to some discussion. We really want everybody's thoughts on that. And also a new form for notice of removal of the contingency. That there's one that's available for the trade association, but we don't have one that's TREC from TREC. And this is one notice that we thought was important enough and simple enough to reduce controversy that we have a form to suggest. So we'll start with paragraph 21. And if you want to look in your materials, all the notice language is the same. The 1 to 4 starts on page 39 of the materials. I forget exactly what page the paragraph 21 is. But the question comes up of what is a notice in the contract? That paragraph 21 states all notices, lowercase, from one party to another must be in writing and are effectively mailed to and delivered or transmitted by fax or electronic transmission as follows. In the not too distant past, we added a with copy to agent to the information there. Because you at the time thought, well, the information being filled in, a lot of times the agent's information, not the actual principles. And it's not how it's intended to be used. So we've added the with copy to, so the agents are copied at least on the quote unquote notices. And so looking at first, what is a notice? The working group went through and made a list of all the notices in the contract. And so if you do Control F and search notice and all the contract and addenda, a lot of them are tied to termination notices, but not all of them. And notice is beyond just something that's specifically stated to be a notice. So, for example, walking through some of the contracts, like failure to deliver, these are specific notice provisions, just by example. I won't go through the complete list. If you're interested, we can provide it. Failure to deliver documentation, documents under the condo contract. You have to provide notice of termination there. You have to provide notice of termination for failure to deliver the certificate for a condo. For the one that's a little unique, we don't think about, new home incomplete, seller's notice about required selections, right? It has in there saying that you have to provide notice of the required selections in that clause. Notice of oral leases, the big one, the option termination, right? There's a notice specific there. So if you go through the contract and addenda, there's all these notices, and I have a list of 23 right here. There are just for 22 that are specific. But then you go into ones that are not just the notices. Let's say a title objections, for example. The title objection, who do you have to make the title objection to? Right? You give notice under paragraph 21 to make sure that it's effective. And, whether it's excess expenses or casualty loss elections, you have to make sure these things are when you take these actions that you're following the notice procedure, right? That's what we would think. But if we look at the case law expands what can be an actual valid notice. And the Supreme Court has a fairly recent case that talks about how strictly do you have to comply with the actual notice provision. in one of the Supreme Court cases, James Construction versus Westlake, in 2022, says that party substantial compliance with the contractual notice conditions is sufficient to satisfy those conditions. However, when a contract requires written notice, a writing is necessary as part of complying with that condition, substantially or otherwise. A contrary holding allowing a party to elude the benefit of the bargain they freely made would open up the door to host of factual disputes about whether proper notice was given. The very kinds of disputes that the written requirement was intended to foreclose. So we go for one step. We have a notice provision that requires a notice in writing like we have. The Supreme Court saying, yeah, you don't necessarily have to follow it exact, but that written requirement adds to the scrutiny. We look at it to make sure you can't get out of that written notice. Okay, so we now know from this, we can deduce that we have to at least provide it in writing. So let's go to the real world example away from the attorney world, but what's happening in our contracts? Notices are being provided, one, not knowing what a notice is. Two, it's being provided a lot of times to the other agent on the other side, whether their information is written in or not. So the question becomes, is that an effective notice? And that's a big deal for the boots on the ground of, am I terminating the contract properly? And on this committee, we've had experiences personally recently of that being the exact issue that has caused potential liability for the principals and the brokers alike. And so looking at another really recent case here, November 8th of 25, out of the Business Court for the 11th Division, it analyzed a real estate contract. It wasn't our TREC contract, but it was a commercial contract. And it contained a notice provision that's substantially like ours. It was a notice to the parties with a copy to the agents. And this is the City Choice Group versus TMC Grand Boulevard Land Co. Cause number 24-BC11A-0002 for the lawyers that want to look this up later. But here it analyzed a provision, and some of the facts behind this, which are important, are the buyer's agent provided notice of termination via email during the inspection period. It's kind of like our option period in our TREC contracts. The email notice from the agent stated, attached is a First Amendment that you requested to sign and return, that you are requested to sign and return to me effective immediately. If you cannot sign and return to me, then this email serves as our notice to terminate the agreement. Lots of different issues in there. But the issue that we're focusing on is this was sent agent to agent, even though the contract said it needed to be provided to the principal. So going from there, the notice contained the same thing we had with copy to agents. The court held that the buyer clearly did not strictly comply with the contract. Right? The contract said you had to provide it to the principal. But the court refused to apply the strict compliance standard. Said you don't have to strictly comply. They found that the court looked at option contracts as one area that there may be strict compliance required. We don't have option contracts. Option contracts, we have an option period is a whole nother beast. So in other contexts, that strict compliance might be required. But in this particular case, the court found that a party's minor deviations from the contractual notice condition that do not severely impact the purpose underlying that condition and causes no prejudice do not and should not deprive that party of the benefit of its bargain. That agent got the email. I believe there's evidence in this case that the principal even got it and actually saw the email. And so what it said is, moreover, the doctrine serves as an important purpose of preventing parties from engaging in bad faith gotcha tactics to avoid their own contractual obligations based on a technicality. And I just love a few quotes out of this case are really great. While this rule clearly phrased to address a situation where a party seeks to benefit from its opponent's failure to strictly comply with contractual notice provisions, there has been no argument that the rule would or should be different if a party seeks to benefit from its own failure to strictly comply. Here, the buyer substantially complied with the notice provision of the PSA in its unilateral termination because the notice termination was effective and conformed with the conduct between the parties communicating regarding that purchase agreement. And so what we have in the cases with our TREC contracts is a practice that's happening on the ground that doesn't match the contractual language we have. this issue's come up many times within the committee, and we always look back, well, there's case law that says this deemed notice issue. Even though you don't send it exactly like the contract says, the court can deem it proper notice. And this is a lower court, right? It's going to go up, and there's other issues, but it's a fact issue that has to be analyzed each time. And so what we're looking at in the subcommittee or the working group is how can we address this to meet what's actually happening? In the past, we've had education attempts in the legal update classes. There's a whole page I think that's dedicated to how to provide notice and to get over this uncomfortable thing of if a buyer or seller lists their information in paragraph 21, that's where the notices need to be sent. And it just feels weird as a practitioner, as an agent, license holder, as sending notice to the other side. Right? What about the ethics rules? I can't communicate with the other side. That's not right. It doesn't feel right, but it is right. That's what the contract says we have to do. And that's okay. And that's what the materials, education materials, attempted to let everybody know. But the education hasn't worked. And the practice in how it's being filled out is still putting agents' information in there, or it's blank and just with copy too. So how can we address this? And the legal brain on my side of this, it took me a minute to get over the suggestion that we have and to do, because to me, I do want it to go to the principal. I do want it to go. I think they should be. I don't want to put agents in the zone of liability, right? Because they're in the middle, they get the notices, they don't turn it over real quick, and it can create issues. But they're already creating issues. Right? And you can go around and talk about this. If we see this all the time, it's not just a little thing. It's pretty pervasive. And so we do think, how can we look at making this more clear? And so we have a proposed revision to the contract that allows, we had two different versions of it, and Ron actually needs to send this to you, that allows a notice to the agent either by the language itself to be effective. This outright notice to the agent is effective. Or a second version that has an option that has a box to check to say, structure similar to what we have now, but an option to check that you can make notice to the agent effective. With the thought, the instruction with the box will make it clear that if it's not checked, you have to send it to the party. Right? We're not trying to educate in the contract. We're trying to make it clear of what the actual contractual obligations are. And so by having that, we hope that provides some clarity, and we're never going to remove all the disputes, but that was the intent behind doing that. And as I'm pulling us up, our all of committee, so we had on the subcommittee, Melissa, Diane, and Christy. Feel free to chime in. It was being the only lawyer, it's great to have the experience of the boots on the ground of how to fix it. So feel free to chime in while I'm pulling this up to send to Ron.
I think this is interesting because we've always been taught if the notice goes to the other agent, it's a delivered. It didn't have to go to the actual person.
It was the concept of implied.
It was, yeah.
Yeah, it was implied.
So I think,
also-
In the case law, I mean, I've had several of these litigation cases recently. Y'all have done apparently a very deep dive in it, which is fantastic. But in the case law, and I think you just said it as well, but get it over there, get the notice over there, and the courts expect, they're going to look at it. Did you really get it there? So writing would be the best evidence that you really got the notice there. And if you got it to the agent, well, let's look at that word. They are the agent of someone. So you technically got it to the principal. Now, your commercial case aside, if the principal vehemently says, but they never got it to me, well, then now there might be a fiduciary duty problem on that side, but that principal is still bound by that contract because the buyer got the notice to the seller's agent. Sorry, principal, you didn't get it, seller, but that deal's good. Now you might want to take it up with your agent. Is the concept that generally the cases hold, like as you're saying, you got it over there. So we're trying to do the contract to say you can check the box for the agent or you can check the box. I haven't seen your language yet, but you can go agent but wouldn't the case law really pretty much be however you got it there? Even if you didn't check your box, it was sufficient. Whether you're like, I checked the box that goes, I want it to go to my agent, or I checked the box, I don't want it to go to my agent. it really doesn't matter. The case law, I can still send as a buyer's agent. I'm still sending it to the agent anyways. Who cares? And it's still effective regardless of what you check.
Did you need to send the
It's
20?
in there. We're technically the backup.
Yeah.
So I think
So, but you're not sending changes to 21?
It's in there. It's, if you open it, I went ahead and sent you the whole
Oh, okay.
thing.
I think the,
If you,
Let me double check.
because there would be other things.
well, they're working on that. I think the conversation back to what you just said though is that didn't happen in a lawsuit
Sent to
recently that one of our broker lawyer
Sent to
members
one.
was involved in. And
Is it
they
in the same,
sent the
document?
notice
If you scroll down.
from agent to agent, we're terminating and we want the release of earnest money.
That one
Sure.
page.
And the principal was an attorney and said, but you didn't send it to me, and it says right here, you're gonna send it to me, and I'm keeping your earnest money. And that's what they did, and I think it's happened twice.
Two thoughts on that, Tony. On some of the case law, I saw, what's the scope of the agency relationship?
Right.
And is with receiving legal notice within that scope of the agency? And so that will be a question that arises from, and I'm not aware of any specific case on our buyer reps, say our buyer reps, Texas Realtors buyer reps, or listing agreements on the scope of the agency granted within those documents. How a court would analyze that specifically for receiving notice. It'd be great to see if there are the
I'm not
cases that
either.
say within.
I would think the fiduciary duty concept would be, you got this, whether it's a legal notice or not, whether it's in your scope, you should have passed it on.
Yeah, and I think those are absolutely fiduciary. That's going to be an issue there. But for legal notice requirements, the one thing, because I struggle with that too, right? From my legal side of, then the issue comes a couple fold of having it, one, being clear in our directive as the committee to reduce controversy. And the cases that there's been the personal experience with the members on this committee has been, it hasn't, as with most residential real estate transactions and issues, doesn't go all the way through trial.
Yeah.
And these have been damages and substantial attorney's fees incurred and fighting and disputes that are controversy nonetheless. Can we solve that by the language? And the language that we have, and I sent around the wrong document to begin with, but has stating it's either or, basically, to the agent or to the principal as effective notice. Or the second one is you have to check the box to allow notice to the agent to be effective.
I'm with you. I'm actually on board. I like the idea of guiding the scene. I like make it clear. I just don't know that is going to alleviate notice litigation later. If you check the box for the broker, we can do the language. I think that great. Anything we can make it clear, but I'm not sure that's going to change the needle later when someone said, I sent it to the agent and they're like, but the box said send it to the principal. I'm not sure it's going to make a
I
difference.
do think that we have one of the options. One had check boxes, the other one did not. And I think them being able to see the language will be very helpful on how we structure that, especially the one without the check boxes.
Yeah.
Well, the fiduciary duty that you mentioned actually cures a lot of the deficiencies that are out there currently, because what's happening is I think the brokers out there are noticing that or realizing that they do have a duty to pass this information on, and they do.
Yeah.
So I think right now we're in a situation where it cures more defects than we know, right?
And that's when the courts look at it. Did they actually get the notice? Did they, what's in this particular case that came out in November, was that what's the course of the party's conduct? How were they communicating through the whole deal? And so that and maybe with the language we have can help focus those issues, even if it doesn't ultimately solve it. Well, no, the intent, they wanted to make it effective, they could have checked the box. And so that's the course and how the contract was written. And so we're going to read to make that a little more bright line. I don't think we can ever make it bright line unless we may go to look at the language like we have from default that you drafted. That makes a pretty bright line there. So there may be a solution that we can come up with to make it even more crystal clear. But I also went back of, do we want to do that? In the back of my mind, and we didn't discuss this at length, but do we want it really black and white, knowing agents are still going to screw it up, and having notice to go over, to be effective in certain situations where it's clear and a gotcha tactic, as the Supreme Court or the business court was looking at? Do we want that little bit of flexibility there to make it, reasonable in cases where, they got the email, they were there, went to some other thing, and there's no question the principal had it. But I think making that as bright line as we can with knowing that might be the ultimate issue. And so,
Will you do the one that says D first on the page?
yeah, if you're gonna top.
Go up one more page.
This is the optional one. We thought first having it clear is what we did in the revised paragraph 21, we added, the language is the exact same except for the delivery to the party's agent. And we added a little bit in terms of the address and the boxes.
Ron, can you give me a little zoom? My age is starting to show.
So-
I think we focus just on the main paragraph. We don't have to worry about what's below right now.
Yeah, just give me a
Oh, okay.
little help. Thank you.
I think it was supposed to say mailed, hand delivered at, or transmitted by.
What about the concept of just, or when actually?
It has mailed to in there.
Huh?
It has mailed to.
No, mailed, ED.
He was copying the
Oh.
exact wording from the current 21, and the current 21 says mailed to.
Oh, got you.
Yeah,
Got you.
that's what he meant, yeah.
I really want to move facts from there, but I think it gives you a this version.
Yeah.
Well, I did like the fact that you're moving the
a fax is
parentheses here.
electronic. A fax is an electronic transmission.
So,
That's true.
John, are you wanting feedback on this now, or I should just shut up and read it?
So, I think now's the right time for feedback. I'll say one last thing here. I struggled with this from the legal side. Of putting this puts the agent squarely in the middle of having notice of them be effective, right? It crosses over to say it explicitly. But I got over that fear because that's what's happening already. And it admits the clarity of what's actually happening on the ground.
Yes.
So that's why I end up like, but no, I think feedback.
No, I think you said it right, which y'all said, like, it's not natural in the industry to start directly speaking to the other side or to encourage your people to speak to the other side, and then no telling what will snowball from there. Well, they started talking about termination, then they decided they put the deal back on. Well, what are you talking about? Like, it's natural that you want to keep it agent to agent. The agents already, if they're doing a great job, they're already communicating every other aspect, coordinating that they should be on this contract, title, everything. Why stop there? And then they have, as we've just mentioned, they're still going to have a fiduciary duty if it lands in their lap anyway to do something about it. So I'm with you. Why put them in the gotcha situation where they got to make sure they look at their emails or their text to make sure that they didn't get someone's notice of termination, but they already should be doing it anyways because they're facilitating the transaction so they can get paid.
Yeah. Well, and part of our discussion was, just like what you just said, that we're working agent to agent the whole rest of the time. And it would be weird at some point later in the contract to just be like, oh, and by the way, now I'm going to start talking to the other principal.
Right.
Yeah.
But that hasn't been the precedent of the contract. So it's weird for the agent, but it's also weird for the consumer. Because if I'm a consumer and all I've been doing is talking to my agent Diane, and all of a sudden I start hearing from another agent, Christy, I would be like, Diane, Christy just called me. Like, Christy just emailed me. I would be freaking out as a consumer. Why is the other agent even talking to me?
Right.
So it's for agents and for consumers as a practice, the way that we do everything else in the transaction. I mean, we had this discussion quite a bit because John was trying to make sure we knew we were opening a can of worms, so to speak.
Well, we do this.
We do it, but from.
All we're doing is putting it in
You don't
paper
feel
to
like
say,
it's
do
really
it. I mean,
Right, right.
we do
Responsibility on it.
this.
Right. And so,
That would be my.
and that was my concern, and where I got over it was what Tony's saying, that fiduciary is
It's already
issue-
there.
an issue already there, and does it help reduce controversy if I'm making it clear?
Mhm.
And so then agents know that that's okay.
I'm just thinking of a seller's agent that gets this at 5 o'clock on a Friday and doesn't communicate it to the seller until the next week. it's still been delivered, so I understand, but is that an issue? Then the seller is gonna say,
I think
well, I
that's
didn't.
when it comes back to the
Yeah,
fiduciary, what he's
all
You
right.
had to do it
Right.
anyways.
I'm just
This is just
making
telling you,
sure we
reminding
didn't-
you,
yeah,
you really
we
have to
didn't put
do
an
it.
additional
Yeah.
layer
I think
on
it
that.
increases someone's understanding that that is their fiduciary. If you have a listing or you have a buyer, you have fiduciary to get information. I also think that while in practice, a smaller group of agents and brokers may actually provide notice according to how it's supposed to be, it's still a problem because then those other agents who don't say, why are you? And we don't have anything that we can readily and easily find with Trek's name on it on the interpretation of why we're doing that. And then once again, it's a battle of, no, this is how it's supposed to be done. No, you're talking to my client. And so this really does, we have liability anyway. And while I don't necessarily always want my agent to not take care of stuff, at that point in time, I don't want the agent who's not taking care of fiduciary. And that's my responsibility as a broker to terminate their sponsorship if they're not taking care of that and taking care of our client. So I think this makes it super clear. And I like this version of it.
I like it too.
The thing that, to me, this language right here seems, can cause some confusion about what it means.
I think delivery is.
So I think if we say all notices from one part or the other must be in writing, and using the current language, something like, and are effective when delivered to the party or their agent at the following.
I like that.
Location.
Simplifies it and
Yeah.
less words.
Because then it's an or, and that's all you have to add and not get into.
I really liked how he did this, where that first sentence is specific to the requirement that they be in writing. Because I've always looked at this notice paragraph as being two separate concepts. One, it has to be in writing. And then second, okay, what is the safe harbor for delivery of the notice? If I comply with this paragraph, I know I've given effective notice. All right, so the way it is written in the current contract, in my opinion, confuses that.
I don't like the current layout either.
I really would like it to be in.
Sorry.
You don't like what?
The current contract, he's talking about, it's a little bit vague still, even though we put that with copy, it's still, it could.
And so I'd say let's keep it in writing, period.
He didn't like your and/or effective, Ron.
Okay.
Well, we can look at the multiple versions.
We're just cutting out a lot of words.
From my standpoint, when I was in private practice drafting contracts, I would look at the notice paragraph as being a safe harbor. I know if I comply with this paragraph, I have given notice. That's not the only way that you can get notice. If it's actual notice, then that's notice. But put and that's why the existing contract is not clear at all, because it says it's effective when delivered as follows. Well, it doesn't say only, effective only if you give it in that way.
And that fits in with the 2000.
That's consistent with the
Supreme Court
case.
case.
Yeah.
And Diane, I know you had a comment too.
Well, I was just going to say, being on that subcommittee, I wanted to thank, and I think I can speak for the brokers. We were all brokers, spearhead by our co-chair, who is an attorney, and John just stepped up and helped us address in the subcommittee with his leadership of a problem that's been out there for decades. And then it came to the forefront in 2020 when the practice was told to be changed. And now I think with the true broker-lawyer committee working together, we're going to change something that so badly needs to be changed for the boots in the ground, as you were saying, but with the legalese that we need from our attorneys. So I'm so glad that everybody is working in concert, because those listening and those practicing are going to be so much happier. And I was the member who, our brokerage experience to following the contract to the letter of the law. We really didn't like it as a committee a couple of years back when this got changed, and now we're fixing it. So thank you all.
So
Thank you.
I moved it to the last there. So it's just the 2 sentences now.
Notice of effect when mailed to the why don't you get rid of by fax?
I would agree with that.
A fax is an electronic transmission.
Okay.
John, not to take us on a too far a rabbit trail, but it's on notices. You went through and you did a kind of an overhaul of the contracts, identifying all the notices or implied notices, which I'd love to see that because I'm always.
You can scroll up in the.
You don't have to now, just at some point. I wonder if almost like we have an amendment that says, we're amending paragraph 4, 6, 8, or 12. If we made a whole notice sheet and it identified all the notice, and it's entitled some kind of notice pursuant to the 1 to 4 family residential, and then go check box all the things you've listed, we can build into an agreement, and that's the notice. And in that notice, you can say it's going to whomever and have them sign it.
The only concern that comes to mind is those that aren't specifically notices, let's say title objections. Does title objections, do they have to be sent under the the notice provision? And I believe they do, but then, so it would take a little more of an analysis to make sure we would cover everything. But the concept of having a document out there, at least consider these.
Right. But maybe later, but this looks good.
The other thing we did at the bottom, don't worry about the lines.
I took out the word copy too here. So here I deleted copy too.
Perfect. And then we added the word address. Diane brought up the point of, it's just blanks under there. I believe Diana, it's a working group. So let's just say address instead of having them fill in something else. And then under buyers with copy to, we just had a blank. And so since we're actually having notice being provided of needing to have some direction there as well, whether it's the address or email, we take out fax. Or I guess we had to leave in fax there, don't we?
Brokers, do y'all ever put the people's address in there? Like, do they? I mean,
yeah.
Or would you want to put electronic
transmission?
transmission?
Like, I don't want them. They don't need to know my address in San Antonio. They don't need to know my home.
You must have a phone number and email for us. Most of the time, we don't have a physical address, mailing address.
If something is going to be sent certified mail and there's a reason why, address comes in handy. In practice, these boxes have historically been left blank for the fear of one agent stealing from the other. And if they're honest, they're going to say that. And we've tried to get it to be filled in to help the title company and all parties involved.
So this is a good time to introduce a concept as well.
I'm sorry, are we leaving fax or are we?
Finish fax. I think
there are people.
I mean, you're going to fax, you're probably going to get it on your phone more than likely these days, but.
You can have a fax.
I think it's fine on the bottom. I like that we took it off in the paragraph, but I feel like to fill in the blank.
All right.
As Brian's
almost there. We're almost there.
As Brian's name tag indicates, some people are still using fax.
I don't want to jump ahead if you're already playing on this, but given Brian's notice about the email change in rule.
Oh, that's it. That's what I was diving into.
Okay.
Yep.
You go.
So in between meetings, members like to geek out, and we always stay on top of these things. And Brian was on top of a change, not so much a change in the actual rule, but clarification of the process that the USPS, United States Postal Service, came out with a clarification about postmarks. There's this concept in the law of what is this mailbox notice? When is a notice effective when given by mail? And from a legal perspective, when it's deposited in the mail, that postmark date is kind of what we've always looked to. But USPS has changed how their practice over the years to now being processing mail at regional facilities more than at the individual offices. And that postmark date isn't necessarily the date you're depositing it in the mail anymore. It's the date that it's being processed at the regional facility. And so they came out with the clarification of that Brian pointed out of, we can't rely on that from a legal perspective anymore, right? Best practice, go take it somewhere and make sure it gets stamped and, deposited by delivery in hand. But from the legal side, that's not an absolute. And so that is an interesting plan if you wanted to expand on that.
The way the the Postal Service has characterized it. They say, well, this really is no different than what the rule has always been. But because of their change in practices on how they postmark, it is having a practical effect on what you see, and you assume that that's the day. Old days, I mailed my tax return, and I made sure I put it in on April 15th, knowing that there's going to be some person there stamping the receipt that night for me, and that's the way things always were. But that's not the way it is anymore. The Postal Service does say that there are other alternatives that you can have. If you need to be able to prove that you mailed it on a particular day, you can go inside and they will give you, for a fee, a certificate of mailing. Or you can get the person there at the desk to stamp your letter in front of you, and that works as well.
I'll follow you. So what do you, so
I don't
everything
know
makes
that
sense.
in
So what do you
this
want to put down
contract-
there? A little parentheses. If you mail it, better get proof.
No, I don't think we change anything personally.
Because you're right.
I do
Home
want to
doesn't
say
get
that.
stamped till 48 hours later in Houston, a distribution center.
Right.
And sometimes I have had the need to go down to Beaumont and go to the office, like, I need you to sign something that this thing went out today.
Well, I think the bigger question is that's coming to the light is, do we eliminate the mail as a place of delivery of notices altogether? I see somebody over here.
That crossed my mind. I didn't want to raise it yet.
We're keeping facts and we're getting rid of mail.
Just one step at a time. One step at a time, Tony. One step at a time. But no, I think that's the bigger question, because
Maybe just get rid of, or maybe you don't get rid of mail. Maybe you make it certified mail.
Yeah, that's what we do.
Aren't these choices? And if we take one away, is that our place?
Well, I'm not taking it away. I'm adding, instead of effective when certified mail.
If you put certified, it is stamped that day.
Okay.
That's not a bad
That's what he's
idea.
saying. How do you get the
Do we
stamp that
want to look
day?
at doing that now?
so if you put certified, no one's going to use it. So it's all going to go
Yeah, it's all
electronic
gonna
at
go
that point. Yeah.
But it's electronic right now as a practice anyways, right?
Correct.
Has any brokers, have you
Yeah.
mailed any notices?
No.
The only thing I do is.
No.
No.
You never know if the
What is that?
Yeah,
you
we
never
may
know
not
if the
get
postal service
there.
is gonna get there.
May not arrive. Well,
Oh, you already
and
sent
we
it
don't
to-
fax either.
I send certified.
No.
Did we take it out?
No one
Because
even,
it
no one
charges
relies on the
certified.
postal service for anything,
Yeah.
except TikTok shop.
So what if we make it clear on that? Send by certified mail, because it sounds like Mary's sending it
Judges
certified.
make you do certified mail. If you go in front of a court, and this is property management, but if I go in front of the court, the first thing they're gonna say is, where's your certified check?
Yep.
Yeah, did you send it out?
May I just step back one bit here? I like the way this is going, but it doesn't, I again look at this as being a safe harbor. It doesn't address the fact that if there's a written notice that has been received some other way, that, you emailed it. I gave you two different or I gave you one email address, but I have a different email address, and you send an email to me at my other address, and I actually received it. Have I received notice? Heck, yes, I got it.
You've received notice if you got two texts.
Yeah, I think.
Yeah, and so really, I think I like this as being a safe harbor. If you follow this rule, that constitutes notice, but it's not the only way. And I'd like somehow to put in there that notices are effective when mailed to, hand delivered at, transmitted by electronic transmittance, or actually received.
So I like where Brian's going with this, because if one person chooses to interpret it as notices are effective when mailed to, hand delivered, or transmitted by electronic transmission to the other party or their agent as follows, if they strictly say, well, you did send it to, because I have 3 email addresses, you sent it to ctatumjansen@gmail and not Chris Tatum that's right here, that does not fit. Is someone going to argue that? So do we leave
Yeah.
it received?
What they've done is they've implied the word only in there. It
With
doesn't
the
say
as
that.
follows.
So somebody, they're saying notices are effective only when, well, that's not the case, and it never has been.
I think we should say, or when delivered by the title company.
There's a
Let's think about that.
The title companies will do that. You call them up, this deal's done. They immediately kick out an email, deal's over. I just did that one in South Texas. I'm like, hey, I'm not sure this is gonna work. And deal's over. I'm like, everybody sign release earnest. I'm like, whoa.
I'm okay with leaving mailed. I think that's going to be the ultimate question for us, whether or not we'll leave it, we'll take it out altogether. I don't have.
Mailed or certified mailed?
I don't have a big preference. It's really for the brokers because no one's using it. So I just raised the question of why do we have it?
Does it matter if we change the as follows part or make it?
I mean, we still have hand delivery. So if you want to send to FedEx or whatever, you can still do that.
Well, or if you're worried about the mail getting there and you want to have proof, you can
No.
always still send it certified mail. It doesn't say you can't.
Yeah, I mean, I think that the word certified is just, if someone says it wasn't there on time, you have something to prove that it
Why
was
is
stamped.
why is FedEx not a hand delivery?
Yeah, I haven't thought about that, but I think somebody's handing it, so.
Yeah, we're not saying received by. We're just saying
It's not the normal practice, you know, as we look at the.
Should that be a list of, to keep it open, a list of ways such as to be delivered so we don't lock ourselves in?
Instead of as
'Cause
follows.
I'm hearing you all saying yes, as follows, because you're saying, well, it should be done this way, or that way. And what if it's not? It's another way, but it was still delivered. Have we locked ourselves in? And should it just be notices effectively, however you attorneys want to write it, but leave it open?
I'd like kind of the approach that Brian suggested
Right.
takes care of that because it's the actual receipt. I would be fearful of having as such as type language because then you can come up with a lot of different creative ways and arguments as opposed to here are the ways or if you actually get it.
Yeah.
And if you actually get it language kind of leaves open the other ways. the person
Received
can
by will
issue.
cover
And-
FedEx,
Here's
UPS.
the way
all
that I have seen
Yeah.
people draft it. You just go to the end of paragraph 1, after all the addresses. And you would just say, notices given in any other manner are effective when actually received.
What if you did
What if
this?
someone says they didn't receive it because it went to their spam and claim they didn't receive it? Is that a legal issue?
Yes, that is
Because it's
a legal
delivered.
issue
It
and
could
that's
be
not
mail, it could
normally
be pigeon, it
defense.
could be whatever, it's delivered.
But if you say you have to send it this way and one of its email would be fine, then you're okay because you sent it to the right email. Then if we had the receipt by and it went to your other email address, that will cover, oh, you actually got it.
Mhm.
And spam generally is not a defense to
Okay.
actual receipt.
What about that? If you just take, if we just be a little broader in terms of delivered to,
Oh.
I like that
looks
because
good.
mail is a
I
form of
like
delivery.
that.
Then the.
FedEx and everything else
Does
covered.
that eliminate the mailbox rule?
Do we even have to have as
It does.
follows?
It does eliminate the mailbox rule, yes.
Can we just put the colon after agent and take as follows completely off?
Well, no, it doesn't eliminate the mailbox rule. I'm sorry. Mailbox rule says when placed in the mail is delivered, right?
Yes.
Is the- yeah,
When you say when delivered to the following address,
Right.
then that negates the mailbox rule.
No, it doesn't.
Are you sure?
Well, if the, oh, I see what you're saying.
And go back, Brian's, I really like what Brian said about, or actually receipt, where we keep it the same and that clearly incorporates the mailbox rule. And then you have that safe harbor of, well, if they actually got it, it's still effective.
And you would do that at the end, after all the addresses. You just say, notices given in any other manner will be effective when actually received.
You mean at the bottom of this?
Yeah, at the bottom of, after you've done all the addresses.
Okay.
What's
So-
on-
So delete, remove
Take
all
that
those
left
changes that
out.
you made. Go
Okay.
back.
Well,
A statement of actually
I'm worried
receipt,
about-
is that then requiring proof of receipt?
No, it's the-
Absolutely, absolutely.
Well,
But
Whoa.
you know what? That's
There's a
pretty,
big difference there.
but that's why this is good. This gives you the safe harbor. I comply with this paragraph. I know I've given notice. If I want to give notice in any other manner, hey, that's on me.
yeah, but why
So
put that
you're
in
saying
the
that the received is a disjunctive. It's not a also you have to do it, the approved receipt. It's just a, or if you do it differently, you gotta show
Yeah,
receipt.
exactly. And then it's an evidentiary issue, but it's a.
Yeah, because already you got so many people say, oh, I didn't get the email. Oh, it just dropped
Yeah,
off. the
but I don't
mailbox
think we
office
should
like
put that
that.
in.
Contractual.
Yeah.
I don't think that we should put that in contractually. That's essentially the law anyway. You're gonna show actual receipt, then prove it up. But I don't think we
But
should.
We had an example where the lawyer said, you didn't follow the
That
contract.
gets that practical.
But that
You're not
might,
gonna find
I
it
think
out all the way.
that might not be the regular situation, and then it had to deal with a lawyer. We all know how that
I mean,
works.
I withdraw it.
I said it, I said it.
I see it a lot though, not having gone to fee, but when running the title company. It would always come in, well, has it terminated or not? Right? We're in the middle, we can't advise, but seeing this experience with actual damages to the parties in terms of having to pay attorneys. But all the ones that don't pay attorneys, they're still calling the title company and asking, or they're still trying to get advice. So it's that controversy that's out there. Doesn't necessarily have to be damages, even the controversy. So we can eliminate that by saying you actually received.
Well, let's see how we write it, because I just don't want people to read the first two sentences and go, understood. And then the next sentence and go, well, wait a minute here. I got to make sure they received it. Like, how do I make this guy show up and the seller acknowledge they got it? I can't get this agent on the phone to acknowledge she received it.
Let's give Brian the first shot at this. Brian's like, yeah, where are we saying?
Go to the end, to buyer's agent. And then just add a sentence that says, notices given in any other manner will be deemed delivered only when actually received.
I think that's sounding like it needs to have proof.
It does.
And then it would go back to that, what if you didn't send it to that email and you sent it to a
Or
different
they-
email? Or what if you-
So Brian's point there is that that's still the law anyways. And so this is just stating it. in
So what is the
contract.
agent gonna have to get as proof?
If they do it the first way, it's just, they're sending it just fine. If they do it any other way, they're
Okay.
going to have, depending on the million different ways you can provide notice, have to, whatever that method is.
If y'all use your normal text, you're gonna need them to screenshot a copy of the text back and send it back to you to prove it that
Well-
they actually got it.
But I have a question.
Please confirm
Electronic
receipt.
transmission with the phone number on there is done, correct me if I'm wrong, but I'm talking from someone who would interpret it this way as a regular person. Scroll back up a little bit, Ron. So we can transmit by electronic transmission. Is that not including text? So if we send that text to their phone number, I'm good. I don't need.
Electronic transmission would be text.
Okay, I'm just making sure how I understand, because we don't always want to have to get attorneys' opinions on everything. That gets very costly. And while I can understand y'all explaining that last sentence to me here in the room, what are agents and brokers going to say when they see that out in the field?
That's a good point. Now we have two on that column. It causes more confusion than it's helpful.
Yeah.
I don't know.
Can we just not take off as follows and just put the colon after agent and take off that bottom line, or am I being too simplistic in that?
I see what you're saying.
Put the colon after agent,
And just put a period
To
there.
Yeah.
buyer at, to seller at.
colon, and then we take off that
Or not
bottom
even-
sentence.
Yeah, just a period. And here's
Yeah,
where
check
they
this
go,
out.
yeah.
What are the legal ramifications with that?
Nothing. It's more of a practical, do they know?
Is it
To
though,
fill in.
really? Because we're not saying that you have to send it to because we have two buyer, sorry. Okay, so because we say to buyer at and have the two buyer's agent.
To the other party or their
We
agent.
need added two seller's agent.
Then why do we have 2 emails / faxes and only 1 phone number?
Husband and wife.
Husband.
I think that's because of husband and wife, if there's two.
Well,
Because
there's
two
2 phone
partners.
numbers that you need to text?
Yeah.
Sure.
I'm just asking why would I only have 1 phone number for my household? I don't have a landline.
No, you make a
Everybody's
good
got their
point.
own phone number and their own email address. Should there be
That's
2
right,
phones
right.
and 2
It should
emails?
be
Do we need to
Co-owners.
add phone on the buyer's agent and the seller's agent? Because that's where the text is going to occur.
That is where the texts go. They don't go to my address.
Yeah,
That's true.
I don't even think they know that office addresses anymore.
well, and some places don't have an office.
That's true.
Do we need to say phone twice or we just have 2 blanks for it to allow for the room?
Well,
for
and
less
then
noise?
if you do have phone twice,
And you're supposed to send it to notice, you're gonna have to send it to both phone numbers, both emails.
So just maybe one is better for either side.
So when you
Pick
have,
one, it doesn't matter which one
so
you
as far as the
want.
brokers, when you have spouses,
Or whatever.
are you sending them to both spouses usually as brokers?
No,
What's going on?
typically we ask the client what their preference is and document that.
Then I would just say use
Yeah,
one
well, it
email.
depends. Yeah. And if
Y'all are
if
just
it's
using one
you're
email?
copying
I think everybody.
Some of that also was used for title, because if they have to send to
I
both,
was wanting to
if
say.
they have to send to both spouses to sign something, some of the times they go to that. Otherwise, they send you that letter. Please fill this
Well,
out
and it
because
may
you haven't
be-
given us
it may
anything.
be an entity buying, and there are two people that both want that information, so. Could be
So
that-
it
that.
sounds like it's better to give 2 phone numbers, 2 emails.
And maybe
So
we do
that-
get rid of fax. I mean, nobody's gonna, you've put electronic transmission, and I guess if they wanna fax it, they're gonna,
They'll specify.
It could be the
they'll
phone number.
specify what fax number.
Mhm.
I mean, fax is a phone number.
So you want 2
Two phone
Phones.
lines
and 2 email lines.
and 2 email lines with no fax.
Okay.
Not to take it even too much further, but so that
Go
we
3.
don't look to our agents and the consumers like we had typos. Should we put co-owner phone, or co-party? So that they're not like, why do these people put 2
Well, they
phones,
don't
2
have-
emails, 2
They
everything?
don't have to send it to the party, right? So it could be their attorney, it could be.
No, I know. I can just be sitting with one of my co-worker brokers at breakfast on Friday. He's like, why'd you put phone in there? Did you mistype this
Yeah, why
thing?
is that a
Why'd you do that
duplication?
multiple
Yeah.
times?
What if we took out the actual word phone but left the blank on the second line?
No, I mean, phone, email. Should we put co-party?
No,
Or you
then
could-
somebody's got to be named co-party, and if it's a spousal situation, you're
You're
gonna have
right.
a problem.
You're right.
How about if we say
Or what if
text,
they're-
text? Well, because why are you saying you can call somebody? Notices have to be in writing.
Well, should that be phone/text?
Or text/fax?
Yeah,
Ah,
yeah,
Or
I think it
text.
does.
Or just the word
Or
text
maybe it's
because it
just
has
the
to
word
be in writing.
text and
I
not
think it's
just
just the
phone.
word
So that makes
some text in the contract.
So do we want to even encourage text by putting text in there? We don't want to,
Seen that.
we know it happens, we just don't want to encourage it.
Well, let's see, are we on the leading edge of changing it up to get the modern world?
Then we need to take
The
fax out.
modern-
We're on the
modern-
leading edge.
modern- I can't talk today. World is a lot, text is.
It is text.
people are sending documents through text. Everything is going.
Our attorney says,
all
do
kinds
I
of
hate
not
stuff.
do it when he teaches our agents. Do not put it in text. It is too hard to keep a copy. If you've got an
It
app for
is.
your text, it is not the best protection
That's
for
true.
you. I don't have to take it to court.
And does Instagram message count?
Annette dishes
Snap
words.
counts.
Yeah.
What was
Text is the bane
the,
of
Ron,
existence.
what was the thought when y'all added 2 emails? What was the thought for, why did we add the second email?
It was
Spouses.
husband and wife and stuff.
Partners.
Partners.
I think it first started
Business
as one
partner.
was an agent, one was a seller or buyer, and then we moved
But if it's
the
delivered
agent
to
down
one
below.
of them, it's
If
deemed
they're not
it's deemed
divorced,
effective. So maybe we just do
Yeah,
one
if they're
phone
not
and one
divorced,
email.
delivery to one is good.
I think in principles, we're assuming that there could be more than one, just as a courtesy. And agents, we know there's only going to be one.
And-
Well, it doesn't hurt to add more.
Right,
I guess you could
right.
fix it with buyer parentheses S, close parentheses, buyers, sellers, to kind of give them the, no,
Oh, I
that's
see what
why,
you're saying.
that's why
Oh,
there's
that's a
more
good
than one.
idea.
Then they would understand why we have.
Yes.
And it will be an interesting thing to watch and practice.
See
If
what
we
they're
do
telling you.
add that line about transmission to the other party or their agent, if we end up seeing less and less buyer and seller information in there at all and just agents, it'll be an interesting thing to see where that goes.
That's what you want?
I like that.
The
Yes.
majority of us that I saw come across my desk in certain markets were already that way.
Yeah.
So,
Mhm.
Going back to
Yeah.
phone, are you putting text in there or not?
No.
I don't think so.
Okay,
Do you want
So-
to take out fax?
Yes.
yes.
Take out fax.
The other thing is, I think
You
the,
need more room to write the long
the
email.
question about the FedEx and the overnight mail issues. So I think you can say overnight mail with mailed, but I don't know
You could say, I looked it up with their, I mean, you just simply call them courier,
courier.
FedEx and UPS,
So you want to say
global. identified
sent
as courier.
by courier? Is it? I've usually I see in other deals is overnight courier. is
That's
what
what I see too. I didn't know if we wanted to put overnight. What if someone said 2 day?
Well, actually, courier is a good
Well,
general use.
The problem that you don't want to do is a courier takes you 4 days to get there.
Then we're not locking ourselves in if it
So
takes one
what you're
day,
trying to
overnight,
do,
or 4
well,
days.
it's when sent by overnight courier, then it's effective the day you send it, not the day they get it.
I'm okay with overnight courier. That's what I use
Yeah,
in legal.
yeah.
We need to add it to at the end.
And time is of the essence. But we're getting so 2026.
So do we want to have an address for the agents, or do we just want to have a phone and an email?
We added
We
that.
need your home.
I need to put
Come over for
put all
dinner
this in there.
anytime.
We had a brief discussion, I believe, and thought about, we already have agent information on, at the end of the contract, but we wanted it to be separate for the notice, right? We looked
Yeah.
at maybe tying it to the end, but thought it's best to put it up there.
I like these changes.
While we're talking about this, the buyer on a contract is Brian and Linda Watts. And you put both of our phone numbers and both of our email addresses in, but you send notice of termination only to me.
Shouldn't it go to both parties, though?
You have to.
Should be
that-
addressed to
that-
both parties.
It's received.
Is that effective if they only send the notice to me
Yeah,
and not to my wife?
legally, yeah. I've had that one, by the way. Had a client wanting to get out and he was trying to use the angle. I immediately honestly didn't like the client because I didn't like his style. So my wife didn't get it. My wife didn't get it. And we explored that. I'm like, no, buddy, all the trial court cases say you got it. Now, if you were getting divorced, you might have an argument if you've already filed for divorce.
I would hope the title company would address both parties, buyer and seller side, and not pick and choose, just for all those relationship issues that could come up that shouldn't become part of the transaction. Fully disclose everything.
Is it gonna create more of a problem for y'all as brokers, to have to send 2 notices though? Because the way we have it, maybe y'all are already doing it, but the way we have it now, it's almost like you're gonna have the wife mad at you if only the husband got it.
We wouldn't, because we have it can go to the agent now in here.
Yeah.
It's gonna go to the agent, which is what they're doing now anyway.
And the agent should have they're already having correspondence with their
They should
consumer.
know
They've been
who they're
having
sending it to.
correspondence for weeks or months at this point. They're gonna be aware, like, I need to make sure this goes to one spouse or the other, or both, or copy, whoever else, business partner, that kind of thing.
But that was a good point.
I do kind of like the idea of taking the agent's address out though.
Well,
I really do.
what's
There's a
wrong with,
lot of people that are at virtual agents, virtual offices. They don't come in.
Well, shouldn't it go to their
Well, it
office
could be
then?
blank.
Sure, but if it's going to a PO box.
well, if they don't,
They had, a
if
lot
they
of
don't put
people's
it-
physical address is a
They
PO
don't put it.
box mailing address, not a physical address like we have.
So what do you
No,
think
but
is
say
more
that you're a listing
practical?
agent and you get an offer and the other agent has proactively filled in some random
The-
PO box somewhere.
The
You're
only-
like, I gotta strike that. It's
Look,
just-
if they put the PO box in there, then
Yeah.
they don't regularly check it, that's.
But if
Yeah, you wanna
someone's-
take that out, or what, you know what I'm saying?
Someone's sending some type of certified mail though, and that's how they want to send it. An agent should have something to send it
Okay.
to, or send something for an attorney to send something to if it.
Yeah, I guess that makes
Where are they
sense.
getting their
Okay,
check notices?
yeah,
Like, they gotta have
Yeah.
something.
Email?
Mhm.
email.
True.
Trek doesn't mail anything anymore.
Well, and now Trek will be collecting business addresses.
Yeah, we will
So
have
that will be
business.
part of the, when you go on Trek's website,
That's true.
you'll have at least an address you're required to have.
Your broker's business address, which is also virtual.
Mm-hmm. Yeah, that's what I'm saying.
So do we
The
need to
broker that has
clarify that
9,000
on
agents under them. they
business
pay
address on
$50
the buyer's agent side?
transaction.
No, I think
Probably
that's where they
talk
want their C notice, doesn't have to be there.
You can never get a hold of the broker on the phone when something is an issue. I'm sorry, digressing.
Oh, so, okay, so let's.
So a formatting question for you. You know how we have the, over here. oh,
So the
wrong.
keeping address in?
Mhm.
So we have we don't currently have the address here listed. We just say buyers at, and then the address goes
It's
2
confusing.
lines. Do you like the address like this, or do you want like the current form, the way it works?
No, we wanted to
Okay.
add the word address
Okay.
because there's just these random blanks and people
Okay.
are like, what goes in there? I'll just throw an email in there. They can write whatever they want.
Okay,
So it's a little more specific.
all right.
Not to be that guy, but if there's more than one buyer, it's like me and John are buying something. Do we need to put 2 address lines?
And at some point,
Where do we
that's the thing
stop?
About that, stop. And then you can use special provisions to complete a blanket
Wherever that is.
contract.
You're being that guy, Tony.
No, no, I'm not. I'm not.
That's the 5%.
No, personally, I don't like phone, email. That's what I don't like. I really don't want to add another address line. I don't like phone, email.
And that's where I was like, having 2
Just
blanks, but
one.
just one phone, right? And
One
two
phone,
blanks for
2
one email.
lines?
Yeah, exactly.
Or you could even do phone, like we did the buyers,
Slash.
parentheses, S, close parentheses, if there's more than one phone number. I just don't like all that extra.
Okay.
We can squeeze in 2
Let me
phone
squeeze it
numbers
in.
if we have.
Yeah, so what I'm going to do here,
I mean,
because I'm
You can
I'm gonna
text in
stop
2
sharing and
phone
I'm going to
numbers
share
right next to
on
each
the
other.
minutes because I was moving this over to the minutes and
I think by not
Now I'm doing it
putting
2
2
different
phone numbers
places.
and email addresses, we're encouraging sending it to just one of the parties on the buyer's and the seller's side. I don't know if that's good or bad.
okay, so I'm just
What
putting
if I
the
have 3
list
buyers?
and then letting the,
Then you put 2 on each line.
I'm just,
Be creative.
No, did you
3
see-
buyers
did you
would
see
be
how I have buyers,
5%
or
rule.
how Ron put buyers with the
I don't
parentheses
know.
S,
I have a lot of
if it's
couples
singular or plural?
that are buying together.
You could do that on phone, you could do that on email.
oh, I say you do it like this and just do one line.
Yeah, just show me an example, please. Yeah, just like that. And then just do one line. You could cut some lines out.
Yeah,
I
definitely.
think that's the way to do it,
Long
because
enough.
like
Yeah.
down here, for people of 40, I have couples buying houses
Phone
together.
is fine, email probably
So
is
I've got
gonna
4
take up
buyers.
more, but the phone.
Well, you could do this.
Yeah, you can't fix people's.
You can
Yeah.
format it this way.
Yeah.
That's email, so not gonna.
I don't know that we're gonna be able to get 2 on one
Right,
line.
but you can do this.
What's
There you
what's the purpose? Saving space or being?
No, I'm not trying to save space. I'm just saying,
A little less
Yeah,
confusing.
that way if you need.
There, you have 2
But
lines.
if the line's not long enough to be able to write or type in what uses it.
You have 2 lines.
you have 2 lines now.
He just took out the email on the second
Tab
one.
over though.
With 2 line for each.
On the phone, so.
second
You actually get a longer line for the longer email. So that guy with the short one goes on the top and the one with the longer one goes on the
So
bottom.
we're having 1 line for phones.
So we
or
were not
2
putting
lines?
address under buyer and seller's agent?
Oh, yeah, we need that.
You're just gonna take that up with zip form. Make sure
They're
that
gonna
goes.
retype it.
I was trying to bring it over to the
Does anybody have
minutes.
zip form now to see if it can fit 2 in the blank? And it was one of the lines.
They should be told they can't do that.
What do you want me to look up?
Those forms
On zip
are
form, see
proprietary.
how much you can get on one line in the current
Get this up so I'm on together.
notice provision. See if we can get 2 phone numbers in there.
Well, isn't Zip Form's getting some big new fancy schmancy update?
I hate this new zip forms. If you really want to let me know.
Oh, I don't have them. Yes.
So,
Huh?
Is the new one already launched?
Well, I just don't like
Did we
the
add
new
fast
format,
forward?
how you have to add a form. When I
Oh,
just
yeah,
want to
took
look up
that
a
out.
form, it's just annoying.
thank you. I was bringing it over to the
In
minutes.
the contract, right?
In the contract, right? 20, paragraph 21.
Someone wants to.
In
someone
Zip
needs to
Forms
speak.
under
Is
phone,
that
when
what
you go
that's
to type it
blinking?
in, it puts the parentheses in the dash.
So it won't let you put.
Welcome, Tracy. Glad you could join us.
So,
You can always, you'd have to do that and you'd have to do that like in dot loop. I can't do it.
I just.
Some of the
I get
times you'd have to add a
confused.
text.
If
Let
we
me
have
just put it that way.
email lines, why are we not having
There's
2
not
phone
enough
lines?
room.
I mean, if
Because
I
they
put it
can
here,
only
You have-
you have one.
you can get it on the same line.
What
You
is the
can
one
put
with
it
the
on
first
there.
person's name? This is
What about the
Diane's phone number, this is Les's phone number. You've
This is-
only got one
this is
line to
one
do
line.
it.
There's no
Yeah, there's no
room.
room, so they need.
Nope.
Instead of.
There's space there with how that came out though. So we
Yeah.
have zip forms up now. There's space if they put a second blank in to fit 2 phone numbers on one line.
Right.
But
They
try,
need to-
but
they
start
need to
typing
form-
one in.
They
Watch
need
what
to
happens.
format. It's a zip form formatting thing.
Start typing one in.
Oh, I know. You'd have to,
It puts the parentheses in the dash already,
Right.
and then you can't keep going, because I added or, and it'll let me do another area code, but then
But I think we can get with zip forms.
And
maybe
tell
to
them,
get
oh, yeah,
on
yeah,
the
there's
table.
enough
Input too.
room.
Well, you've got
They'll fix the
DocuSign
format.
rooms, that's a totally different entity, and more people are using DocuSign rooms, so we.
Well, that's what they'd either have to do, it, put a text box into DocuSign or into,
Okay, and how about
that's
the
an agent
consumer who's
just
not
doing their
using
job.
either and is just getting it off of the Trek
There's
website?
enough room for them to handwrite it.
Handwrite, it's easy.
Yeah, I'm filling it in
I
on
just
the,
don't
And I just-
understand why one line.
I think that we're just gonna see that get more and more blank and not.
you can get two
even
line,
then.
two phone numbers on the form filling on the Trek forms that are up there.
I think, yeah. Zip forms can make that fixed. That's not a hard fix, an extra tab.
Again, we've got the consumer who uses neither, and you have DocuSign rooms, and you have other entities that provide the
Docker, yeah.
contracts. So we can't speak generally to how it's gonna be formatted by those private entities.
And during DocuSign or dot loop, you do text and the agent
Well,
just
you
puts
say
the
with,
text in.
Yeah, so but
Just add a text box.
I do have one other notice issue that's related, but past the language to put on the table.
So if you do this, like, that's what I'm talking about here, you can get two of those numbers in there easy enough. So. Then there's a lot more room there. So,
And we're removing the parentheses.
yeah, we're removing the parentheses, plus you have this line here, all those kinds of
I
things.
just think it's implied that only one phone number would go in there.
Well, you're gonna have phones
It has
there.
the plural S.
You'll have the plural S.
While you're in the contract, can you jump to paragraph 7? And raise the other, and the seller's disclosure notice, 7B. Since we were looking at notices, we actually have a defined term notice in the contract. And that's, I think, because for brevity's sake and how we discuss the seller's disclosure notice in that paragraph. And so if you look at 7B, at the end of the title 7B, we have our, how we define terms in capital N notice for the SDN, for the seller's disclosure notice. I'm not recommending a change. I just want to, as we're discussing this, to get the brain power to see if we do need to make a change. The only place we use this capital N notice, unless it's at the beginning of a sentence somewhere, is in 7B.
I'd recommend just putting seller's disclosure notice everywhere. Because I do think it avoids the issue. And it's only one paragraph. That'd be my recommendation.
Great.
I agree.
Remove the defined term and just put S.
Yeah. Let me put that in the minutes.
Well, they're there. Should we talk about the one that someone talked about 7D or bring that up later?
As is.
I think we bring that up later.
Yeah.
I think we finish the notice provisions. Yeah. Any other issues I'm leaving off that we brought up in our working group? On the notice issue in particular? Just want to make sure before we round out the discussion that we have everything else on the table.
With the backup contract, I mean,
He's got.
We said paragraph 22 next and then
Yeah.
back up.
yeah. But no, I think this paragraph we were good.
We'll take a look at the language from one last time we were on. Ready, then we'll move on to paragraph 22.
Yeah, so go ahead. Stop sharing here. Or do you want me to pull up the,
Our final language, let me just make sure we're.
oh, okay, let me go back to, where am I? Here I am. Okay. Let me go back to the minutes because I think that's where we had. So obviously I'm leaving formatting to to
Yeah.
the preference of staff and others, so.
So the blank will come out after at, correct?
Right. Oh, that's right. I'm sorry, down here where,
To buyer at.
To buyer at, and it will just
Yeah.
have the address underneath, not a blank.
Oh, but watch out for that. It's going to delete the other side.
sure is, yeah. So we're taking the word at to buyer agent here and just put it like this, is what you're
I think we
recommending?
need at still.
Yeah, you
just
can
without
leave the word at, just get rid of the blank.
Okay,
and the blank underneath that as well. We can,
yeah.
Is that first
Sorry, I didn't mean to
paragraph
call
need to
them.
say
No.
to the other party
I did this in the
or
minutes.
to their agent?
Yes, that's the last wording. And the same thing
So
under
the
at the
same thing
top,
under
to the
the
buyer at,
seller.
that, yeah.
Yeah, you're right. Okay.
You can unplug me for a minute if you need.
I'm okay right now.
I
I'll
think this
tell
is
you
a
when I
good
start.
change
I
that
like it.
solves an issue. You get with the reality of the practice. This is something that
I'm okay right now.
So is this too many twos by electronic transmission to the other party or to their agent? Is it needing a two? It's the third line in the notices.
Well, they're all like mailed to and delivered.
She's
at.
at,
No, it's the sentence.
she's asking, do we need to put a to between or and there at the last three words of
Or
the
to
sentence,
their
or to their agent, or is or their agent sufficient?
I think it's okay the
I
way
think
it
it's
is.
okay,
To the other party or their agent.
yeah.
Would you say it that way? To the other party or to their agent?
Mhm.
Whatever.
I think it's
Or to
Majority
agent.
rules.
Well, you could put a two in there. I don't think it hurt.
Grammatically, if we're going by English rules, you would not.
Because that to goes back to mailed to, hand delivered at, courier to, or transmitted to, and then the other party or their agent.
Right, if we're gonna use
Yeah,
The two is going with, yeah, the
preposition
two is going with
diagramming,
the
then you would
transmitted.
just not.
Yes.
yeah.
You would only have one.
And I still want the 2 lines for the phones, but.
This is gonna be a longer line, so just,
We'll have enough room.
I want to be the one who has to listen to the agents.
Remember, remember, it's double tapped in.
you're on the
this screen.
formatting committee. You can make it as long as you want.
that's true.
I have a feeling that that's
You
not
got
going to
the
happen
trump
right away.
cards. You get to come in later.
You know why I volunteered then.
It might be an
And it's
Arial.
like-
Remember, that's a double
Instead of
tap.
Times New Roman, I mean, what do we even think?
Okay, so that's, I think we're ready to go to the next issue. Do we,
Okay. And you wanna
do you want
put,
to take a quick break?
Yes.
So let's take a, come back at 10:30.
Good idea.
Get started again at 10:32.
If you walk out the door, you can see it.
So our next thing, our next topic we'll tackle as part of our working group is paragraph 22.
Okay.
And in paragraph 22, we had looked at two different things. One is how complete, or paragraph 22 is where the addenda are listed. And how complete is it? How can we reorder it? And how can we look at the duplication of the language in paragraph 6E12 and at least 1 to 4, and it's a little different than some of the other contracts. So first, we what are the different ways it could be done? So we looked at alphabetical. Right? Alphabetical doesn't make sense with how we've named or titled the addenda.
Well, because they're all addendum.
Yeah, and some start with addendum 4, some say something else. It wouldn't make sense. So we also looked at how they appear in the contract, and that was even worse, right? That's just as scattered as it is now. We looked at, well, what about the most used, right? Putting the third-party financing or other things that, depending on what we think the most used are, and that we didn't think made much sense. So then we thought about categories. How can we maybe do it by category? And this is a little bit of a, guessing game because you can do so many different categories. So, but if we were to change it, we thought that probably made the most sense. to break it down by category. And from in there, because we started the naming convention, we'll put the most used on top. And as we go through these categories that we came up with, I highlighted a couple things. And the highlights are the ones that aren't in the paragraph 22 right now, or they're not in all the contracts. One that I thought was unique, like you see in this first one, is the addendum for release liability on assumed loan and or restoration seller's fee entitlement. That's in, I think, the condo contract, but not the 1 to 4. It didn't make any sense of why it would be in that one and not the other. So we've highlighted, I think there's 3 that are not currently in there right now. So the categories we have, or should make these drop down boxes, but we have financing slash payment, financing and payment terms, leases, and we can kind of go through the broad categories, come back to each one. Association and minerals. I don't really like that one in general, but it's like I was trying to fit the POA addendum and the mineral reservation addendum in one. And then property conditions, disclosures, and regulatory notices. And then 2 final ones beneath that, taxing districts and an other category. I also, for sake of our analysis today, put in all the ones that would not be included. Right, so all the ones we have out there that are not on that list. So I'm not sure the best way to display this, because I know it's hard not having it all on the screen. If we look at it starting from the beginning, or what, I guess the concept first. Regardless of the categories that we had, somebody have any alternative thoughts on doing it besides category and one of the other ways, like alphabetical or most used, that they would like to explore it all, or just jump right into the categories?
That's a lot.
You know, and there's also something to be said for don't change it.
And don't change it.
People are
absolutely
used
not.
to the way it's ordered right now, and if you change it, that discombobulates people.
And that absolutely is in.
Is there a benefit to change?
Might get them to read it.
Well,
Oh.
and we get comments on it quite often.
Yeah.
We do get a lot of comments throughout the time, you know, from the agents or the
Yeah.
public or whoever, saying, why are these in here like this? And why don't you have this form in there? And
And to be fair, it'll cause confusion for a very, very short period of time.
yeah,
And, you know, making a change.
Well, there could be say, don't put
What's
them
the
all,
advantage?
just put the blanks.
What's the advantage of?
Yeah,
putting
that's
a
another
category?
one that we thought was scary.
Yes.
About leaving off and not having that reminder.
just do it alphabetical. So that was the question.
No, I mean, I followed the logic, but is there a problem now that no one is checking the correct addendum boxes, but if we put a category, they'll go, oh, well, that category I do need to put a box? Is that a problem?
It's been raised several times in terms of how we have ordered it. The issue in terms of missing things is not having like the addendum, the PID notice, or not, sorry, the MUD notice isn't listed there. And then especially with the confusion between paragraph 6, E12 and paragraph 22, which is a separate recommendation we have at the bottom to add to 22. So I think at the very least, we need to look at adding the MUD notice in there.
So are you recommending putting MUD notices in 6 or in 22?
So let me jump to the second recommendation, is to remove 6E12
Okay.
and to combine that in with new language in paragraph 22.
Okay.
And that language, if you want to scroll down.
I'll have to stop sharing.
And I think
Didn't we just put in 6E?
We did, but we've had a lot of comments on that. That's
Well, people
one that
don't fill it out. People don't fill it out. They just go and check
And
22.
We did it to call it out because there are strong termination rights associated with not
Right.
providing the notices in 6E. And so we added in the contract before, if you don't provide these notices, here's an notice that you might have a termination right arise.
Right.
And the ability to list the notices that were already provided that weren't addendum. Right, so if you provide what we call the MUD notice or the special taxing district notice, or the PID notice, you would have a spot to list it. Because it doesn't necessarily have to be attached to the contract. It can be provided in advance and not even be an addenda to the contract itself. As we provided at those particular ones at or before the time the contract is executed. And so The current, I put both the current and the suggested revision here. So 6E12, we basically took that language and added it to what we would like to add to the bottom underneath addenda in 22. And it keeps everywhere where there's outside documents within the same provision, and we still get the same admonition of, hey, there's some potential rights, termination rights that might arise if you don't provide these other items. And we kept in and added one more to the list of examples of those notices.
Would that include like the notice about whether you're in an HOA or not?
So no, the notice of the HOA is actually built into paragraph 6.
Right.
And it's, so there's not a separate document to provide. And the POA addendum doesn't satisfy the.
Yeah, for the statutory, yeah. Okay.
So-
Again, I think this is a question of use, is where do you find, or I guess where do the brokers find that the parties are actually paying attention to it or not?
I would say we pay more attention to 22 than we would do 6E. I mean, I have a,
That was
all the other
strong
brokers
feeling
are going, uh-huh.
Yes.
The brokers in the working group was strongly that 22 would be the place that is,
Yeah.
they're already filling out, they're checking, they're not having to go in the middle of the contract and do another blank.
So you're recommending striking 6E12
Correct.
altogether?
Strike it altogether, or just have it be very short, saying notices that have been given
Are listed.
or attached are listed in paragraph 22, so seller's failure to give notices.
So we thought that it's best to strike it. So we have that language you just said where you're listing it itself. Because if you just had, here's a list, we're going to just gloss over 6. And they're going to just read 22 and not have this additional helpful language that hey, there's some big rights tied to these things. So keeping that together is where they're going to be filling it out and looking at it.
6E12, I'll tell you, most of people just pass that by.
I didn't know
I
there
hate
was
to say that.
6E12 till today.
You were here when we added it.
That's right.
I know, I'm kidding.
John, to Tony's question, and Melissa answered it, is that many agents, they see 22 as we just kept adding addenda randomly to 22. And I know in a meeting last year, members no longer here said that's something that should be on the list of things to look at, so that there's some kind of order. Not every agent only has the third-party financing addendum, and they may have a unique situation where they think, I think there's a form for that. And if we help them by seeing it categorized, it's because they, oh yeah, there it is. And they'll know in the future for a different situation that these are the categories for the forms. And I think we would be doing a tremendous service to the consumer and the license holder by grouping them together.
And if we're making a change, right, this is kind of that legacy, the burden of legacy and burden of having it one way. If we were designing it fresh today without an existing contract, what would we do? I think we would name them different one to be able to have it in a little more viable thing. I don't think that's appropriate for today, but at least with the providing some direction, some categories to help the understanding and to make sure it's complete.
Well, I noticed here, like you're talking about the seller's disclosure notice here, and that's one that does not have to be attached to the contract. But then these others do need to be attached to the contract.
They don't. Those are same,
It's
it
at or
operate the
before.
same way.
Well, no, I thought that there were some notices that said that either as an addendum to the contract or for.
Not the
So
PIN
all of the-
notice.
PID and MUD are.
I thought some of them were required to be addendums to the contract.
The ones that are in 6 have the language built in themselves where it's not a separate document. And if we look at what the addendums are, I believe in that blank, we're really dealing with the MUD notice and the PID notice. And now what we would add is the seller's disclosure notice to it. I'm not sure there's any other.
Well, there were,
notices that were in that.
we have the coastal area notice.
Oh, yes, okay,
We
sorry.
have the intercoastal canal notice. I have the what's the gas?
The reservation,
Well,
the reservation.
And that's why we have that in
No,
in
no.
addition to.
The per
Right.
pay.
Yeah, but I'm saying,
Oh.
I'm saying is the language here, all I'm saying in the language here is that you have has delivered or attached to
Right.
the following statutory notices.
So, and that's where that addition to, because you would have already checked it just above there. And so in addition to everything you checked up above, here are the things that aren't.
So my worry is that seller's disclosure is something that is sort of done outside of attaching it to the contract, whereas the others are always attached to the contract. So that's all I was really raising was, I'm thinking that just take this out, but that's.
But then the question is, if you go back to the seller's disclosure notice, it says you'll receive it in 2 days or within whatever, and there's a penalty. So should it be? If we make it attached, if we tell them to attach it, then we don't
It
have
says they've
that.
already received, there's also the option for already having received it though.
And I think historically, we've been trained as agents not to include the seller's disclosure notice.
Oh,
So it
granted.
doesn't warrant all the things in there. And so to Ron's point, maybe that being used as an example isn't a good example. And it should just go, for example, notices concerning utility, water, drainage, ones we know that there's a form for.
Which is our existing language that we have.
Yeah, so like the lead-based paint form, even though it does contain certifications and stuff, for the most part, it's just a disclosure form. So, but it's attached, it's part of the contract. And everyone breaks unless it's attached.
Has anyone ever given a lead-based paint form and actually said there was lead paint and didn't say unknown? Like, is that, it's like a form that everybody's like, oh, no, here.
Yeah. I actually
Okay, I'm
had,
fine with
I
taking
actually
it.
had an
So,
owner.
yeah,
get
that
a
was
lead-based
just a-
paint test like a month and a half ago.
We didn't have a
Just taking
big
that out.
discussion on that as well, Mike.
Okay, I'm just gonna strike. it.
Looking at all the notices that fell within this category of you could provide it in advance or with the contract.
If you know what hire certain contractors. If you don't know, you have to use the same appraisers. If you find out for sure you don't, you have to use it. You need to find out for sure you didn't.
So are there notices other than these type of utility things that need to be, that you're contemplating being placed in here besides,
Not that I'm aware of. The other ones are either built into 6 or.
so we want to put, is there taxing district notices? I don't think there are, right?
Well, taxing district would be the mud notice, right? Or the
Yeah, or the
pit
groundwater
notice.
conservation, which would fall under the water.
Your local drainage district notice.
It can be given at, with the
But
contract.
is it a part of the contract?
No, but that's why we have that separate, right? That's you can make it, we have one as an addendum right now and one that's not. We have the pit that's listed as an addenda, but the mud notice is not in the paragraph 22 as it exists. And that's one of the decisions today. To make it consistent, do we add the mud notice in or do we take the pit notice out? There's no reason one should be in 22 and one shouldn't be. And that removes the duplication from above, listing it and
The question should be, is it a part of the agreement between the seller and the buyer?
I think
Does
that,
it create contractual obligations in the addenda or the HUD notice, the mud notice?
Brian's raising a good point. I'm going to tee up at a little higher level to get down to where he's looking at. Addenda are meant to be part of the contract itself, right? And that's when a lot of agents list in other addenda things that are not addenda, things that should not be part of the contract. And, for example, the 2402, that's listed there a lot. It's not intended to be. That's a separate written agreement. And so Brian's raising, should we list as addenda these things that are not really part of the contract, are really notices that are given by the seller in most cases here. So that's a very fair point. Where then do we remove those from 22 and just have it listed as this was intended to give some evidence that you actually provided the notice is what was intended. And maybe we get more specific since we have a very small number of saying that instead of the, for example, and having a very broad statement that doesn't tie it into those two notices. That we say, for example, the mud notice and for example, the pit notice.
The PID's up there though, right? The PID's on 22.
And that's what Brian's comment raises. That's a good reason to take it out of 22. And then
I
have
think that's a
specific
legal
reference here.
call. I think the attorneys here really have to tell us that.
And would it be appropriate to have a paragraph 22 and then a separate paragraph? We'd have to move, the last paragraph is paragraph 23 that says consultant attorney. What if that was now paragraph 24 and we made another paragraph in between and said statutory notices? So that all the check boxes are like in the same spot, so to speak, but in two separate paragraphs of the contract. Do you see what I'm saying?
Well, you can also just put addenda and other attachments if you wanted to say which are part of the contract, a part of or related to the contract, and then you could put that in there if you wanted. If you wanted to broaden what's going there as opposed to just being strictly addendum, or excuse me, addenda.
If there's an A or B, if we left in, can you pull up the contract? Paragraph 20.
Paragraph 22.
So, yeah, I think that where you're actually going is probably the way to go.
I think it's like A, B. You keep
Yeah,
the
so
first
you go
sentence, then we
22A, and basically you make it addenda that are part of it, you know, and however you want to group them. And B
or
would
do
be
it.
Other attachments if you want to put that.
Yeah, that would be the same concept, yeah.
Yeah, or maybe not even an attachment, but other notices that have been provided, the language that we have in 20.
Other
12 right
information,
now.
if you want
Yeah,
to,
yeah.
whatever, however you want to.
It preserves that need to have evidence that those really important documents have been provided. The notice that if you don't, then these big rights to terminate can arise. And here's the ability to list what you've already provided. It's not part of the contract, but you've provided it.
And by checking the box, the buyer is acknowledging that they got it.
That's true.
So is the PID notice here, we call it an addendum, and
It's
the
the,
coastal,
it's the next to the last one. on
yeah, and the
right.
coastal area property, I don't think those have
Another,
contractual provisions other than there's rights of termination. So we take those out and no longer call those addenda and call those notices.
Why, isn't it because the PID's in there because there's an actual form? There isn't an actual form for the mud. You have to go find the mud. You have to go find the mud form. We have not created.
Well, no, it's how you define addendum, because we were saying addendum actually has contractual rights.
Okay.
But some of these are called addendum that don't have contractual rights. They're just notices.
We can pull up the actual statute for those to see if it reads like the mud in the pit. I've
Okay.
looked at that before, but I want to confirm it doesn't say, or what it says, to make sure it matches.
I would like some clarity because the addendum for the PID that we have is not, if there's a PID and there is an actual PID notice by the PID, they don't have to use our promulgated form.
Correct.
So if they are attaching it, I guess they would put currently, if we use our current form, they would check other, and if they wanted to include it with the contract, they would write the name of PID notice because they wouldn't put addendum containing notice of obligation because they're not using our form. Is that how that's how we would currently do it if the PID already has its own notice without us having to use our promulgated form?
Yeah,
Well, I don't know if that's.
for example, I'm looking at the environmental or Tidewaters notice. It reads different than our mud and PID language. It says failure to provide this statement prior to closing either in the executory contract. So the in to me would be.
Yeah, but it's just a notice, right?
Right, just notice, but it's talking about what's part of the contract or not. And to Brian's point, in the contract is part of the contract, but it can be provided outside of it. So to me, that would make it okay to leave it in as an addendum, where these other ones are executed at or prior to the time of the contract. It doesn't contemplate it being in the contract, just a deadline for execution and providing the document. So that, to me, may be the distinction, cutting hairs here legally, but the distinction, what would make me feel comfortable with why these other ones would be left as addenda and mud and PID would not be. That's just one of the Yeah, I can pull up the other ones as
Well,
well.
like the addenda for coastal area property, I just pulled up and it uses the term notice regarding coastal area property. But it does have some language in there, some blanks in there for the seller to fill out, whether he has any notice of any prior fill there or not. So that's a notice. It's not necessarily a contractual obligation.
This is the PID. I think we misnamed the PID. It should be just notice. It was not an addendum.
Well, you also need to go back to the statute itself, because of the statute, it says must be included as an addendum. Then you want to use that term. So we'll have to look just at the forms, but the statutes.
Same on that propane gas, it's a notice. I mean, right, the propane
Yeah,
gas service.
so,
area,
but
it's
we
a
got to go
note,
to,
yeah.
so we need to go to the statute
Statute
to
and
see what terminology they use.
And I don't believe there's a statute that contemplates an addenda or addendum to the contract. I think they're all providing it, they're executing it, or you can, that one Todd Waters can be in the contract, but can be outside.
Okay.
And so I think that's kind of the breadth we'll be looking at. It. Delivery, execution, or it can be in, but kind of having the scope of things without, we need to look at each one in particular, but I'm confident that's how you phrase between the three options.
All right. I guess what we can do is for today, let's just presume a certain way. And then
see if we like it first, and then we can.
And then we go back to, then we can always move a few of them based on our review of the statutes.
I like that. We can advance the ball.
Let's just make
and this doesn't
yeah.
necessarily, it's not as pressing as like the notice
Right.
provision would be a change that we can.
But let's make a presumption about this now for purpose of drafting and then go back and double check.
Much potentially as well. Okay, so let's, is there a way you can start a new draft that we can tinker with?
Yeah, so what we want to do in, see, we're in your version of.
Can mute online? Somebody's unmuted.
That'll take Amber just a second.
Okay. And maybe look at the list first of what's not on there right now to see if we want to add those. And then, because that may impact the fields we have, and just make sure everybody's on the same page.
Okay, so do you want to start with this and say we're going to go with this kind of grouping?
I think that could be step two. I think the first step may be to tee up these ones that are highlighted is minimal, because I think that could impact the grouping. I don't see any reason why this wasn't included other than space in the contracts. It's in condo. There's no sense for it to be in condo and not the 1 to 4 and others as well. So I would recommend adding that one as we look at doing the addendum for release liability.
We have that?
We have that in the condo right now.
We don't have that in the 1 to 4.
Exactly.
So
I mean, we
It doesn't
don't even
make
have
sense.
a piece that it doesn't exist.
You're not going to need it for the new construction though, right?
Does that addendum exist is what I'm.
That's true.
Well, couldn't the list be made specific for the contract that's attended and taken out? I mean, that shows we did our homework and knew that it didn't belong there.
Okay, so
that one, I think if we look at where it's added, if it's appropriate to add in a contract, I think we should on this one and not for like the new home. Like Brian mentioned.
Do we have that though?
Yeah,
Do
it's
we
right
have-
here.
You have it? Oh, it's over on truck.
And then the next one, there's only 2 other ones here.
let me get this for the minutes real
I've
quick.
never
So
seen
that,
it. I've
so
never
we
seen
are
it.
recommending adding those 2 to paragraph 22, right?
It's one form, but yes.
Yeah,
I think
I'm sorry, yeah.
to the 1 to 4 contract.
Okay, go ahead, I'm sorry.
And I can check. I know it's in the condo. I need on the unimproved property.
Well, it's only assumed.
Let's see if it's in the one
Assumed loan and or restoration.
in the unimproved.
How many assumed VAs do we have?
Who's stuck in and or in a title? Oh my gosh.
that one slip by. It must have been a late in the afternoon edition.
I'm gonna say it's one of the old guys.
Yeah. It needs to be added to the unapproved as well. Can you get a?
So we're gonna add, let me stop sharing here, and then I'm gonna pull up the minutes, and then we can just, you can tell me what we're actually doing here. So we're recommending adding this form to paragraph 22. And what we can do for the minutes is to say of the 1 to 4 family form and other forms as appropriate. That'll work. I think Abby will understand.
I'll take notes.
Or as applicable. Okay, so what's the next one here?
So the next one, I think our discussion on the AB paragraph issue will address the PID notice. The PID notice is in there right now, but not the MUD, so I'm not sure we have anything for the most bit on that. The other form that's not in there right now, and I'm throwing on the table since we're analyzing this, is the non-realty items that didn't.
Lenders hate that.
They hate it, and that's why we've largely kept it out.
Right.
I'm struggling with why we did that. And I've always, each time we talk about it, I struggle with it. And just because lenders don't like it,
It's part of the contract.
it's part of the contract. And
agents ask for it.
and they shouldn't be having things under the table. And I hate, I know why we did it in the past, but
Here was the thought was, if it's a mandatory form versus a non-mandatory form, then the fact that you would use it, but not attach it to the contract, that's why it was excluded.
okay.
All right, so it was allowing the brokers to get to use the form without attaching it to the contract because of the lender's objections to it. Some thought process like that.
Well, because you've got a lot of the houses by the lake and stuff. It would be a nightmare to do the non-realty if they're selling a furnished house.
But I think so.
Nightmare.
But I've seen.
They do,
I've
they
seen
just
the
do a
addendum
regular.
attached. I've seen the addendum attached with lender transactions in some cases, and the lenders haven't objected to it.
I think the lender's viewpoint over the last 20 years, when this first started, where the lenders didn't want to see a non-realty addendum, and their rationale is we're lending on property, not on Harvest Gold, washer, dryer, and refrigerators that are 30 years old. And so all of a sudden, 20 years ago, 15 years ago, it all came out. Now we're seeing their attitudes a little different in that it depends on what's included there. And what we are seeing is that agents who remember that will have two different contracts. One with a non-realty item addendum where the buyer and the seller have signed off and agreed to what goes with the transaction. And it is a TREC form, so we need to introduce it. And others that don't include whatever is on there to the lender. And we know that that's not acceptable. So I think there, at least in our market, has been an increased need for the use of that form. And if the lender involved in that transaction has an issue, then if with their instruction, it's removed.
And
Or we can be like the other states, they just include.
I think it's a valuation issue too with the lenders, because you have how much is the value of the non-realty item addendum? And the problem at closing, whether the parties realize it or not, they're stating and verifying there's nothing outside the transaction. And if you have, whether it's just a washer and dryer or whether it's a full house full of furniture, there's consideration being paid for that. And they scrutinize how much you put in the non-realty item, whether it's $10 for all of this, or is it, the actual reasonable value that may be tied to that. And so it can impact the flow of transactions. And I struggle with this too, because we're supposed to expedite real estate transactions. And where you have been fine with good actual foundation reasoning of being voluntary. I think the context of we know it will slow down transactions if it goes, but ultimately the parties are saying at closing, there's nothing outside of what we've done. And if that non-realty item, which is an addenda, is part of the contract, isn't included, there is something outside of it. And that's where I think I struggled that I think we need to include it because of that. And the practice needs to understand what they're signing and what the regulations are.
Does the wording need to be reviewed based on that?
I haven't thought about that.
Let me ask the brokers too, is it a problem of just having a checkbox that says non-realty items addendum?
It's not a problem. I love the idea of including it personally. If it's part of the contract, it's part of the contract. If it's not, we have nothing to do with it and should not have anything to do with it. There shouldn't be any side deals going on, and we do not allow our agents to use the non-realty if it's not included in the contract. As Diane mentioned, if the lender has a problem with it, because right now we're checking out, they're putting non-realty items addendum. If the lender has a problem with it, then we go back and we amend the contract to remove it.
And I do see a lot of lenders and the title company that's saying, take it off. But they're getting themselves against, they're just trying to get the deal closed, right? But it's still against what the parties are signing. And it's most time the loan officer that's just, let's get this one through. I don't want to see it, put blinders on.
I guess
That's not appropriate with what they're signing either.
I guess the question is, non-realty item mainly is the refrigerator. I mean, in most cases, it's the refrigerator. I mean, that's 90% of it, okay? Why wouldn't we just add it into the contract? In the first two paragraphs, because Colorado does, Utah does, all these other states, the refrigerator comes with the house.
Oh, gosh, I think that's a horrible idea.
We found something that got our attention.
I'm sorry. Did I say that out loud?
Yeah.
You lost my filter for a moment.
I'm just saying, the other fiduciary states, that's what they've done. They've just added it into the contract.
They can always add it. Let's bookmark that for discussion too. Let's look at the non-realty first, in terms of I thought the language of the actual form, which I think is a good idea for us to look at. But if we're making these changes, I think it's to me best to add it as part of the list and not keep it off the contract anymore.
Agree.
Yeah.
And if we look at the other list, if you pull up
the contract
or the outline that I had.
Oh, okay.
I went through and listed, or we had working group with it and listed the other forms that aren't included as addenda right now, but that are there. And we don't believe these should be added, but I just wanted to write they're not included. So these are the other forms that we have that are not listed in the section, and for good reason. We believe. So when I say that first one not included, for the farm and ranch, we decided last time to take it out for the farm and ranch. Or no, sorry, that's it. These are more notices or certificates, not addenda.
Yeah, this is fine. I don't think that any of these need to go because they really go with typically part of the contract. So this one, D, is actually going in only if you only have a lease.
And it's no longer.
And that's going to be an attachment to the lease. Oh, that's right. It's no longer required now. Yeah.
Not the temporary lease, yeah.
Short term.
So I just wanted to highlight our other forms that we went through and looked at everything, not just what's currently listed, but the other one. So just want to highlight that before we move on to the next discussion. In this, we discussed and made a decision, it's in our minutes from last meeting, to remove the mandatory property owners association addenda, or addendum from the farm and ranch contract. And that's because section 5.012A of the Texas Property Code requires certain notice language in contracts. And if the sale of the property involves basically residential sale for single family house, the farm and ranch contract doesn't have that language. And the addenda doesn't have that language either. It's built into all of our other contracts. And so the determination we made last time, do we add that additional language in to the farm ranch contract and keep it as the POA addendum as an addendum listed? Or do we just take it out of the farm and ranch? And we decided to take it out as an addenda. So with Diane being about specific to each contract, that'd be one we would leave out under her thought there. And I agree with that. 100%. So, but just as we get through there, we've already taken that out at our last meeting from that one contract.
Now we talked about this.
Yep, and so now we would go to the we do the categories.
Back up to the categories. Oh.
And I think that we were purposeful to put the financing category first, right? Like when we were discussing like, okay, then does it go in alphabetical order by category? No, because the thing that needs to be attached most of the time is how are you going to actually pay for this purchase that you're doing? So the financing would need to be
Most
the
common.
first category.
So on the PID, are we leaving taxing district? Because we would need a category of taxing district, right? If
Correct. We would take those two out.
Take those two
if
out.
We did the thought that we're going down on that being listed in section B, or at all.
Okay. Well, I'm almost tempted to just throw this number 3, whatever I just did there.
Just hit the back button.
Undo.
Undo.
Just putting these under other.
I wouldn't mind that either. I was struggling with that category when I was trying to throw out ideas.
Yeah, so you just stick those here because you only have one form for each of these categories.
And that not needed in farm and ranch for the middle,
Yeah.
and there's not. There's an
Yeah.
error in comment there.
That'd be my recommendation, and then take this one out, number 5.
I'm good with that.
Okay.
Is there any relationship in those forms? Other seems like I don't know what to call it, so I'm gonna call it other.
No, it's just the fact that there's only one form for it.
One-off
Yeah,
addenda.
so the title is basically what each form that's within that category already is. And so the other, it's just,
Other
it's the one
forms,
title.
yeah.
I like that. I think association and minerals is confusing.
Yes.
Do you like the idea of putting them in the categories like this? Financing is one thing and.
Teaching wise, yes.
Understanding for the agents, I think we're giving them a huge help. They only have to look at the categories. And they may remember something that they were gonna forget.
I mean, yeah, I think
I mean, it won't
it's,
include everything, but
Not included is a,
But we wouldn't have that. That's just for purposes of reviewing.
okay.
It
All right.
wasn't intending to display
All right.
all this, was more we're talking.
All right.
I think it'll be way easier to read, identify what you need, much more cohesive from an educational standpoint. I think that's huge. Especially when we're talking, there may be a few agents that give pushback on it, but we have had enough comments to do something with it. And new agents coming into the business, I think that will be a huge boost. for
I
them.
agree.
good point.
Yeah.
And the language can be worked on with titles too. So the titles is the best to come up with an idea to throw out.
Okay, getting this over to the minutes.
My only comment might be in the lengthier ones, like financing and payment terms, that maybe the order of it be in the most frequently used as opposed to the current order. I wonder about seller financing addendum being that high up, and addendum concerning right to terminate due to lender's appraisal. That used to be a very frequently used form. I'm not sure how much it is now, but just a thought if there's.
I think that those, so when I'm looking at the order of those, the only ones I would switch would be C and D. Otherwise, I think they're in a pretty good order compared
Yes.
to how
And I agree,
common.
those are the only two I saw,
Mhm,
C and D.
mhm.
This is coming out. Let me stop sharing and just show you what I'm doing here so that I'm gonna have to take some time over here in the getting the minutes correctly here. So I'm bringing these over in these categories here like this, along with your notes over here. And then this one is going to actually be moved, right? We're going to take this out.
Correct.
I think that does that. Obviously, I got to fix this up for the final.
You can go and take that note out to the bottom of the page. I'm not leaving farm ranch, it's the inheritance.
Okay. So that's the general categories for now. I'll fix this up for the final minutes, but so we'll have the financing and the payments. Was there some movement around here that we were doing?
In the first one, seller financing, I didn't think we can do that below the appraisal, didn't it?
Flip C and D.
Oh, okay. So we don't really need this one in the condo, right? We take this note out.
Correct.
Okay. I'll fix that up when we have, maybe at lunchtime, I'll fix this up.
We can make a note that that's not needed in the new home.
Okay.
In particular, the long title property conditions, disclosures, and regulatory notices, that was pretty lengthy title, but I was struggling with coming up with a recommendation that was shorter considering the nature of the documents that were in there.
So these are probably not regulatory notices, but statutory notices, right? So the reason why you have property conditions here is only because of the addendum authorizing hydrotat testing?
Correct. Before, when I was moving things around, it had
should this be going, should this
Put
be?
that under other and then just do
Other and just call
disclosures
it
and statutory
disclosures and
notices, yeah,
statutory,
I like that.
Y'all are thinking so smart fast there.
elected brain power.
And make it statutory disclosures and notices.
Okay.
Is the water district notice letters, whatever the seller is giving to the buyer, is that now under 5 taxing districts notice to purchaser special? Isn't that our form when there isn't an available water district notice? Is that addendum 59?
Yet the notice to special
Uh-huh.
taxing district, that, yes, and that we were talking about moving into B. and out of this instead of getting rid of that category, the taxing districts above.
in
and
that
then move it
notices
up.
section.
So if that is only used when there is, and legislature says you're supposed to give one water district, should there not be a place? Because what we're seeing is that agents are attaching that under other right now, whatever it's called. Where would they be putting it now, and how would they know to do that?
With Ron's idea of adding that into that new section B language that we're moving from 6E12 down to 22B.
And that would prompt them somehow
Yes.
to know that it's water, not just other in a blank.
Correct.
It's gonna say.
Okay.
So I'm sorry, I only caught half of that. What, is there something I need to move? I was-
No, you've already taken
Okay.
those. It's got the water notice and the pit notice. We were discussing how you thought of moving that to B. And
Okay.
the new section B that we would add.
So one question here, since we say this is the statutory disclosures and notices, this actually, the environmental assessment is not statutory and it's not a notice or disclosure. Should we move that to other?
That was part of the property conditions.
Yes, yeah.
Short answer would be yes, it's not appropriate there since it's just a,
And do we need another property condition standalone if we have at least two items, like the hydrostatic testing and the environmental assessment? Do we just create one for property condition, another category?
Would you like to do that?
I didn't catch that.
Do we just now create a standalone property condition category with hydrostatic testing and environmental assessment underneath it?
It'd be interesting to see how that format, I think that makes sense now with
Yeah.
our logic of having two under that category.
Good thought.
And we've taken one out already, so.
Which one are you? The second one from the left.
I can see people attaching inspection reports. Property condition.
Yeah, but we won't have another there.
It won't be well,
We're not gonna give it an option for
No.
other.
no.
Other.
Yeah, I guess,
Let me know.
Is it property condition then the best wording for it? Is it property inspections?
Environmental, I don't think has.
Inspections,
Um,
or is it just talking about,
yeah, no, it does call for inspection or whatever they call it. It's assessment. to
or
be
property
done.
assessments?
Environmental assessment, maintain a report. Maintain a report. So it's discussed, it looks like you may obtain a report of some type for each option.
Because property condition almost makes me think of seller's disclosure notice.
Yeah.
Or inspection reports, neither of which you want to have attached.
Property
Can we just put them back in other?
inspections.
Yeah.
Yeah, that's a good
Inspection
point, because
authorizations.
maybe they're not used as much as some of the others. Inspection.
I don't like that either, but-
authorizations.
No.
Is an environmental
Yeah.
assessment just a statement?
Property physical characteristics.
That's,
I don't know. I'm trying to think of different words for that.
Other.
Evaluations.
We,
Oh, additional inspections.
we want to make sure we don't impact somebody's argument on 7A, reasonable access and what's
Yeah.
allowed.
Oh,
Hydrostatic testing is
Authorized.
absolutely a category you have to get.
Authorized tests? Food for thought.
I don't know. I'm not sold on that, but
I'm not sold on it either.
This is where we need to put it in ChatGPT and say, give us 20 examples.
cheater.
I'm not joking.
It does work.
There he goes.
So we have payment terms here. Should we just simply say financing? Well, there's got the addendum, section 1031.
Finance.
A lot's going to be depending on what we put in as the lead in to this paragraph. So that may explain it if we just simply say these are categories.
So you want to jump to that to take a step forward?
Yeah, I can go back to the contract form here and see what you have on that, because it's
I'm typing this out. What am I going to say? I haven't really been.
Is that wording sufficient for 22A and we just need a header paragraph above it? Following documents may be attached or something, and then this, because if you're gonna have agreement in 22A and not agreement in 22B, but notices, the agreement can't be the header for the whole paragraph, right?
yeah, because we'll have to break it down into an A and a B.
Right, and under A, it would be agreement. So I feel like 22A could just read just like it does. Right?
Damn. Is it agreement of parties or is it disclosures of some type? Is this the time to relook at that wording, agreement of parties?
Yeah, the title to that paragraph you could change if you want to. John's gonna see what ChatGPT says.
They can do a copy.
See what's going on over here, yeah.
I think the legal 2 update says something about AI.
AI, and the entire chapter was written by AI. But then it had to go back through how many lawyers and clerks, and so that the whole thing is you can use it, but you have to review it. That's cannot trust it or blame it.
That's right.
I happen to have it here if you need to look. I love that.
You know what?
That's a fun chapter to teach.
I'm teaching legal one
in the
next
instructor
week.
courses. The AI chapter it evolved over time. As we were
160 people in class next week.
Oh, yeah.
I have it. I need to
Actually, 22.
Legal one.
just a little bit.
It's having the contracts in there though.
Well, we're gonna give them.
Well, because we have to teach contracts separately.
You don't have to, in addition to.
A lot of the students thought it was a lot of duplicate. You just did the 3 hours, Mary.
I like the exercise.
Huh?
I like the exercise.
So-
Trying to figure out which one fits.
Agreement of the parties actually makes more sense here because if we break this out into A and B, so this would be addenda like this. Check all boxes that apply. And then you'd have, I have to fix all this so it'll look better for you. And you may want to double column this, I don't know.
Yeah.
I think so. My thought is, as I drafted that, was to have the same structure we have.
Look of it with just.
Yeah.
Otherwise, it'd be 2
currently-
pages.
Yeah,
Is with
currently.
formatting in Word is looking.
I defer that to another working group.
Would we want to do financial instead of financing?
That's probably better.
Yeah.
Oh, that's interesting.
Oh, I need to fix that.
That's
Okay.
what it's all about, folks.
The challenge is some of those
Watching Ron
titles are so
Yeah.
long. it
Yeah.
doesn't-
It's fascinating.
Watching him
The
move
most
things around,
amazing
format.
leaders.
Yoda can do it.
Yoda.
I guess you can do double count on.
Christie, you need to fix this title here on this additional test.
I know, I didn't like anything my chat GPT came up with.
I'm not liking what's coming up with here either.
Can we just?
Physical
I still think
condition,
put them up in other.
property
I'm
evaluation.
okay with them being.
They're not, I mean, they're.
I will say this now for the public's benefit, but as I was getting ready, or for a while before the instructor courses for the new legal update, I kept track of how wrong ChatGPT was, in particular, the one that I mostly use, with contractual issues under our contracts.
Yeah.
And it was 75% of the time. So we had check rules, statutes in our contracts.
Wow.
And it's gotten better since then. There's probably about a year worth of data. And I've stopped keeping it at some point, but it was, it was, when you say you're wrong, go look at 1101, blah, blah, blah. The thing, oh, you're right, I was wrong, here's another wrong answer. So cautionary tale of everybody that would listen to this, all 15 of us. Be very careful with using ChatGPT to track or analyze.
Anything that I've done with law, and I barely use it because I don't trust it. It never comes out. It's like you said, 3/4 of the time, it's like, no, I have the statute right here. What do you?
Where'd you pull that?
But you can work with it with hours if you want, like dump this statute in, dump this statute in. Remember this, now regurgitate it back, and it still will get 50% wrong. You're like, I just gave it to you.
And it sounds so good too.
Oh, no, it does.
Oh, yeah.
Wow, that's well written.
Christie, how about we just move those back into other?
Well, how many do we have in other right now?
1, 2, 3, 4, and then another in the other.
Double
So
column.
5.
Some of those titles are so long. How are we gonna double column?
It's that way right now.
Yeah. they're the
It's
same
that way right now.
Oh, because they
It wraps them
double.
down.
Okay,
It
that's what
wraps.
they're doing.
Yeah.
They wrap them. Okay.
I'm not opposed. I still like the fact, I'm just gonna say the
Testing
one,
is Probably more common
it is more common and
than the environmental.
not
We'll talk
known
about
enough because there are problems with agents getting hydrostatic testing done without that filled out in advance because they have no idea and think, oh, I can go do what I want to do. So I love the idea of it standing out a little bit under a
Header.
evaluation or assessment.
Yeah.
At the same time, I understand that maybe at least other is still better than how we have it. It's improvement.
What's that? This, you could just say assessments. No?
I don't like additional.
Oh, okay.
I like the way you have it,
Okay.
or evaluation.
Property evaluation.
You like test or evaluations?
Evaluation to me pulls it away from the inspection report and disclosures.
That's safer.
Yeah, it's something they're not used to seeing, which will distinguish it.
I think, I like that.
Which one?
Tests and reviews.
Simpler.
That's what ChatGPT can do.
So this is now paragraph 22 is going to just read, this contract contains the entire agreement of the parties and cannot be changed except by their written agreement. And then addenda will be A. And then we could put well, check all applicable boxes. I don't know if you need that instruction really, but.
Well, we have it now,
Yeah.
and I feel like you should.
Yeah, I agree.
If you wanted to do, I don't know if you want to do something like this listed in the following categories.
I think because the current, when we're saying the addenda which are part of this contract are, and then checking applicable boxes, really underscores the fact that if it's not checked, even if it's included, it's not part of the contract.
That's
You have to
usually
check
what
the
it
box
says.
and attach the form. Yeah, there is occasion sometimes where somebody attaches a form and doesn't check the box or.
I mean, that happens with third party
Mhm.
in paragraph, the first, second, third paragraph.
Well, if your signature is attached to it, I think you're sunk to argue that it's not part of the contract.
Okay.
Got that from a legal.
I like it.
Do we want to move on to B?
Okay. Go with that for now.
Grammar police, should that be addendum that?
I struggle with this one all the time.
Do we need to say temporary leases?
The current contract says,
Or is
It
it?
currently
has-
says addenda which.
it does.
That's what it currently says.
Which one that? What does-
I think,
I like it categorized, so,
I do too.
but I like the idea of going on and doing B and try, because that's gonna be a little bit extra.
And what is
Copy
going
in.
to be notices?
Saying that there's that where we move 6012 into 22, so taking that and reworking it to specifically reference the
Yeah.
hood notice and the mud notice.
And like you all have said earlier, it's education in itself.
What if we
Oh, I
do,
didn't know that
back up,
one.
do an additional test and reports? Because on the environmental, it says buyer may obtain environmental report, may obtain a report from the natural resources, and may obtain a report from an environmental specialist.
Additional tests and reports versus reviews.
Mm-hmm.
Oh, I like
that.
I like that. And still keeps it separate from inspections.
this doesn't mean that the brokers are actually going to take tests and do reports on it.
Yeah.
Get my school teachers in here.
I'll circle back to that.
Are we going to provide any blank lines?
Yeah, there's going to be, this is going to be more,
Other,
Okay.
yes.
I kind of always hesitate to give them those blank lines.
yeah, this should
God
be
knows
more.
what will be there. Do we have to?
Before we do.
Yes, because that goes to the whole concept of whether it's the primary contract.
Oh, you're talking about the order?
The ordering, okay.
Yeah. Yeah, the only concern I have with notice is just to throw out there as we're starting to drop this is, does that, we already have a notice, paragraph 21. Just a thought as we go through.
Statutory notices is what we'll need. Yeah, let me copy what you had written on this over here. Because you call it required notices, actually.
And that was taken from our paragraph 6012.
Mm-hmm.
I'm looking like a propane gas that in paragraph 6, it has a statement, an addendum containing the notice approved by TREC or required by the party should be used regarding propane gas system service area. So is that saying an addendum that contains the notice? So where does that and the Tidewater one fall? They both have the same wording, an addendum containing the notice. Are we looking generically as addenda being anything that's attached?
Correct, and part of the contract itself.
And I think that's a problem agents have with that interpretation because years ago, they were trained, if it doesn't have addenda in the form name, it's not an addenda. And we've come away from that. Yet we still use the word addenda, just throwing it out there.
Well, remember that thing that I gave y'all from that says this is an addenda, this is a notice, right? And an amendment. Do you remember that?
Well,
We had our working group and I gave y'all
we
the
have
screenshot. from that
this up
stuff
here,
on the
statutory
class.
disclosures and notices. Should we now consider putting this back under this category and almost like have a, if we stuck, I'm just gonna put that here.
To put
just
all of
show.
those in B, is that what you're saying?
Let me ask you from boots on the ground, away from just the geeky legal side, does it hurt having a part of the contract? right? It's such an important thing. We want to encourage that practice, and they don't have to do it if they provided it before. Of putting the PID in the mud up in this section with the other addenda, instead of having it down in the separate required one. What's the harm of doing that? It's not required, so we get away from this looking geeky, what's required, what's not, to.
We have a lot of mud districts in the Houston area, so it is one of the most frequently used.
At some point, we thought it was good to put PID as the official in the addenda section.
But wasn't the reason we split it up was because we wanted to highlight that they have the right to terminate if it's not delivered.
Which I think we still keep B, but maybe still circle back to the thing of putting that in as well in A, right? And B still is the spot to list if you've already provided it, if you want to, or we look at that, but that's telling you may have this really important right. But I see what you're saying.
Yeah, because that's why we had it separate, was because there were additional rights, and we were trying to keep that language that if you don't do this at or before, there are rights to terminate.
A lot of people missed the mud before. They missed the mud. They missed the mud paragraph.
Well, let's work on B and maybe we can see how that turns out to give us the answer.
Yeah.
Ron, can we get our Zoom again? Sorry.
Oh, yeah.
It's just a little bit. Just a smidgen. I may have to move to the front of the class.
You may have to go switch with old Brian.
I'm gonna sit in front of old Brian. My visitor pest said Big Tony, so I liked it better.
So this would be B, and we want to say.
Oh, thank you.
It's called
No,
recording
appreciate
agent. And this would just go right in here like this.
That's a much needed statement.
So in that parenthetical there, we're really talking about the mud and the PID notice, right? We're vague, and I think if that's truly what we intend that parenthetical to be, that we be specific.
Yeah.
There, and then we can talk about the duplication of that and above, but it's not duplicative in the sense that you can provide it before and it'd be sufficient. And that's the place to evidence that you did provide it.
Could we do something similar in this section, how the seller's disclosure notices earlier in the contract that has already provided or is attached? And then we have a checkbox for PID, we have a checkbox for MUD. And regardless of whether or not they use their own form or use our promulgated form, there's a way for them to indicate that it has either already been provided or
It's being provided
is
now.
it being attached now.
That's going back into paragraph 6 then.
No, I'm not saying it has to
No.
go back into paragraph 6. I'm saying kind of work some of the language we have around the seller's disclosure notice on either having already been provided versus, because that's what this is saying a little bit, that we would normally have put on that line what's already been provided or is attached.
Oh, okay, so you're not saying a separate checkbox. Okay.
Well,
Well, some of those forms you already have in here, like the ones that are in paragraph 4, give you a have been provided or not, and then they're attached. I don't know that we want to go over that again.
no, I am also understanding that sometimes a PID may have its own form and they don't have to use our PID form. Same with the water district.
Right.
So indicating the difference between that. We can't just have a checkbox for our form because they could have
They could
provided
use
their
their
own.
But they can use the other.
They could use
That was the
other.
whole idea, right? Have a checkbox for the Trek form and then have a checkbox for other. You don't have to use our form, but if you
Mhm.
are attaching their form, you put it here. Like the mud notice form from the mud.
We don't have any local forms that are normally required out there, are there? I know in Austin, we have to give that energy inspection.
That's stupid.
How do you feel about it, Mary?
Stupid form.
Um,
And half
So I
of the
guess
time
that-
it never shows up.
So if you want to put it in here, just go under other, I guess.
Yeah.
So are you just planning to
So we
leave
have
B?
another with another?
Yeah.
Do-
It's the.
How about additional?
Or what we can do, just
Nice.
leave it blank
Someone's asking a
With the
question
check,
in the
yeah.
back.
with a checkbox. It can
Yeah, I like that better. It just.
I'm struggling with something. So required notices is, this paragraph is only kind of saying like a water or a PID notice. Required notices, seller has delivered to buyer or is attached. And then the paragraph above is talking about notices, which a notice could encompass a lot of different things. And then we just said above, it can be delivered to buyer, seller, or their agent. But then for attaching it to the contract, like it's going back to just between the buyer and the seller. Could you just take the bold version, the bold sentence, and then move that to paragraph 6, 12, like where it is now, and just say failure to provide? I'm struggling with something.
And that's
So you're saying send them from paragraph 6, send them down to 22.
Yes.
That's what she's.
I think what the intention was moving this together is to have it all in one spot where it's listed on what's been provided or what's attached. I'm struggling, with that on the two places because it's taken into account that we can provide it in advance. And so having, like here, what we have is inspected by seller has delivered or has attached to this contract. To me, attached is already done in A.
Yeah.
But if we moved it back up to 12, 6012, we'd still be having to look two places.
Okay, but what about the words like when we have up in 12, 6 or whatever, where it has all the notices and it talks about the HOA and it says that it is attached, use the form or whatever. I'm just using that as an example. What if we had a sentence like that
just like move
sends
that
them
bullet
back
one.
down, to just a statement?
Well, why don't we just put it here instead of just put mud form and just put a list here? Just list of mud, water conservation, and just put those down there.
With checkboxes?
So in other words, what you'd have is, with the checkbox, with the utility, and then a line, water, a line, drainage, a line, public improvement, a line, or, PID, and then you just have those mud, and then just another one that's blank.
And back to like the argument that the attorney made,
So it'd be
like that kind of got paragraph 21 revised, like, do you want to include seller has delivered to buyers and someone's like, oh, you didn't deliver it to me directly to the buyer. So the buyer, like, does it need to say or to their agents for the same word notices and in the paragraph right above it, or to their agents?
Most
Well, most of these
I think
require.
The statutory ones that we
Require a
careful.
Or it may come later. And then if it comes.
If we go down this,
Mhm.
if we go down Ron's thought of having all those
Are they
checkboxes,
doesn't?
I think
Notice.
that's going to take more
The
time to
statutory
review
one
and
is supposed to
see
provide.
what each one's required that we list there. And then we can look at that same time, the actual statutory notice on,
The PID out of here. I was working.
if it's a statutory requirement, can we change it up by contract? And on who ultimately receives it, or how it's received. But that could be part of that additional thought process on how we analyze on how to do that. Or that might.
Just the one I normally.
So I do think if we're making this type of change, we need to go back and look at the statutes and make sure we're listing what we need to there.
Well, so what's going to happen here is this is going to prompt someone to ask, are we subject to these things, right? Because we're going to see lines here where we're
Well, we
gonna
have
put
that
this
new water form that's somewhere on our to-do list for today too.
in. So, and then you could put other districts here. If you wanted to do that. And then you would have check boxes in front of all these.
Addendum for
I'm sure we-
wood-based paint.
Limit other.
Would that Austin form you were talking about fall under district, or is there another word that, in that other that you just added there?
Or I guess you can just say other.
Just say other. Just other.
Bring this up, so it's on one page. Didn't get it. Still.
I want to make sure I understand because I'm a little confused. They check the box, y'all would have a checkbox in front of that, and then they're supposed to list out the name of the water district, the name of the drainage district, the name of the PID.
Mm-hmm.
Okay. But are they also understanding, that doesn't clarify that they've either already provided it or not? Are we still having the other language is still below it?
Yes.
Well, if they've already provided it, what's wrong with attaching it?
There's not anything wrong. I love the idea. I would recommend everyone attach it even if they've already provided it. It's clear. So if that's the way we're going, fantastic on requiring it to be with the contract.
Well, I normally do that when we have that because the title companies all want to see it.
Why would we have blanks for
The name of the district
right
or the form.
the form as opposed to just being another checkbox? Because if it's a district, we're providing the right form to go with it that would have all the information.
Mm-hmm.
Seems, at least for the mud and the PID.
Okay, so you want to
So for the two forms that we have,
take the lines out? What you're saying?
I would think, in my view, yes, because they're already providing it through the other one.
And it's gonna
so
be
fill me in there.
attached.
Right. It makes it less burdensome on completing it.
do we have to name the fact that we have two forms, our notice to purchase of special taxing or assessment district, and then our PID form? Do we have to name those like we've named our official other promulgated forms as an option?
That's what
that's what you were saying.
That's what I would like to,
Yeah.
to do, just have it as the actual addendum.
Okay.
Mm-hmm.
Like this?
Addendum containing notice of obligation to pay public improvement district assessment.
So Abby, remind me on the form that we have out there about the water and other utility district form, are all of the districts they're supposed to be using that form? Or
No,
are they-
That's the
No,
issue.
That's
that
a
was
voluntary.
backup
Okay.
when there
If
were
they don't have
issues that the water districts weren't providing it because some of the smaller ones didn't know.
Yeah.
TC, EQ, whatever, did not notify them. That's not what we're seeing now, that the water districts have their own forms.
Okay.
And I rarely see that they go to our addendum 59.
Okay. Yeah. So there's really no reason to, other than just if you wanted to name the district, I guess you can name it.
That's what
Well,
I'm
that would
wondering,
give
do
the
you
name
want
of
to
the
name the
notice.
district?
Yeah, the name of the form almost, to me, is what should be filled in there, since
What
they can
is
use
it?
our form or they can use the water district's form. What's the
So I
actual
think
title on the water
The
district form?
statute doesn't use.
Notice
Well-
to
Purchaser.
There's going to be, I mean, if you're attaching one that you, water district notice that they provided, they call it different things.
Then I suggest that we put the names of our two forms that are options for when the provider doesn't have one available. And then under other, we could put in parentheses next to it, attach the water or mud or PID form. I don't know.
Well, you can have the one they have, notice to purchaser for special taxing or assessment district. That covers your
back to what we had here. I don't know,
covers your water, your road, everything here.
What if we went back to
No one's gonna fill that out.
some of what we had as the following, mud, water, drainage, public improvement, and other district notices. And you just had a checkbox there, and then just had either name, all that apply, whatever instruction you want to say, or list all.
Notice. Okay.
And this is an A though still?
Yeah, this is an A, so that you wouldn't have a B.
So you wouldn't have to be.
Would that be better to do?
And this is under the thought that even though it doesn't have to be attached to the contract, doesn't hurt to make
For
them.
clarity to go ahead, even if you gave it to them already, add it again for clarity.
Because that's what we did in 6 currently.
So then where are you gonna put that language that we're pulling out of 6? That,
I might have to put that in there.
I think it's getting better. I still have a concern that if we have promulgated forms that are available for the license holders to use, that
We
they
need to list
use
them.
it, we need to list it with the checkbox. But still also, if there's a different form they're using, I don't know how to tie that in together, but I still think we have to list the 2 that we have.
I agree with that.
Right. So all of these would have a checkbox in front of them.
Could we, if we have a checkbox under the following, include as an option under the following our 2 promulgated ones for water and PID? In addition to the lines, showing that they have an option if one is not provided by the actual MED or PID, here's their options on what they can use.
Aren't the mud districts
so you
required by
want the
the state
addendum containing notice of
legislature
application.
The hay
have
and
those.
mud.
forms?
Yeah, they should.
It's the rarity when it doesn't happen. That's why I make sure we
Like
don't
this, the
confuse
PIDs
it
were
and make
more
the agents think they
complicated.
have to use the
Right,
promulgated form, because they don't.
they don't. But knowing that it's there, I don't,
And so, Leitra just joined us. Welcome, Leitra. Glad you can make it today under the circumstances. Thank you.
Thank you.
I remember the conversation when the addendum was developed. It was during all of that confusion with the water
Mhm.
districts.
Some are providing it when they are
Yeah.
required to.
Yeah. And I just don't want it to make it look like and confusing to the agents. Am I supposed to be giving this to the seller instead of the other one? And no, they're not.
Our forms are hard to fill out. Just go get the
Yeah.
one that's out there.
Yeah.
Well, it's a seller's disclosure. We're not supposed to do anyway.
No, but I mean like the PID and the mud and stuff, I would never use these forms. I'd go to the district and get them because
Well, the districts are supposed to do it. My point there was that we don't want to confuse the agent to make them feel that that's their job now. And it's not.
Almost saying like Princey's after mud, district provided or track promulgated, given the something
yeah.
that if we want it to be educational specific. And then,
I think it's
I do see your point though, because every other form that's promulgated, we have in that list, except for the PID and the mud.
Or even something like you're saying, John, district provided option, there
If
is
the
the
district-
ability to use promulgated forms in the absence of district provided forms and provide them with I know the contract's not where we need to be doing necessarily education, but
Well, you could just put a note here, district notices may be provided by the district.
Some districts provide these forms.
Yeah. Or,
If, in the absence of them having one, we have a form available.
it's provided to, we're using providing the same thing 2 different ways. The first one, because if the seller has to provide it to the buyer. We don't want to give the indication that the district providing it to the buyer is okay, as opposed to making it available.
Well, I guess you could,
Maybe things.
seller may obtain district notices. I guess I'll just kind of.
Someone let us. Soccer wants it.
These other forms you want to say, or where are those? Or, I mean, other than. Or provide. What do you want to say here?
You could just say use.
May use. Notice is published by TREC. I don't know if that's the right thing to do. They use forms.
I feel like
It's almost like it's saying we publish their district notice.
yeah, and I don't like it that it's just like, or they can do this, because some people might be like, I don't want to go look for it, let's just fill out the
Yeah,
other form.
Yeah.
It needs to be more like, in the absence of them having one,
Yes.
there are forms available.
Yes.
And since we're really only dealing with those two, are we opening up a can of worms? Do we really need to be saying that much here?
Mhm.
I mean, it's the state legislature that passed the law, or the statute, whatever, that the water districts have to do it.
Why did we include it on the original addendum list?
I think because it was new and
It
we were
was
just
new and
like,
we didn't have the other.
Yeah.
at the time.
Exactly.
and at the
exactly.
time, there were a lot more PIDs that didn't have any paperwork.
Right. And I think we've come a long way since
I think
then.
we've-
Well, and when they give you that PID number, you're gonna go look for it, because if I looked at that form,
Mhm.
I was like, there's no way I know how to
Yeah,
fill this
yeah,
thing
the
out.
form
I
is
gotta go find
Yeah, I'm almost
the
circling
PID
back
form.
to just keeping this.
Yeah.
My mind has shifted a lot during this meeting.
I would like a printed copy during lunch so I could write on it and read it again.
See it all as
Well,
one.
maybe
I need to like
paper.
digest
is-
it during
it's-
lunch, yeah.
Okay. So what, I know I'm going to respect, Aaron Day has joined us again today. How long do you anticipate? 1 minute. 1 minute? So I would like to give him the opportunity, since he's taken the time to be here before we break for lunch, to talk. If that's okay with you, or if you're. That's great. Okay, and then we can maybe print this out and pick back up after lunch with this. So
Just call me snacking with some more.
We don't mind introducing yourself to everybody again, and
Yes, I'm Aaron Day. I'm the Vice President of Governmental Affairs for Texas Land Title Association. So appreciate y'all having me here today. We did submit comments. And also you took our request to look at how to treat the charges associated with the fence and expenses that are coming down the pipe. They're going to be implementing that in March. They had delayed implementation. Originally it was going to be in December. Now it's going to be in March. There are some lawsuits taking place, so we don't know what the ultimate result of that will be. If this rule will stand, things aren't looking good with the early decisions. But no matter what, the cavalry isn't coming before March. And so despite our congressional efforts and other efforts. So
and looking good, meaning that the rule will go forward. It's looking good to not stop it, right? That it will go into effect.
yeah, we want to stop the rule.
Right.
And the litigation does, but it's not looking good.
Okay, so I want to be clarified for everybody.
Yeah, absolutely. Not looking good in that,
It's coming.
yeah. So the court cases, it's up in the air, but the first decision was against challenging the rule.
This is nationwide.
Summary judgment.
This is nationwide.
This is nationwide. Just real quick, going over my minute, but real quick, the public policy, or the policy is all transactions that deal with a buyer that is buying in cash and using an entity. Okay, so and when that gets triggered, they want everybody that's around the transactions cascading responsibility, typically going to fall upon their title agent. Okay.
That's an LLC or
Or a
partnership,
trust.
not
Yes.
Joe and Sally Smith.
Correct.
Right.
Correct. And in trusts, yes, some trusts, some family planning trusts were excluded in the final rule. Okay. But the folks that are liable for it are pretty much everybody around the transaction ultimately, but the escrow officer is typically going to be picking up this responsibility, and there's a cost associated in it. So it's the track form wrestling with that. We still don't have clarity with the department about how exactly we're going to be able to recoup these costs. It's not title insurance. It's not an escrow function. It's never happened before. We're just deputized by the federal government to pay for a surveillance activity that they want, and they're not paying for it. They're just, so it's a deputy without compensation is the role. And so it's a brand new animal. We don't know really how to treat these costs, and we don't know how the market and the industry is going to respond to that. Some underwriters may help agents do it, technology may help streamline and impact these costs over time. We just don't know. They did promulgate a form that you're going to have to use online, and there's 105 cells in that form. Okay, so it's not the most user friendly, and we're afraid that we're going to face that if you're doing it online, that you're not allowed to go to the next cell and refresh that cell, and so.
Is just the buyer side that is being
No, they want the buyer and the seller's information. So if a trust is selling, and Brian, correct me if I'm wrong, but if the trust is selling something to that buyer, and there's an 8-year-old and the multifamily members in that trust, they want the social security number of that 8-year-old. So it is data that is not necessarily readily available. It's going to create some friction in the transaction.
I thought it had to do with money laundering on the buyer side. How would the seller selling something be applied?
The federal government, without editorializing too much, and saying that, don't look for real reasoning in the policy, but also it's total situational awareness. They want to know, they're trying, there are 3 pillars for this. The reason why they say they want to do this. Number 1 was Russian oligarchs. Russian oligarchs are buying homes in Des Moines, and we need to stop it. Not being a little sad, but that was their attitude. Across the nation, we have these sanctions on individuals and countries, and we want to know where all the money is going so we can make sure they don't buy homes, okay? Because they're on the bad guy list, or the bad naughty list, okay? The other reason for it is they say Russian, this illicit money is being used to drive up home prices. So the Russian is crowding out the home buyer, the first-time home buyer in America. And then, and they say that with a straight face. So we that are on the ground know that the economics of that aren't really the case. And then 3, they just they put it right in the middle of their talking points, but they say, and we're we're harmonizing with European money laundering standards. And that right there is the real answer. Remember how the truckers in Canada, they got all of their finances cut off. We are an international loophole for privacy and finance in America, because we have Fourth Amendments and First Amendments and things like that they don't have in Europe. In Europe, they have total situational awareness is what they call it. They know every penny that's being spent by whom. So if they need to cut someone out of the society, they can turn off their ability to spend. And so that's kind of where that structure is going. And this brings us closer to harmony with that structure. People at the Treasury Department, that's who they're hanging out with all day long, or these international systems of anti-money laundering, because this is all in the context of money laundering is the reason why they say they're doing this. Now it's resting on a 1970 statute, we'll see. But in the meantime, our recommendation and our request is that y'all did craft some language, and it was good language based on what we told you we thought would happen. Okay, we think, well, this is either going to be a third-party fee or it's going to end up in escrow. Well, as we've lived with it a little longer, it's not as clear how that charge is going to be assessed and where it's going to be assessed and how it's going to be categorized. That's the most important piece. How are you going to label it and categorize it vis-a-vis the TREC contract if it's limited and just speaking to 2 definitions or 2 descriptions
either escrow or third party, and there's this third animal out there, then we want to make sure that we don't have to come back here and you add another word, another noun to that laundry list. So that's why our suggestion is, instead of saying escrow agent or third party charges, that you just say any charges. And that way y'all aren't overly prescriptive and y'all don't have to come back and change the definition.
And that was what was in the recommendation that I read.
Yes, ma'am.
Got it.
I do have one question for you about the pay any escrow agent. Right now in the language that we have, so you replacement reference escrow agent with any charges. So we do have another thing. Sellers and buyers shall properly execute and deliver any statements, documents received or requested by escrow agent required for, and then we changed the second escrow agent up in your recommendation. My thought in question for the group later, and while you're here, is, does that first escrow agent need to be broader of who's requesting it?
Well, because it could be an attorney, right? A certain time, am I wrong?
Right, and so for our group, I was going to bring up is escrow agent in our contract can be an attorney. It doesn't have to be the title company. We already split that out. But I didn't know with how the rule will come down and in practice, do we need to be a little broader escrow agent or some extension, with how it would be done in practice that would need to be addressed?
We understand. Well, okay, so that's a good question, because let's say a third, and I'm thinking on the fly here.
Right.
But if a third party, without knowing your language and what all the definitions truly means, right? There is a world in which the requesting party, where the escrow officer, in fact, this may very well be the world where the escrow officer says, you're going to receive a phone call from XYZ compliance company, or, we do fencing, .com or whatever, right? And so give them that information, and is that the escrow officer asking for the information, or is that a third party?
Yeah, and in escrow, as we use it, escrow agent is most of the time the same as the title agency, not the company necessarily, but it could be the one and the same. So we use it broader than just an individual escrow officer to the entity, or it could be an individual too, but the entity. But to your point, you're hitting on where my concern is. In practice, if it's going to be done by a third party outside the actual escrow agent, then do we need to change that language up?
I would say, I think you've spotted a good issue there, because we don't want people to think, well, I'm only escrowing the contract to, Sally Joe at the title agent, right? That when I get this other third party that I need to talk to, that's working on behalf of, and will be reporting their information on behalf of the title escrow officer.
So I fear a lot of pushback with people with this type of request.
Right.
Give me your 8-year-old's social security number.
Right.
And then that's really, they're going to scrutinize our contract. I didn't agree to give this to this third party I didn't hear about before. Only gave it to the escrow agent.
Right, and who knows, and that may become a sticky reality later on when, fraudsters learn about this thing and everything, so, and jump in the middle of it, as we've seen in other transactions. But I'm just observing that possibility right now with this conversation. But yeah, I do think the bottom line is we want folks to have the heads up going into the transaction. They're going to have to render this information. They're going to have to give it to this person. And I would hate for it to be a stickler that person is this third party that is tooled to do this compliance on behalf of the escrow officer, and that's not a company.
Or they refuse to do it.
Right. On the basis that the contract says I only have to give it to Sally.
Yeah.
Right. Yeah.
And I wanted to give you the opportunity, since you're here before lunch, to do that. You're welcome to stay for later too, but we'll discuss this topic at length after lunch. And does anybody, for now, in case he doesn't stay, questions on his recommendation?
Is this a post-closing obligation? Pre-closing obligation. Okay.
Cannot close the deal
without the information ahead of time. Okay. All right.
The title company can't, right? The title company can't close it without.
They have the governmental responsibility to do it. And so they have to know that they're going to be able to file the report as soon as closing occurs. And so they have to have all the information gathered before closing, so that when closing occurs, they pull the trigger and do the report.
Just out of curiosity, since they are oligarchs and rich and crafty, that's the problem in theory. Why can't, I haven't read the statute or the federal rules on it. Why can't they just take their cash, maybe not even go to a lawyer, or go to a lawyer, just write a deed? It's a cash deal anyways, and just transfer it and skip this whole process.
Oh, they will.
I mean, like, if you're the cartel, like,
It's not
oh,
about
wow, they got all these laws. Let's just skip the entire title company. Let me just give you a cashier's check. I got a lawyer, he wrote a deed. We're good. Like, why?
Yeah, now,
Like,
the lawyers are on the hook though to report, but
Okay.
then again, it's only as much, they're in the basket. The lawyers, it's not just the title company, it's the lawyers are, and even arguably realtors.
Okay.
So there's a joint and several liability of everybody around the transaction. But kind of to your point, like, fraud like water or what obfuscation, I mean, they're gonna find a way about this. And this is why, and again, it's just my editorializing, it's not really about, because they keep changing. When this first started, it was about the cartels. Then Russian oligarchs became sexy, it became about them. Now Russian oligarchs aren't as sexy, so it's back to about being cartels. Meanwhile, there's this European structure, and we seem to be replicating it and building it based upon the European structure.
It was something you said just concerned me, that joint and several liability. Is there if there is a clear settlement agent in the transaction, am I using the right term, settlement agent? The settlement title company in our case, let's get the boots on the ground. Does that then focus liability because they're handling it? Or this joint and several of, we're all in the ambit, so if that title company screws up, all of us have potential liability as the attorney that looked at the deal for the buyer, the agent that represented them. We are all relying upon that title company.
The attorney that wrote the deed is specifically on the hook. Yes, and they contemplate multi-party agreements.
Well, wrote the deed, so I'm getting into minutia here, being a lawyer. I didn't write the deed. I was hired to review this contract.
I don't think it reaches you as a contract reviewer. I think you need to be a little closer, because they talk about the lawyer drafting the deed. But I don't know if you're that, you may be a little bit farther.
Okay, and then so let's go to the broker agent example then next. And I know none of this is absolute, but as much information as we can get. The broker agent isn't doing that either, right? And so we say they're in the ambit, but if they step in to provide this, or I'm going to help you close this and take on that role, then they're exposed, or just by being.
I'd have to look at the rule. There's an area they call it cascading responsibility, and they describe what activities get you in the bucket. And so I would just advise everybody to review that and make sure that your practice.
Don't get in the bucket.
Yeah, don't get in the bucket. Christy, don't get the 8-year-old.
Don't get in the bucket.
So from the title company, is this going to be a condition on Schedule C that has to be cleared? I mean, is that how where is it going to? I'm just thinking as an agent to say, well, you can't close until you do it. And it says so right here on Schedule C.
Schedule C is really the requirements of the title company for issuing a title policy. But in practice, a lot of times title companies use that as a place to give notice to parties that before we're going to close the deal, we need to get this information.
It's their other.
The other.
So I don't know that it's necessarily going to be every title company's going to do that, but I wouldn't be surprised that you'll see some title companies have that.
Put it on C.
How's the timing going to work? Cash transactions historically are an incentive to be short, a short fuse. This doesn't sound like it could be necessarily short. Information may be provided, but who does the checking? Does the escrow agent have to do the checking?
Well, it's the third, probably, well, yes. I mean, ultimately, yes.
And that's something that we've certainly been thinking about at our company. And, is we have a portal online for people to fill out information. And as soon as we open a contract, boom, that invitation to fill out the information in the portal is going to be there, so that it's not a last minute thing. But you bring up a really interesting situation of what if you have a cash buyer, an individual, and the day before closing, they say, we're going to sign the contract into our LLC and have the LLC be the buyer, and all of a sudden, hair on fire.
Oh,
We
wow.
didn't get any of that information before because we had an individual buyer, but now the buyer's an LLC.
Well, what if it switches? What if you have an LLC and it switches to an individual? Are they gonna say, oh, then now you're out of the parameters?
Yes.
Yes.
Oh my God, this rule's a joke.
So the cascade, this is just from a internet source, but if the internet source is to be believed, which we will check, it's cascading if we have tier one. And if there's tier one, that's who's responsible. If there's no person, in the absence of a person executing these functions in tier one, then you move to tier two. And these are those that they look at. And in the absence of anybody in tier one or tier two, then we look at tier three.
Yes.
And there's going down to 5 on here. So 5 tiers.
So study that and apply to, see if you're in the bucket.
But by and large, the people in this room, it's gonna be the top tier settlements.
Right.
Yeah,
Correct.
the agents who are going to have to notify the parties somehow with what accurate information that buyer, you are a cash. How's that?
No, then I'm in the bucket.
No, we're gonna put this
Then I'm in the
contract.
bucket.
It's gonna be the contract, and then it's gonna be on Brian down there to get this right.
We aren't gonna do it.
I would
'cause then we're
advise
in
you
the
to stay
bucket.
out of it.
No,
It's gonna
but
be an
we're going to
obligation,
have to
but it's,
alert our clients that they run the risk of a slowdown because of this. We're not
Oh,
out
yeah.
of this.
Our
We're the front
producers.
guy who's going to have to explain, this is the way it's working now.
Well, and think about it from the seller perspective too. If you're looking at multiple contracts, if one's going into an entity, then I know there may be a delay there, so maybe I want to go with another.
I'm smelling a Texas.
So it's as
Notice
simple as-
form that tells you what this whole.
If it's an LLC or an individual, this might be the steps.
If it's an LLC.
Right, that's what I'm saying. The difference, if I
Yeah,
have
that's the
two
difference.
offers
Yeah,
there,
those are the two.
this is an LLC and this is, okay, this might be the steps.
Yeah, you may run into a decision, yeah.
And one thing to keep in mind too, or later we'll get into more of this at your lunch, but there's websites out there that have good videos explaining it. There's, Brian's been great to send information in between meetings, and he included some in our materials here. So there will be, I look at this kind of like Senate Bill 1968. Nobody really paid attention to it. Now it's law and everybody's starting to pay attention. When this, I think we'll have those resources people focus on, and even internally that we're further removed from this, but there is stuff out there that will help that discussion, I think, for the fiduciary.
Is this law right now?
Well, it's rule right now, and they're enforcing it March 1. Yes.
Huh?
There is a rule right now. It's a
March
rule
1?
right now, March 1.
Good, I'm closing a house this
And
month.
Aaron, for the flow of the money from the
Yeah.
contract here, when are the fees being collected by the title company
At closing.
at closing?
Yeah.
Different
So
categories.
have y'all incurred cost as a title company prior to closing on this? Or,
It would have, yeah.
Well, yeah.
so if the deal falls apart at the last minute,
Right.
it's the title company just eats that?
We do title commission.
Yeah,
We don't collect.
Yeah, that's
Unless
a.
the deal closes.
Okay.
One thing. to keep in
Any
mind-
idea about the range of the money in a typical residential deal?
According to the CFPB, they say it's gonna cost $500 a transaction.
Okay.
Now, that's according to the government. We think it's gonna be less. We're hoping it'll be much less.
Okay.
The local firm that printed $75 on a flyer already.
Well, this almost need to be required, and just put our minds over lunch, something like for the HOA, paying the HOA outside directly via direct charge, so you're not having to wait till closing to collect it. Let's say the title company who's incurring the money, or if you're using third-party vendors, pay the third-party vendor.
That would be a possibility, but I think the market is going to, would control that from.
Because right now we have it as a buyer's expense.
But my fear is to get ahead of it, you can't wait until closing. So especially if third parties are being used, they're incurring the expense as the escrow agent. And then, but like for the HOA information, you're having to pay for that up front, right? And get a link.
Correct.
And so if this report has to be obtained early on of some language or thinking about the process of allowing title companies to collect that up front, to build it in, to make that process simple, so they don't get burned on what is a significant expense.
It does have to be obtained, but it is not technically part of closing the transaction under the title insurance rules.
So I
One
think
thing
it is
that y'all
still
want to keep in mind when Aaron said March 1, that's for any closings on or after March 1. So you're going to be entering into contracts
Good point.
Yeah.
in February
Right.
that are going to close after March 1.
Very good point.
And people need to be aware of it sooner. The information gathering is going to be happening and starting before March 1.
So in instances where we're just now talking about adding this language in, how is cost going to be allotted on those that are on contracts that don't have that pre-laid out?
It'll have to, during the interim, it'll have to be negotiated by the parties.
Okay, so we'll get a preview during lunch. Anything else before we break for lunch?
No, just appreciate the consideration and thanks for listening.
Thank you. Appreciate you. Yeah, thank you.
Have a good lunch.
Okay, we'll break for lunch and we want to come back at yeah, well, yeah.
Whatever.
35. Okay, we'll come back at 1 o'clock. 1 o'clock. Okay, it is call back to order at 1:02. We ended with Aaron Day's presentation that we'll circle back to, but I think we were at paragraph 22B still, if you don't remind me where we broke to.
So we were at 22B. Let me just share here real quick, and then I'll probably refresh everybody's memory. Okay, so here's what we did where we were as far as that. We were going to have change paragraph 22 to read agreement between the parties. And then we had an A with these listings, but we were in the process of eliminating the B and going just with an A because the B was going to be this, the required notices. So I think if we go the route we had finally drafted here, then we would just basically move this up into the same paragraph right here. And then this would all flow underneath.
And can you go to the language about the districts in that draft?
I'm not sure mud is the right term here to use, but.
We left that in there last time because it was a commonly used term, I believe, but it's doesn't mean we have to stick with it.
Well, we could do this like I had done in one way.
Instead of municipal, local. Sometimes they're called local districts or special purpose.
I'm not sure we would need that afterwards. I'll leave that to the broker.
Don't even say municipal, the following utility, water, grid, and other.
How brokers on MUD, the use of the term MUD, is that a term of art that you use, or would you understand if we left MUD out and just have municipal utility on the water, ... We had left in MUD in our prior versions because of the general use of that term, even though it doesn't really, it's not MUD notices. We just have it left in there because of the general understanding.
And I wouldn't use the word municipal because you can have a county. It's a local government district.
And some of ours are special utility districts.
I just leave it just follow utility, water, drainage.
I don't think we need the word mud.
Okay.
Since we have two in particular that are top of mind, I can throw us out there without having thought it all the way through. We've changed it now where we don't have it, for example, that we had before. So it leaves open the opportunity still to have a for example, if we wanted to put the notice to purchaser in the PID notice listed there.
Well, you had this here. You had, for example.
which we've taken out now in the draft that we have. So it gives us that opportunity to, since we've listed that what's in the for example in a different way, we can then utilize that same procedure or setup to then list out the two notices that we think will always be listed there, or should be listed there if they're applicable.
So going back at this if we leave it like this and don't put a B, then we have that entire new addenda section for paragraph 22. And then it makes them attach the PID, water, med, anything that they have by checking that box and then writing in what they've included.
Correct.
And if they have used, by chance, in the absence of a PID provided by the district, they can use ours, and then that's where they would write in the name of our addendum if need be.
So you want to put our addendum here?
No, I don't know. I don't think our addendum needs to be up there. I think it complicates it.
Not even the PID one?
I think thinking through this and seeing it now, does that complicate us having a checkbox here and then having the name of ours on there? I don't know.
You say ours, are you referring?
The Trek,
Addendum 59.
the optional Trek one. I don't
For the
remember the
water.
number of it. For the, either the water or the PID. I think either one of them.
Well, I don't know how much the water district, and Abby can go correct us if we're wrong here, but the water aspect of it was the legislature said, water districts, you need to have it. Did they also do that to the public improvement districts, or is our form needed there for that?
Well, they're both of those are voluntary use forms. So, and the statute the statute outlines the requirements for the notice. I think it's the same in both.
There's an exception to if the district does not have the notice available now within, I believe, the PID notice section. That if they don't have it available, then there's something
Yeah.
there. I'm not remembering the exact name off the top of my head. So there is some protection that wasn't there before. They changed the deadlines up for the termination right deadline in the new statute. Excuse me.
Does the statute also talk about SUDs and WCID and all of these other places, or is it specific to municipal utility districts and public improvement
The
districts?
water code definition of what qualifies for a district that requires the notice to be provided is one of the most convoluted, poorly written things
Yeah, I
I've
know.
ever seen. It has it can form under the local government code or under the water code.
Right, which is
And-
why our form says the stuff that it says,
And
right?
then it goes into, if you dive in further, if it's this much within this county and, this percentage over here. And I mean, there's so many different bunny trails from this definition
Mhm.
that in speaking with Brian Sledge and others, they were real focused on this other water language. I was focused on this mud. How do we clarify this
Mhm.
very important thing? And in dealing with that, and realize even those that are in the know don't, have a complete grasp of
Mhm.
what's out there and what's not out there, and where there's no one location to go find what's a district that's within that definition.
Mhm.
There's some good sources, right? The Water District Viewer, the different sources, but none of them can say this is absolutely complete.
Right.
And that if it's not right here, then you don't have to provide it. That'd be great if it had that language.
Mhm.
But we don't have that. So as far as what PID's its own thing, but what qualifies for the water district notice requirements, very broad. You can't, but it would include all those things that you,
Yeah.
clearly what you said.
So on that bottom sentence that says seller's failure to provide applicable statutory notices may provide buyer with remedies or rights to terminate. Because we're gonna be asking them to attach it here, even though that's not technically required, right? Should it say seller's failure to provide applicable statutory notices?
Is it talking about the information in the notices or the actual notice? I see your point.
So there's a prescribed form, right? It doesn't have to be, you can change the title, I think, up or something, but it has to be the notice and have the language of the notice. And it's not our notice, it's not necessarily the water district notice, but it has to have what's required by statute.
The information. Okay.
And if I don't provide the lead-based paint disclosure, do I have rights to terminate the contract? I guess because it says they may provide.
So does that bolded sentence apply to everything above?
Yeah,
or
that's
just
kind of
this
where,
section?
yeah.
Because originally it was a larger paragraph that was kind of freestanding, speaking to things above it. This does make it look like it's only talking about, and
All of
maybe it
those
is, statutory disclosures and notices.
Do we need to specify which statutory notices?
Now, they do. Now, we then look at the propane or at least under the C word, the coastal area, those aren't provided. There's termination rights in those statutes.
Yes, they are.
We don't talk about those, but they're built in if you go to the language
Right.
in paragraph 6. There's cites to those statutes, and those statutes do have termination rights.
So it does apply to every single one of those.
It only
Yes.
goes 1, 2,
So
3,
I think
4,
they're asking,
5.
is that bold just for the statutory
Right.
disclosure, or is it for everything above, everything in?
Statutory
Section.
disclosures.
I believe that's going to be everything. I'm going to check the certified, the propane one, the certified area.
Because didn't you have this as a part of the required notice?
Yeah,
and
so
that
what
was
we should
lifted
do to
from
make
it?
that clear
Shortened?
is if we title this the same as that category. That
There
might,
you go.
and then I think that you can just stop here. Because there are some remedies or rights to terminate this contract. Is the contract capitalized now? Is that what we're doing?
Don't think so.
Okay. I can't remember what we decided before.
Yeah, I don't think so.
Okay.
I think the propane gas one, maybe you have to provide it, but it may be a section that doesn't say there's an absolute termination right
Yeah.
attached to it, but it has to be provided in well, what's the remedy if not, but our language there is broad enough to say remedies or rights to terminate, gets the point across, it's required.
And then here, do you want to do like we do this notice thing that we've done before on the other forms? Is that how we do it?
I think that, not speaking with council.
On your material, suggested revisions to include paragraph 22 under addenda required notices had all that wording and this line, and it was for everything above it, so just double checking.
So if we go through what's in 6 to make sure what we're leaving out, that's an actual notice and not something just built into the contract itself. Abstract or title policy, 6E1, that statute only says you have to include this language somewhere satisfied by our contractual language itself.
Mm-hmm.
The POA, same way, that language in the contract satisfies the POA, except at Farm and Ranch. Statutory tax districts we have on this list. Tidewaters we have on this list. Annexation is what's in the contract itself. Certified service area, that's the propane. No, that's separate. That's
No, that's-
Are you commenting what above that, the notice line applies to?
yes, yeah.
Am I looking at that with no space between those lines and notice? That's a unit. That tells me that everything above under statutory disclosures and notices is what that notice applies to. If you're saying everything in the addenda, paragraph 22, that's an alert, a notice, then it should be further down and to the left.
I see what you're, it's the, former, your first, so this is only applying to this subsection.
This little section there with 5 forms, okay. That's what it
And I'm
is.
checking to
My
make sure we
question
didn't
was-
leave anything in 6 that might be another form that's in there. I don't think we did. I'm just double
The
checking.
mold remediation. Is there a form?
So the mold remediation, there's not a form that we have. There's the certificate there. I believe there's one prescribed. I have to look at whether it's promulgated or prescribed by statute.
But it just says must provide.
Right, there's no
form.
There's no form and there's no remedy directly in the statute for
Okay, all right.
if you don't provide. That's one of the struggles with that one.
Okay.
You have to give them within the last 5 years. Doesn't say what if you don't have possession of them, doesn't say what you can do if you don't.
But I think that's it.
I'm back.
Ed, you got propane? Water fluctuations, nothing? Mold.
Does that sentence in the PID paragraph, that last one, addendum containing the required notice shall be attached to this contract? You take it out.
On that page.
Since
On paragraph 6.
under
E7.
6, yeah, 6E6.
What?
E7.
Is it 6?
Yes, I think that probably, I'm gonna go back to the statute just now.
Oh, because I'm looking at,
It has the language on.
yeah.
6.6 covers the mud.
Yeah, I don't think we have a consistent way on how we do these bold notices. We say important notice in one case, and then others, we just say it. We don't use the word
Right.
notice. So,
6.6 just says water in the word.
so it doesn't matter if you want to include this word notice here or not.
So for to answer the question, it was real quick for the PID in particular. Says this notice provided required by this section, PID notice section, shall be given to the prospective purchaser before the execution of a binding contract for purchase and sale, either separately or as an addendum or paragraph of a purchase contract. So I think with our new language, probably Abby's right, we're pointing out, I think we can remove that since it's covered down below from paragraph 6.
Oh, you want to move? Okay.
So in paragraph 6, there's a line that says, and that's at the end of 6E7, it's 1-4. Public improvement districts, if it's in there, you have to notice, and then the last sentence, an addendum must be given. An addendum containing the required notice shall be attached to this contract. And so we don't say that for the other.
So just take it out of 22 altogether, you're saying?
Not altogether, but that last sentence there, since we have it, this language down below, it's just, do we have to? No, but it avoids the duplication we're trying to.
So on 7, where it talks about public improvement districts, the last sentence on that one says an addendum containing the required notice shall be attached to this contract. If we're now requiring it, we can delete that as well, yeah. So, yeah, 9 as well.
Attached.
So the last sentence of 7 and 9 in the 1-4 family.
Yeah.
In the corresponding sections in the.
It's in 6 also, buyer acknowledges receipt of the foregoing notice at or before the execution of the binding contract for the utility
Under
service.
utility service.
Yeah, I see here.
I believe that notice is itself the.
That's
they're
part of the
receipt-
notice.
Yeah, exactly. I'll go pull up the water code real quick, but I believe that.
That's part of that 13.257.
I don't have my document with me. I went through each one
I
of those.
feel like you're
labeled
right.
it.
I feel like the last, it's very long, but the last 3 lines of 6. Of 6E6. It's in 4 too. Why did we just keep writing that?
So 64, 7, and 9 is what we have right now.
And
6, we're trying to decide if that's part of the action.
4, 6, 7, and 9.
Now 6 is a little different, right?
6 is, yeah, a little different.
The other 3 referred to an addendum.
Is 6 itself the actual notice in there?
It
They're
is, yeah,
saying
I'm
that
reading
they
it here.
are,
It's the
this
actual
is their
notice.
notice
Yeah.
and they're saying that they've gotten this,
Yeah.
that they're already acknowledging that notice.
Because this
Yeah.
is the
This is the
notice
notice.
That's
in the
notice, and it's
paragraph.
exactly
Yeah,
what,
so-
yeah.
Yeah.
It's what popped up.
So we won't need to
Interesting
do
that
that.
they have it written that way.
Yeah, I think that one's fine. You have a comment on what we're, Becca?
Oh, I'm sorry. Okay. So a rabbit hole, kind of like what you guys were on the notices. So without pulling up every single statute and like reading it, but for an example, like 7 for improvement district, if you pull it up, it says, person who performs or otherwise convey real property that's located in a public improvement district, like has to give written notice. And then for like the water code, if you're reading it, it does say it's a notice or an addendum to the contract. Like, so some statutories will say it needs to be a notice, and some say it needs to be, or it could be either one, an addendum or a notice. So like 7 did say an addendum shall be attached, but the statute says it only needs to give a notice, not an addendum. Whereas the water code chapter 49 and 3 says it can be a notice or an addendum, but our current contract for 3 for statutory districts doesn't say anything at all under 3.
I think that highlights a good change to take it out, and this new language that we have will encompass it being done either way as the, and for attaching to the contract would be the notice itself too, so that would be providing.
So if
the
you
notice to-
check under paragraph 22, and sometimes just mistakes happens, you check it that certain things are supposed to be attached, it gets missed as an attachment. Does that mean that your executed contract is not fully executed because that district, that addendum that we're saying needs to be attached is not attached? And so if you're missing one of them, because it says that this is the entire agreement with all of the addendum attached, and if you read some of like how it's written with like the property code or the water code, some of them don't say that it's an addendum. It's just a notice to be given, like seller just is providing this notice. It doesn't mean that the buyer the buyer's not agreeing to it. You're just telling them where you're at, it's a notice.
On the legal side, I think my first thought on that is to have a contract that things are missing, right? Check, not attached. If you had the core material terms there, and that being a notice, I don't think a court would analyze that and say you don't have an effective contract just because this notice is left off. And then it would become an issue of, well, did you provide the notice up front? And if not, what rights arose from that? So the court will still enforce the contract, and you would have to look at for the mud notice. If you don't provide that and add it for the time of executing, you have a right all the way through closing to terminate. The buyer does. And so then you would be stuck having to prove elsewhere, no, I did provide it. I gave it to them in advance this other way to try to cut off that right, because the statute does allow them to provide it outside the contract in that one. So I think if it's checked and inadvertently left off, the risk of issues arising from that would be fairly minimal or boxed in, hopefully. But it's good to remove that language you pointed out, because we're not saying you have to attach it.
Yeah.
Over here, we're saying it's a notice, and we're wanting them to.
Yeah.
And in one spot, you should attach it, but
Certain
it's.
notices, like different things, like, just in a recent class, I know like on the Texas Realtor Sellers Disclosure, it's got like, buyer and seller initial on every page and you sign, and even the Trek one just has the signature, like, and I've been taught, the buyer doesn't have to sign it. Like, as long as you've given the notice, the buyer doesn't have to sign. They're not agreeing to these things unless that's.
The statute for the water code does require a buyer's signature, to be effective notice by the seller to cut off that right to a separate issue. But that one in particular has the buyers required to sign.
yes.
This is kind of what happens down the line. Some of the other ones don't have, it's just a seller.
Yeah, because they're all, if you pick them all apart, they're not all consistently like have the same buyer and seller have to sign, or one says it's notice, one says it's a notice or an addendum. And so I was just.
Yeah. I think that fits in. I think everybody's following on that. So
Yeah.
what do we, language there? Can we make a note to, something about corresponding contracts? I know in our farm and ranch, it's a little different numbering, I believe. Let's see.
For D up there to just make sure that we get it in the right ones for the corresponding ones.
Correct, exactly.
Yeah, because they're not the same actual paragraphs or subparagraphs.
It catches me when I'm teaching it, when like title objections, it's let's say C instead of D, and condo or whatever that might be.
So we have just minor differences in the use of must, shall, and should in those 3 paragraphs. So that's just a little note that I made there.
Yeah.
So you're asking now,
To just
John.
put on there this and the corresponding paragraphs in the other contracts, because they're not exactly the
Right.
same. It's not always going to be 6479.
It's actually 6G in the farm and ranch.
Okay.
And then they go off a little bit on the numbering as well.
Okay.
I think that would be sufficient for what we're trying to accomplish, what you're putting in the notes there.
Okay.
Yeah. I can put Nota Bene.
He's never gonna be able to leave this committee.
He doesn't want to.
We just determined.
Keep trying to get rid of me.
9 and 24, but we can get in the public number, so 36.
That's right.
So,
Let me go back to the other.
so up here is what we have here.
Correct. We just have it all within that one subsection. Yeah. Got a skeptic here. Let's look at the language.
Okay, so we got.
So did you want to change because of the word addenda here? That was one that conversation we had earlier. So did you want to say addenda and other information, or addenda and disclosures, which are, or addenda notices?
The category that is not a technical addenda
Those are just,
would be that one paragraph we had that we said.
Statutory disclosure.
notices.
Well, I think that's why we were originally going to put it in B.
It's
and
just,
make a separate one.
I mean, what you can do here is you can just say addenda and notices.
Mhm.
Brokers, does that invite people to write in seller's disclosure notice or something where they shouldn't in other?
Under the, well, the only place to write other that we have in the
Is
whole
under
thing is under statutory.
Oh, yeah.
Oh, we do need another,
Yeah.
another.
Other, right?
Uh-huh.
Okay.
That's a good catch.
Other with other.
Or maybe that's just a,
Did I just not bring it up? I thought I had,
It might have been on that other
Yeah,
document where
we
you
had
were copying from.
We had
Yeah.
another. We still
Yeah.
had some stuff in other. I thought.
Did we get everything from the,
Yeah, we hadn't. So we still had an
oh,
other.
we had the
category.
non-realty eyes addendum and the backup
Yes.
contract
And then there's our other.
and our other. But did we move?
Other, under, other.
oh, we didn't read like mineral preservation, I don't think.
Yeah, that's right. So what happened to that one?
yeah, we had
I wonder
the,
if I deleted all that accidentally here.
on the email that John sent you, We had financing and payment terms, leases, associations and minerals. We've moved around property conditions, disclosures and notices, taxing districts, other, and then we had a thing that said not included.
Those were the ones that weren't listed on the list that we weren't recommending.
Mm-hmm. But under the other section before, it was the non-realty items addendum and the addendum for backup contract.
Yeah. So we need the POA addendum and the mineral rights, mineral reservation.
This is why I was like, I just need to look at a printed copy. Okay.
And then we had, I think we also had the PID there listed, but I think, are we eliminating that one now?
I think so.
Mhm.
Yes.
Okay.
And then take out that not needed in farm and ranch.
Because we had, let me look, make sure.
Should say really needed.
Notice to purchase special taxing.
Needed.
I have notice to purchase of special taxing in a assessment district.
We're leaving
Which
that one
is
on
the
too.
mud notice.
Leaving that off too? Yeah.
And that one wasn't in there.
Okay, that's it. Okay. So we still need to say, we don't need to see F&R discussion below, do we?
No.
Okay. Okay. Is there any particular order you want for these?
Brokers. Let's say the POA.
Should have 22 total documents
You
plus
want
the order.
POA first?
I put backup first, because backup is sort of,
We use the
PO is more
The A-
prominent
yeah,
in the
goes to
backup.
very
POA
effective
one first.
contract. It's check.
Which way you like it?
I'm staying out of this one.
I do think we do use the backup contract a lot, but we also, I'd say POA does get used more often than backup.
And you have a thought on that?
And
Or
then
about the order?
non-realty and then minerals.
Yeah, I agree with you there. So if you like it based on use in the preference, then I think we need to switch the,
Well, that's kind of how we did the rest of them. Like under financing, we started with third-party financing as first. So it's not like they're alphabetical or something inside of each category.
Right.
They're really more based on use.
I'd say non-realty gets used a little bit more than minerals.
it probably gets used more than backup too.
I would say so too, yes. That is beautiful.
Makes me cry, doesn't
Yeah.
it? Or,
Are we leaving those words in there under the POA that says not needed? in
that's just,
contract?
that's just for them, just for us.
Just making sure that was for.
Something bad just happened up
Association.
there.
No, don't need a,
Something weird.
don't need a box there.
Yeah, put a box.
We created an
second box
addendum we
down
don't
is
have.
weird.
Oh, yeah. Okay. I think I did that. All
And
right.
just to double check a thought I had, so with the formatting changes, if we send this up to the commission for approval now, we can still come back later and monkey with the formatting. Is the, okay.
We get to monkey around.
Yes.
Get our little scissors out.
They're gonna wish they'd been on our subcommittee. Just kidding.
I'll tell you about the red deck story another time. I claim red deck on formatting and changes and.
How
I
many
painted a big old deck
documents do we
for
have in there,
Took a long
Ron, in the
time.
whole
Hot
list?
summer.
Oh, gosh, I don't know, a bunch.
We used, there should be 22, I think. Plus other.
We can check.
I just want to make sure we didn't miss any of them as we were monkeying around, so to speak.
Let's pull up that other list.
We get more than
I think-
22?
Well, no, with the others we do, but not.
Okay. I just don't want to have less than. I don't want to have missed one.
This just feels good.
Yeah, and well,
It feels
and while we're here, what about this new water form that we're gonna talk about later today? Is that gonna need its own little spot and its own little check mark?
Yeah.
Oh, yeah.
Well, we do have, that triggers is separate now in,
Is that going forward? Do we know?
We don't know yet,
Looking
but we don't know yet.
we could probably include it though.
We can, yeah, I think we go to address it now. We have some substantial revisions to discuss, potential revisions on that one.
You're just what tomorrow.
Yeah.
Could it go under other right now if we don't know, if we don't have it?
Maybe as a placeholder that can be removed if we decided to pull it.
Well, is it gonna
Is
have to
it
go
not
under the statutory?
Yeah, is it not a statutory?
It's not
Ground-
statutory,
groundwater
so that one,
notice.
that one
Okay, so it
failed,
would-
yeah.
okay.
There was one that would require at least some more disclosures.
So it's
and
not
that one-
statutory.
It's just contractual.
Okay.
Because, let's see here. Yeah, so I'm not sure. The trigger for it is pretty much the same as the seller's disclosure notice. So I'm not sure that we would include it in here.
So it would be.
Yeah, that's a good point.
Yeah,
It says
it-
other.
Yeah, because, it's like the,
So if it's like the seller's disclosure and has some of the same language, it shouldn't be included if we're not
Right.
including the
So
seller's
that's what's
disclosure.
so you got, I got the notice, you're gonna give me the notice, or you don't have to give me the
I
notice.
see what you're saying.
Yeah.
Yeah, so it wouldn't
makes
be
sense.
in there.
Yeah.
Okay. Does everybody understand that logic?
Until we forget next time.
Yeah, okay. Good job on that.
Yeah.
21 and 22 then.
Let's go home.
We got a lot more to go.
Working backward.
Yeah, just
All right.
finished all the stuff we did in our subcommittee.
So, yeah, we're still got one more big point in our subcommittee.
Yeah.
This was the backup subcommittee meeting. So the next thing we did, everybody good? Move on? Okay.
Yeah.
Yeah.
Next one we have is the actual backup addendum. And with that, let me get my notes. We were looking at mainly the language about receipts and where we can stick receipts for the additional earnest and additional option money. There were a couple other issues as well. We looked at a capitalization option fee was one in the underlying contract. And Diane, I know you had some additional comments on this. I didn't get fully digested. Do you want to tee the receipt side up, or you want me to run with the?
You can just run with it. I can't remember what that comment was. I think it came in late.
So the options here, tee up the options first, is right now in the contract itself, we do not have an additional option fee receipt. There's only an additional earnest money receipt. And we have an additional earnest money because the contract itself, it contains a provision for additional earnest money, right? You can pay so much now and owe additional earnest money later. We never had an additional option fee outside the amendment. The amendment provides not only a place to receipt it in effect by the language, but the ability to make an agreement for an extended option period. And it contains the language that protects the parties for this other consideration provided, and then make sure that the has paid language means that consideration has been paid to support that option. Yeah, we'll go back and forth. And so we looked at, okay, do we stick it in the contract? Or do we stick new receipts on the back of the backup addendum? And how is it used in practice? What's going to make the most sense without confusion? One of the things that we suggested is that if we put it all on the backup contract addendum, have one for the additional earnest money and additional option money, it would keep it housed in one place, right? So they could pick up the backup contract addendum and receipt those specific items that are unique to the backup one right there. And that there would need to be some documentation of having the additional option fee that's not confusing the overall contract. Introducing the concept of this additional option fee to put ideas in consumers' heads or agents' heads that I can figure out to make the additional option fee there. If we did that in the backup addendum, we would want to do some parentheticals beneath the title. So right now, under the contract, go down to the bottom, I think it's the additional one. So under the additional earnest money, we could put a parenthetical, not for use to receive for the backup addendum. And we have language for that. And likewise, if we had the backup addendum, we could put a parenthetical under the title of the additional option fee and the additional earnest money if it's not meant for this other use, to keep it consistent. Another thought is, well, why look in two places for receipts? Why not just keep it in the contract? Why not keep it in one spot and add the additional option fee receipt in there, not worry about putting ideas in people's heads, and maybe add some language and parenthetical underneath that. Another thought that is, well, the amendment has this language about the additional, making a new option, extending the option. Can that be moved into somewhere else out of the amendment itself? And we didn't think that went through or developed that enough, but that's on the table for discussing today. And so it's an option to look at that. At the end of our initial working group, we thought that maybe the having it on the backup contract addendum itself would make the most sense. And we weren't strong on thinking this for the contract, but it would make the most sense of one document to go look for that money tied just to the backup. I know we've had other thoughts in prior discussions on that being not the case, but I first leave it up to brokers on that because we can, on the legal side, draft it however we want. In practice, how would that work for you? How would you like to see it? What would be the least confusing in terms of where to receipt it? And then same with title, what would title want to see? Is title looking at it any different?
Having one receipt page helps, but I also understand just receipting the backup. I don't know.
And it gets receipted at a different time.
Right.
Right? So when you're first going under contract, you're completing the receipt page on the 1-4 family, right? We've got the contract in, we've got some level of earnest money and option fee. And at some point in the future, if you become primary position, now there's more money. So it's not at the same time. I do like the idea of it being on one form, so it is all in one place. It's just, it is at a separate time. So it would make sense that if we wanted to go the other direction, we certainly could. Because you're getting that form out and going, okay, yeah, we gotta, I don't know though. I feel like if I was a title company, I'd want it all in one spot.
That's what I'm thinking.
And the timing thing too is cut a little bit by the sense that a lot of times the contracts are received without the earnest money. And so they're coming back to revisit it later in time.
Right.
Process anyways.
Right.
Title company doesn't matter because we're going to be receiving that money and immediately depositing it. That's going to be the key thing. The thing that I think it should go in the addendum, and here's why. Paragraph H provides for the seller to give notice to the buyer that they have become the primary contract, and that becomes the amended effective date. And I think we should have something at the end of this addendum. Yeah, seller hereby notifies the first contract has terminated.
It makes sense.
And and this contract is now the primary contract. The amended effective date is blank. Have the seller sign that and then put the receipts down below that.
Now, we do have a form to propose to that's separate that we've drafted and have ready to review that does just that. It's the TX, what's right now in use, the 1913 form with modified language. It uses our defined terms and uses our contractual language.
Put it all in the addendum for backup.
And we didn't have that idea popping in our heads during our meeting, but that's essentially doing something along this line.
Might that be where,
Yeah,
at the bottom, where
think
that on.
You put it on this that you created.
Do you want to put that on this? I sent that to you.
Yeah. Make sure I got it open here.
I think that's a fabulous idea.
Which one?
It's a new proposed form.
A new proposed form.
A
A new form. Well,
Texas Realtors provides that to their members. It's a form that is similar to what
Show it.
many real estate professionals are doing.
but that makes great sense to have the receipt on that because they wouldn't, until they have notice of the first one terminating and then they have the amended effective date, the receipt going on that triggers them to go do additional.
You gotta go pay the earnest money on the auction.
And then
So this is what, this is very similar to
Right, that's what we're
the
talking
existing
about.
trade association form, but it uses defined, this uses defined
Going into
terms
primary position,
and changes a few
people
other
would
things.
prefer more option and earnest money at that time.
Oh.
Because when you first go into backup, you might put a small.
that is so
'Cause you may never
simplistic
become
and
primary,
amazing.
right? If you put a $5 option. I want more when you become primary.
So we're thinking add the
The
receipt.
receipts on the
to
bottom of
this.
it.
Have this and the receipt. Back of it.
In real practice at the title company, I seldom see that the monies are really receipted on that page of the contract and sent back. Is that your experience? The title companies have their own document for receipt of
I
the
think,
contract and the funds.
Signed form that was provided.
and I think this is a great way for the title company to get notified, one, that the other contract's moving into place. Receipt, they don't have to go look up the old contract, pull that out, then make another copy of a receipt in the other contract. I think the simplicity of this, and it also is a great reminder, not that an agent shouldn't be on top of things, but the buyer's agent whose buyer's going into first position reminds them that there's a trigger
You gotta
on
pay some more money.
get that money in, if they have that
That's a
in
good
it.
point, yeah.
Mhm.
We have plenty of room on the back. This is the second page of the backup. We have all this room to work with as we pull it over.
Do we- And I'm swinging back and forth. This is a part of the original backup addendum is part of the contract.
Yes.
Mhm.
It's there. This is a post-contract document.
Right.
And so it might make sense to make it a separate document. Have this document with the receipts attached to it.
To make page 3 and have this and the receipts behind it. Where we're not doing the whole separate addendum, it's still just.
Well, why don't you just put the receipt here?
Yeah,
that's
down
what I'm
Oh,
saying.
all in
That's
one
what I'm
separate.
saying.
Yeah.
Put the receipt at
That's,
the bottom of that.
So, okay.
And
Is
just
all
read
you
the basic
That-
language
Does the
from
buyer need to sign that? Since we're having, you have the
they
date,
don't have
No.
to agree to it at all.
So is
but we
the,
have the date, insert the date, this notice is received by buyer. I
So
don't
that's,
know what
that's the
that
trigger
date
point.
When they're
So if
told.
you look at the actual language in
So we're copying,
paragraph G,
emailing it, putting
For
in that
the-
date.
right, and that's the tricky part. I put a lot of thought into how, in the receipt buy is the important thing. And it goes to contingent upon, for purposes of performance, the effective date of the backup contract changes to the date the buyer receives notice of termination of the first contract. So that's why it's a little awkward because you're having to fill it in and then you're having to then hand it over. Open to
Okay,
thoughts on how to do that, but I think that's the language we have to.
Buyer receives or is given?
Yeah, there's a difference.
That's what I
It says
read.
receives.
And the buyer is on a 3-week cruise and he doesn't receive it. His agent does. But the intent is when the seller knows the first contract's gone today is the amended effective date when the seller gives notice to the buyer, not when he receives it.
As
I
long
think
as.
that's a pre-lunch discussion.
Free lunch.
Well, no, and this is one of those unique notice requirements. As we go there, we have unique for the, and I didn't, it's in our outline, we discussed in our subcommittee of having the escrow agent notices is a separate notice provision This is a separate notice provision that doesn't follow 21. It's a unique one. So we had the ability to change this. We're not bound to anything else. Since we're revising this, we can revise the notice requirement to make it reality. I think the thought behind having the buyer receiving it is if there's not a certain date the buyer would ever know about, right? And we don't, I think a fear, and I believe we discussed this, was what if the buyer is on vacation? They don't know when it's going to happen. They went out for a week and all of a sudden they have an amended effective date just because they were provided notice they didn't actually receive and they can't perform because of something. So having them at least get it in hand.
Well, that's not the way it's worked in practice. It's as soon as the seller knows that the first one's gone today, they notify the buyer automatically, and you know in the forms that you've gotten that that's how it's going to work.
Right.
And this is now my new effective date, and my days start clicking off. And agent needs to know where their client is. Client needs to know. I see this as maybe a loophole we missed to say buyer receives because of just what we said before.
And we can turn it around to in accordance with paragraph 21 since notice or something if we wanted to switch that to make it fit the practice
108.
in consideration of the other concerns.
Well, I mean, Brian is right. I mean, we did have this conversation prior to lunch, which is if the notices are being sent to the agents and it's all going digitally, then buyer's receiving it. Even though buyer's not looking at it, he still received it. It may be sitting in my inbox.
So can we take out the parenthetical and just the effective date is this? And just take out that received by, and so there's no question of it. This is the effective date.
Well,
The date that you're sending it.
When you say parenthetical.
Up here where
Just
we
have
got
on the
insert
screen.
the date
So,
that notice.
I just copied down what
received by
This is
buyer.
with the additional earnest money.
Notice
It has to
is
be
received
deposited.
by buyer. I see what you're saying.
Yeah, I see
Yeah,
that
I
too.
think that could be. a
So-
problem.
Because they could argue that,
Like, just get rid of that and just, here's the date. When I send it to you, it has that date in it.
Well, if you send it electronically, it's by email, for example, then whether the buyer has looked at his inbox or not, he still received it. So I think you can simply say the amended effective date of backup contract is,
and this is likely going to
insert the
the,
date,
this is going to the buyer's agent.
Mhm.
So they're going to get that.
right? So the next question that you have is that's going to trigger now the time period to deposit that. Do you want to put in a notice that says buyer, according to the backup contract, buyer has X days in which to deposit the additional earnest money that's specified in the backup contract? That's just a notice to the buyer. You got to go pay your additional.
You
earnest
also
money.
have the option days.
We would have, it'd be almost duplicative. in
When does
some
everything
form
start
to-
counting?
I guess this is separate form.
It's a
so
separate
that's-
form, yeah.
And what if it's calculated wrong in there?
Well, this is the
No,
same
no.
problem you have with the effective date of the contract.
Right, except for the
Right.
calculation
Agents.
days.
I'm not asking how you says that you just track this, that buyer has blank days within, buyer has blank days after the amended effective date, which you're inserting now in here.
That would
deposit.
require us, because we insert the number of days on the backup addendum, that would require the agent to go in, and what if they changed the number of dates? I don't think we
That could leave it
duplicate
open for
that.
renegotiating.
I think it's simply, I think the reminder is simply earnest money and option fee receipts at the bottom of the page,
Okay.
which should trigger them to understand what the terms are that they agreed to here.
Yeah, I agree.
Even if we
We
put
can-
earnest money and option money is to the same terms as in paragraph 5 in the original contract or something like, you know what I'm saying? It's the same
Well,
term.
that's all written into the backup
Backup
addendum.
addendum.
Now has all that wording about if the last day to deliver is a
Yeah.
holiday, blah, blah,
Yeah.
blah. All of that's in the backup addendum.
Okay, then I wouldn't, yeah.
Keep it simple. Let them refer back to the backup addendum.
Mhm.
Ooh, do we need to do our holiday language in here? Like we did in the,
It's already.
It's already in the backup. It's
We
in the backup.
no, but we revised the what's a holiday in our contract.
But wouldn't it already
Doesn't-
have been,
Well, that's.
it already been defined in the contract?
In the
This doesn't
contract.
stand alone.
Yeah.
This doesn't stand alone.
To capitalize it.
Capitalized legal holiday.
Yeah, we've already made that change in this paperwork in the packet
Yeah, I see that.
on
Yeah,
page
it's already done,
108.
yeah.
How many of us have already gone to legal holiday section 662.003
Uh-huh.
to see the
Nope.
lengthy list? I haven't.
Oh, we did in the beginning.
We did, I forgot.
It's always an eye opener in teaching classes to put that provision up there. And
San Jacinto holiday, is that a Texas one?
Yeah.
What
Texas
if
Independence
everybody's
Day,
I
San
just
Jacinto Day.
get it to the first day. Don't be messing with worrying about the third days. Okay. Should that be additional earnest money and option fee receipt?
Yeah, I feel like that's where he's headed.
I was just trying to get it's kind of looking good.
For clarity purposes, I want to, if someone goes in and on additional option fee puts $0, they don't have to pay additional option fee and they still get the rest of their termination option, right?
No, the first line says upon execution by the parties, earnest money and option fee must be paid.
Well, my reason for asking that is because I've questioned a word we put in here under F. It says, on failure to timely deliver additional option fee, if buyer fails to deliver any required additional option fee. So it's saying basically by saying failure to deliver any required, if we don't require additional, they still have the time frame. If they had 5 days.
This is a little different from extending it because it's agreed to upfront on what the period is.
Mhm.
Where I think the concern about lack of consideration in requiring a payment is when the obligation changes. And so since we're not changing it here, it's already written in this many days after the amended effective date that we don't need, there's not a legal need to have it, but you're right, you're exactly right.
They would still get 5 days after the amended effective date, even if we have 0 in here, because we have the any required. That's what I thought, but I wanted to
And they
verify.
already paid some level of option fee in the very, very beginning.
Right, but I've heard some people interpret it as if there's 0 here, then they end and they don't get to extend. And I just wanted to make sure that I was fully clear on how we had written that even if they have 0 up here, that if we're not requiring any additional, they still get the 5 days as in the
correct
first contract.
Okay. So like if the seller says, no, I want $300 up front, you don't need to give me any more. That's all I want. Okay.
Yep.
Yeah, good point.
Yeah, just wanted to make sure.
Okay. So you don't, this is what we're talking about more or less. Not great formatting here, but okay.
You are amazing.
And the same thing with the additional option fee.
Yeah.
Oh, and the option
and
fee
we can
here.
have,
So I need to do that up top. Okay. Additional option fee. Is that what we called it or just
Yes.
in the backup it did call additional option fee?
additional earnest money of,
Additional
and
option fee.
additional option fee of. That's what it says in the backup contract.
Can that be in one sentence?
Do you want to combine that?
Which part?
Additional option fee receipt and additional option earnest money receipt? Do you want to combine?
We have
Receipt
it.
of blank and blank option.
Yeah.
For the.
Could that be earnest money and option? Do you not have to have 2 boxes? Oh,
Back to the
the
underlying
date's
contract.
different though, when it's delivered.
Well, won't they be doing it all at once?
Well, yeah, in the perfect world.
Yeah, should be, but maybe.
And we have language about a shortage being first applied to the
Yes.
option.
Yeah, that's
Mhm.
true.
Oh, yeah, right.
And earnest money is not capitalized.
It is in the backup contract, or in the backup addendum. Unless we're gonna change it. On page
Page
108.
I'm looking at the one that's
It's not.
currently there and it's not, let's see.
I don't think earnest money is. The option fee is, yes.
Yeah, option fee is on the table for us to make lowercase, but. the
Oh,
function-
right. Earnest money is lowercase, and you're right, option fee is capital.
And that will be reduced, right?
But yeah,
Option
make
fee.
lowercase. I think we need to go back to where it's done in the contract, just to make sure everybody's on board with it. I think we need to.
Okay, so you want option fee not capitalized here?
Correct, but we'll discuss that to make sure it's on board, but earnest money definitely needs to be lowercase. Now, just raising the issue, we have two different places for additional earnest money. Not saying we need parentheticals. Now, with how we've done it, I kind of like this, it separates it.
Do we need
But
to-
is there an issue with, let's say title company makes a mistake? No additional option money was, or earnest money is required in the underlying contract. They pick up the receipt page from the underlying contract and just write in what was supposed to be additional earnest money under the backup. Is that a legal concern without a practical, creating practical issues? Because there is a receipt for the additional option money and it's paid. There's no question about it. And
That'd
so-
be a lawyer question.
I think.
And that's why I'm raising lawyer versus practical type
So
of.
can
I
we
think it's
put the
just a mistake.
parentheticals in there that not to be used for, I like the idea of in the original contract, making sure that additional
Not
are,
to be used for the backup.
yes, like your original idea on the parentheticals underneath, not to be used for backup contract. And then even on this, not to be used for any other purpose than the backup
Only to be
contract.
used.
We have a form of that in the outline that I sent if you wanted to have an easy way to display it. If you wanted to show everybody what that looks like.
On the, in the draft?
I
that
mean,
you-
I would think if it was receipted, no matter if it was handwritten.
Not in the draft, in
receipted.
the outline. with all the
But that's a
issues
lawyer
together.
question. That's not a,
Yeah, I think once it's receipted, it's, once you receive it.
That's what I was gonna say.
Even if you didn't get a receipt, I don't know. that
I
it
don't
would be
care
the
where it
law.
goes.
Yeah.
What's that?
Even if you didn't get a receipt, it's still already delivered.
Right, exactly.
So I don't know.
Yeah, that's.
And I think it'd be very rare to have additional earnest money filled out in the contract and separate in the backup. That would be very strange.
That one commissioner's always on our meetings,
Commissioner Lowe, it's just.
always.
Here, like this,
Yeah.
not for use.
We don't have an additional option fee receipt.
Oh, yeah.
Correct. So we would need it. But as far as the concept goes, that's what we were. And you can copy and paste the language to people like that. Yeah, on the bottom of that screen. Right there.
Not for use for payments.
That would be the one that would go in the backup language.
Okay, so you want to put that in the receipt for the
Backup.
the backup? Got too many documents here that I'm open here. Would that apply to both of these or just to the option fee?
Just to earnest money. The option fee
Yeah, let me show you.
would be additional versus just the option. So we could.
So I just pasted it here, but you want this language, you want it under both of these or not?
I think just earnest money in my mind.
Because that's the one that's got an additional already in the other contract, in the one
This
before.
seems kind of odd to put this here. Yeah, I think it's kind of odd to place it here. It just seems strange. Is it something like that what you want? The other thing is, I don't think you need the address and stuff of the expiration since we already know who that person is, right?
Oh, yeah.
Do we need to say that there's like we have a receipt for the actual receipt of the contract? Does there need to be somewhere? I mean, we're saying up above, it just deemed it done when you give it to them. So we don't need a receipt for the actual
I don't think so.
addendum.
Ron, I don't think we need that non-producer.
You mean initially when the
Take that out.
transaction
Let's see,
is
brokers,
first
So
done?
like on the regular receipt page, you have a receipt for earnest, option, and a contract, receipt of the contract by the title company, right? And by,
Yeah, but it is
And
a
if this group
backup
anyways.
contract.
So what I'm asking is there a receipt for,
I don't think
I've received the backup
this is gonna
contract?
be a big problem.
Well, they've already done that on.
Like I received the notice that you're now primary.
Oh,
Nothing.
Received
I
the
don't think
notice
that-
that you're now
With how we've
primary.
structured this.
Because they
That's
have
what this
nothing to
form
do.
is.
But
You're
I
now
don't see it's gonna
primary.
be a big
but
issue.
the title company doesn't matter if they get receipt of it. The main thing is the buyer, buyer's agent has that. I don't think.
I mean, they don't even
I
hardly
don't think
receive
that's
extra
needed.
additional option fee.
Well, the title company receipts the whole contract,
Yeah,
right?
But they receipt
Seems-
of the
And the
initial
reason
contract.
is, you know,
But I
Now
think
they need to know that
That this
it's in
is-
first place. Because most of the time they don't open
so they would
a
never use
GF
that.
number with that
Right.
same
Yeah,
address, so
most of
it
the
just
videos.
sends.
Mhm.
So, you know.
Yep.
I know this is the
Because
style that
question
we
is,
used
how-
here,
How do you
but
usually?
why do we
Do
do
you
it this
need
way?
to have a record of the fact that you
Why don't we just
received
say
the
receipt
That'd
of
be a Brian
additional
question.
option fee
Brian,
and then
practical
check boxes to
question
say
now
what they
here from the
received.
broker piece.
It's the additional option fee they're ever gonna get. So if
What-
you look at the
On
amendment, it
this
goes to the seller.
notice that says.
What about on
hey,
this,
you're
if
moving
we
in first position?
would take?
Do you want an earnest money
What
receipt,
conversation?
an option fee receipt, and a receipt of receiving this form?
Melissa had a question to Brian from the
Just like
title
you
piece.
receipt the
If there
contract,
needed to be
receipt of the
something
contract
on the
and
form that indicated receipt of it.
Hold on one second, I was trying to hear that. Or-
Did y'all come back to this?
Yeah. Yeah, so you want to raise that, or Diane, do you want to?
Yeah.
Let-
Well, the question was, on this document that you're working on right here, does it need to have a receipt from the title company as receiving that it's now in primary position, as well as the option and the earnest, like the regular receipt page on the one to four family contract?
I didn't think so, since it's more of a notice personally.
That's what we were asking.
The one thing with receipts, yeah, no, I don't think so.
We don't do that with amendments and addendum.
Okay.
Ron was going down the path, I was about to throw out a new concept on top of what Ron did. We don't necessarily have to be stuck to the form, we do it in the underlying contract. And Ron's idea is combine it into one. And what if we, instead of having additional option fee receipt or just receipts for payments under, or some other language, right, titled to it of.
What I would do is just strike receipt here and then have receipt of additional option fee in the form of blank is acknowledged and receipt of the additional earnest money. Just bring this up, so then you have one signature.
Assuming they're both paid at the same time.
Which they may not be, I guess. I guess you probably need two different dates, then you'd have to bring the date up for each one.
Is that sufficient for the title company to now begin their process of title search and all that sort of thing? Is that sufficient notice? That's what was the conversation here, is in practice, backup contracts have been around forever. But how did the title company know this is real? Well, they knew it's real because first one went away and now
I think
somehow they magically found out that the backup contract now is in first place.
the deadline for title isn't contingent on, there's no deadline, title's not a party to the contract, but the seller's obligation to provide title commitment is 20 days after, is it the effective date, maybe, which would be the amended effective. That's right, so going to your concern, of, okay, they need to know now their deadline.
Yeah.
Their deadline, what their seller's deadline that they are.
I mean, the title company's gonna get the money, but is that sufficient to the title company? And that's why it was a
We'll be
Brian
receiving this form.
question. Is that
Where the
sufficient
sell-
the
yeah, where the
notice to
seller's
y'all?
Notifying that this contract's terminated.
What's the receipt's purpose in the underlying contract to begin with? I guess starting there, what's the fundamental, there's not a legal requirement for it. It's,
The seller wants to know the buyer's put up his money.
And then all the dates start clicking off on the backup contract now in first place.
Instead of additional option fee receipt, can we just call it backup option fee receipt or backup?
It's not a backup anymore, though.
That's true. That's right.
The fact that these two receipts are on the document by which the seller is notifying the buyer that they're now the primary, I think that should be, that's a pretty good clue. As to what that was for.
I'm with Brian on that. I originally really wanted those parentheticals, but that's where you've been talking this through, and especially with the formatting of this, I think it's going to remove a lot of the issues. And even if there is an issue, I don't think it's going to be form over substance. I don't think it's going to cause disputes at the end at the timing. So I'm okay with it.
Yeah, and since it's going to be signed off by the escrow agent, the title company, it's in their hands. So.
Can we see the whole form? So it's basically this form with that at the bottom. Awesome.
Can everybody read the language? The actual amendment language. So.
Except I think the one thing that we had was the parentheticals on inserting the date this notice is received by buyer. Can we just leave it with a period and erase that language?
Period.
Hold on. Remember, we have the same issue in the contract, going in the effective date of the contract, which triggers all the same deadlines, right? So what we say in the contract is
brokers fill in the
insert the date.
Broker fill in the date of final acceptance. Broker fill in the date of amended effective date.
And that's why following the language that was required is when the buyer receives it. So having that language there, notices received by buyers, is tracking what we have in the amendment itself, but not saying we have to use, but that's why that was included. And I looked at the underlying contract and that was written to that.
Can we insert, instead of saying the date this notice is receives notice of termination of the first contract to match the language in the backup contract? Those sound a little bit different to me because the way it sounds with insert the date this notice is received by buyer makes me feel like I have to go to the buyer's agent and then acknowledge that they've received it versus the date buyer receives notice of termination of the first contract is basically me putting in, I know they're going to get this email today. I'm sending this email today, so I'm putting this in there as the date. Those have a little bit different interpretation to me.
I think whatever you fill in there creates a presumption, but it can be disproved by other evidence.
Since the buyer does not sign this form, it's a notice from the seller.
Well, yeah, that's what I'm saying. You don't need to put the broker fill this out because the broker's going to fill it out anyway. And the seller's going to sign it.
That's why I don't think we need to add something where they're.
But I do think
for the
that
buyer to
received by the buyer is still, whether, it's probably correct contractually, but layman agents out in the field are gonna say, oh, well, my buyer didn't receive it. And I think that just is.
It's pretty universal around, so I think we need to find a solution to it. So,
Well,
Say the date given by seller.
The realtor form's been out there in use.
Yeah.
It hasn't been a problem.
It's
what does
even,
that say?
I would say insert the date.
So this is, they used a little different, and this is what I changed following to language, insert date, this notice is sent to buyer.
Yep,
To me, that
exactly.
That didn't,
Or delivered.
track, exactly the law side, right? Because it's inserted, sent to the buyer, and we're saying that's the amended effective date,
Yeah,
but it's not the actual.
it's delivered when it's sent.
If it's
But-
sent to the right
Delivered
place,
to me,
I sent it to you in this other way, but that goes back.
Can we say delivered? I mean, to me,
Delivered to
delivered and
buyer?
received are for us
Yeah.
that are out, an agent deliver means, okay, I sent it to you. That's the date done. And whether you received it that day or not, it was delivered that day.
So it's a
right.
That's the effective day.
Use
Yep.
delivered instead of
I
sent.
think delivered.
Instead of receive, you have received in
Mhm.
here, put delivered to buyer instead of received by buyer.
Yep.
I like that.
That makes.
Well, the contract says received.
Well, then let's
That's
change
why
the
I changed it.
contract. Let's change the
And they're all
addendum
saying
then.
that's going to cause mass confusion, and it's something that they can't control, right? To a certain degree. Now, to Ron's point, if you sent them the email, they received it, whether they actually got it or not, but.
But when
I
I'm
would-
reading
I
the,
would track the backup addendum it says received, I use received,
Yeah,
unless you want to change the backup addendum.
I think we maybe should.
Because when I'm reading paragraph H, it says, the effective date of the backup contract changed to the date buyer received notice of termination of the first contract, which is when it's delivered to them. Is different than how I'm interpreting this. And I'm just gonna say, most people are gonna interpret it and see it the way me and Candy are.
So if we go into the language of the backup contract addendum to do it together, it's really when they provide notice in accordance with paragraph 21.
Yeah.
Yes.
And so if we state that instead of received, note when notice is sent in accordance with, if we even say, when you say, but basically the concept in 21, then look at here, what do we can say when notice is delivered in accordance with paragraph blank of the addendum. And this point back to the addendum itself. So then we're kind of bridging the gap between it.
It's of the contract, right?
Or this would be point to the addendum section, then we would change the addendum. Right?
And do we need that H change? Because it's to everything we're talking about right now. I think it was a miss. I think we should change that. It
should be the date seller delivers notice of termination.
Or I guess we could do that too. I'm sorry, I'm making it more complicated. I think that, and then we use that language as well in the backup addendum itself.
I see what you're saying, okay.
And if anybody picks up on it, we have backup in quotes in the title. And so when it's the title of the document within our forms, maintain the quotes. But we also define backup contract at the beginning of the backup addendum. So when it's referring to the contract itself, not the title, but all one little small distinction, and the quotes aren't used.
Does it say contact or contract? The very last word. I can't.
Contact.
So are you saying any place backup appears in the addendum should have quotes?
No, not anywhere. It's just, I was just pointing out if anybody notices the difference of why there's quotes on some and not on others.
Should it be according to paragraph 21 or according to paragraph H of the backup contract?
Yeah.
So I originally was going exactly there, but then it's just repeating what's in the backup. So you wouldn't have to do a stair step to, let me go back up, and then from the backup there, both would blend back to the same thing.
But you're saying on the backup addendum itself.
Correct.
We are going to change paragraph H.
To say.
To the
Seller
seller
delivers.
delivers notice of
Seller
termination
delivers notice of termination.
of the first contract.
Delivers to buyer notice of termination of the first contract.
Let me put that in here for the minutes.
Nowhere else do we point back to paragraph 21 for providing.
You don't have to say paragraph 21. Just say notice is given.
What's it say? The date this notice is received, or the date the notice is received?
Right now it says, in the actual addendum itself, it says the effective date of the backup contract changes to the date buyer receives notice of termination of the first contract. First contract in capital.
The date buyer receives notice of termination.
Yeah.
And we're going to change that to,
So it's refined.
Seller delivers.
The date seller delivers notice of termination to buyer, right? Or just delivers notice of termination. What do you want to say there? Just delivers notice of termination of the first contract, right? Just leave it that way? Okay. All right. Or delivers to buyer notice of termination of the first contract.
I'm seeing how we do that in other sections for consistency. Notice termination to seller, notice to buyer, so we do have.
Okay, notice they delivers notice to buyer of the termination. Okay.
Maybe we change this, take out the paragraph 21 language here, which would be unique, and put exactly what you did in the minutes.
Paragraph 21 of the contract.
I think they're taking that out. They're gonna change that.
Okay.
So I can go over here and just show you what I did in the minutes on this one real quick. So just saying that we decided to change paragraph H by striking the date buyer receives notice of termination and substituting the date seller delivers notice to buyer of termination.
Well, does that sound like termination of the backup contract?
It goes on of the first contract. It goes on.
Yeah, it goes on in here. He just replaced that wording and it goes on.
I'm just
in the first
substituting a
one.
piece of the sentence. Yeah.
Yeah.
Notes, gotcha.
For those that read, the select few that actually read our minutes, do we want to include the whole sentence so they?
I can do that. But then they would make it easy for them to understand what we did. Okay.
And I'm wondering too, if instead of having date seller delivers notice to buyer, the to buyer being at the end after the first contract. We kind of have it split up right now. Notice to buyer, what notice? To buyers in the middle, where everywhere else we did is at the end.
Okay, so you want to say the last, all right, let me do this here. Okay, so the committee decided to change the last sentence of paragraph H of the backup addendum to read. So you want change that or?
Yeah, we put to buyer after first contract.
Oh, after over here.
Correct.
Okay.
In the form that we will have, it's voluntary use where we wouldn't define the notice of termination or use the exact language because they can use whatever form they want. But we're having it there for voluntary if they want to use that for that purpose. Yeah. But when we have put in the minutes about that new form, we probably need to specify that it would be a voluntary use form.
Right. So here we need to say.
So we're adding to buyer though on F right there.
So the committee decided to, what I'll say,
Probably should be deliver.
adopt.
Seller
a
delivers
new
to
form
buyer notice of
title.
termination of first.
What did you title this one?
That's what they had on first. And then they said-
Seller's
They wanted
notice.
they wanted to say what was delivered first and then that it was to the buyer.
I think they
It
said that
was
because it's
called-
consistent with other
The way the
language
other
in the
rest of it
contract.
read.
What's the name of that form? Give him that, because he's trying to type it in.
Right.
Seller's notice.
Yeah.
Seller's notice to buyer. Of,
So this would be kept as a voluntary form instead of mandatory since we have one for the use of this?
Well, that's the question of whether we make it voluntary or mandatory. And do we want to force the parties to use this for the notification from seller to buyer? I think would be the only thing, or allow them to give it in other ways.
I would say mandatory, but that's just me. But
So is the question in part coming up because there's a Texas Realtors form that's been used?
Not in general. I mean, that'd be one thing that would allow that form to continue or not, but mine was more broad. I can give notice under different ways. I'm
Yeah,
just saying
send
to
me an
use that, but
email, yeah.
I can't get to the form right now. Let me go ahead and send an email right away to let you know. And if now legally that'd be sufficient, but the agent, if they didn't use the form, if it was mandatory, could be subject to direct discipline if not. So that's the issue. But it's fine if I'm not fine either way, really. It's just a matter of going into it intentionally with what we want to do.
They kind of go together. They're being built to provide a purpose. And the backup addendum, we created this to make it come full circle.
That's right.
And I think that it should be used together, just to avoid
So
the
not
problems.
voluntary, but
Should be.
mandatory.
But you're gonna have the listing agent send a text to the buyer side. Hey, first contract dropped out. Congratulations, you're in first position.
That's sloppy, and we gotta
It is, but it's a
stop it.
notice.
But it's a notice.
But it's effective.
So we would have to say in our language, and go back to what we wrote, that you have to provide that specific form in
okay.
to there instead of just notice, it would be that form.
Okay.
If we wanted to match it up with it, again, legally it'd be fine, but it's just an agent using.
So, but if they're being sloppy, we might want them to have a disciplinary issue with Trex, so maybe it should be required.
For you.
Just saying.
Is our goal to just
Well-
have I'm sorry, is our goal to elevate this industry and do it right or just to get by and do it sloppy?
Yeah. And the buyer or seller could use their own form anyways too, under the 53711 exception.
Don't assume they're being sloppy. Because you send that notice, you started the clock ticking for the buyer.
Yep.
Exactly.
Option to pay that option fee. And if I'm the seller, I'm hoping they forget.
Well, it's just like a first transaction. There's an obligation to get the earnest money option fee if you want your rights. And this is now in the first position, and we should respect it the same way we did the first one.
Well,
I'm okay with having it a mandatory, going back to my thoughts, mandatory with it, because the buyer and seller can always use their own forms or one developed by their attorney. So if they wanted to do it a different way, they can. Having this a mandatory form will make sure the agent is giving the right information and is
Well,
sending out and
I've always-
documenting what it is.
I was going to keep quiet, but I've always had a problem in mandating notices because I think that notices are given in all sorts of different ways. And for the reasons that in our digital world, there I am sitting in a showing at 9 o'clock at night or 8 o'clock at night. I get this call. Someone forgot to send this other kind of notice, not this one. And I need to text over the notice. I need to email the notice. And filling out the form, getting a signature, and all those kinds of things can be problematic. So,
very true on that. And the notice can be, if they have to use a form, the seller has to sign it. as opposed to the listing
Well-
agent being able to send, can the listing agent send it over?
Yeah, that's another question, right? If you send the notice as a listing agent, you grab the form, but you don't have the seller sign it, then it raises questions. So I've never really been a big fan about mandating certain types of notices. I think publishing notices, form notices is great. They're very healthy and they provide good guidance. So I think the realtor form has been very beneficial, but not all of them use it.
You sold me on that. The question I have too, in listing agent, just for, if anybody goes back and listens to this discussion and intention, if the listing agent's the one to send the email or text or whoever over to the other side, not the seller directly, that's still, because this one requires seller sign, that one would still be providing notice, is the agent providing notice to the other side. And we intend that, or, you know, whatever the law is, we intend that to be effective.
Right.
Well, in practice, we teach that they use that Texas Realtors form for communication because there's a gap. There wasn't a TREC form. So to have the official date signed by the seller of when your contract now is in first place isn't our job. I mean, our job to convey it, but it's the seller's notice that you're my guy now. And so I think what we've accomplished here is to provide that piece that's been missing. It gives notice of the date, and it also gives receipt of the additional earnest money and option fee. So I think we're heading in the right direction. Now, what I'm a little confused about is what other forms, to give us an example, that's a mandatory form, that when you say, well, is this mandatory?
So we have 9 different forms that are voluntary use.
Non-realty
Is-
item,
is
is
be-
that mandatory?
Non-realties.
Okay, that's what I wanted to, but give us
So
an
it's
example.
subdivision information form, the certificate, I have a list of all 9.
One most like this one's going to be notice of termination of contract. So when the buyer is terminating
Okay.
at
That's right.
4:04 p.m. on the last day of his option fee.
And I guess I see those a little different. I can see the point Ron made. My other concern is how often have we experienced agents in the field where they know that the first contract is in process of terminating, has not officially terminating, and they're sending a text to the backup contract agent and telling them we're terminating, and then they don't have something official where they're clear the first contract is terminated. Because sometimes the first contract may be terminating and yet it's not fully terminated because we don't have a release of earnest money signed. And it's still not fully terminated and released.
It's terminated
It's-
even though they don't have, even though you haven't released your earnest money. When they can terminate, they terminate. Huh?
Right, so the only thing that I think this particular form does come a little bit more full circle is slowing down enough where we're not having agents just send okay, we're terminating, coming to back up, because I see that happening with agents jumping the gun and not slowing down a moment, because if something's terminating at 9:00 at night and they're sending something, there's still ambiguity around what is the actual amended effective date, and this slows down to make sure we're clear and precise around dates and the communication around first contract is terminated and we have that in writing. That's just my thoughts on it.
I agree.
And I also see Ron's point as well. I get that. And especially in the realm of needing to terminate, notice of termination in the 4:59 PM.
Yeah, if I have to terminate before 5:00,
But this,
I might not get that little piece of paper to you because I'm in the golf
But that
course
is
and I got a
different,
message
in my
saying
opinion,
terminate.
this.
Huh?
This is a little different where I absolutely see agents telling someone in backup position, we're terminating. But what does that communicate around an amended effective date? Because it may not have yet officially terminated. It's just in process, knowing they're going to get a
And
termination.
they can change their mind. And until you see a signature and a date on it by all parties.
And then the seller's clear the first one has terminated and that it has moved on. That is the difference I see in this particular scenario versus the termination notice. Just my thoughts.
Any more thoughts on this? Go ahead,
I'm
Andy.
just saying,
I've
if
been
I had
sold.
to wait
I'm-
for a piece of paper for the next day, that could be a whole argument between agent and agent. Now, or buyer and seller. I'm not giving my earnest money because you didn't terminate before 5:00 because you have to wait
We're
for
not
that.
talking about termination in 5:00. We're
No.
talking about addendum for backup contract.
Right.
Two totally different things. What I'm saying is that there are going to be situations and happen situations where someone calls or texts an agent and says, you're moving into first, but they have not finalized the termination on the other one. They just know, they may have heard that it's in process and they're getting a termination. The person could change their mind. They're already thinking, scheduling all these things. I'm just saying that the finality of making sure, one, the seller is clear that it's terminated, the seller has signed off on this, clear that the first one is terminated, the backup is moving forward. I see this as a different scenario than the termination. That's all I'm saying.
So let me throw another scenario. I can't get to, the buyer can always authorize the use of a different form.
Mm-hmm.
This is unique because we don't have a situation where, what is the notice? What needs to be in the notice? So does the buyer or the buyer's attorney even need to authorize any other form? Right? It's sending that text of, you're now in first place. First one's terminated, you're now in first place. By having a mandatory form, does it prevent that from happening? Just to talk that one through.
Correct.
That's what we're saying. Or do we need something from our client or principal saying, I want you to send this language over, right? In that written authorization. That's where I'm
Aren't most of the transactions we're talking about really involving the brokers, the agents, and not attorneys? Yes, it can be, but I think we're talking about what happens most of the time.
And that's where I'm going to, because in the same category of a buyer, I'm just making it start. But
Yeah.
the buyer, do we have to go to our buyer or seller in this case to say, you have to give me the language for that notice to send over because I'm bound and burdened by this mandatory form that I can't get you to sign right now for whatever reason, to make it effective, right? The notice, or otherwise the buyer would have to send it themselves, right? If for whatever reason the agent can't send this notice, normal mandatory forms prevent the agent from using any other ones unless directed by their client or their client's attorney.
Is giving a notice the unauthorized practice of law? It's not drafting a contract or anything. I don't know that sending a text is prohibited.
Well, that's where I'm going.
Or that you have to use it.
We're saying for,
It's a mandatory form.
it's a mandatory
you have to
form,
use
that's
it.
what, yeah.
And then I agree
We
with
wouldn't
you
do
that
mandatory.
that's why I'm trying to dice into the minutia. Where does that is a unique situation that I agree with you. It's not really drafting legal language, but if I have a form I have to use that is for that exact purpose, where's the limitation? And it's uncharted territory looking at that from our form perspective.
So the only answer would be if it was mandatory, then you can't get the form to your buyer or whatever, right? That the buyer has to send an email to the seller personally to say it's done.
To say, here's the language to use, or send it to their agent, or to send it to the other side. But, and that goes to the making it voluntary. It's kind of a silly situation. You're looking at, it's not really legal language, it's just providing notice. And do we want to create this potential?
I see the point. I see the point. I do think we're going to have situations, and we do have situations where agents don't fully have, because they're so quick to make sure they get the next one going, that they haven't followed the proper procedures of making sure the first one is actually done first.
And I'll tell you,
And that
what
happens.
scares the bejeebers out of me is that you're gonna have a buyer and buyer's agent who are asleep at the wheel, and they don't realize that they have an option fee that they have to be paying in 2 days, and they're gonna forget, and they're gonna lose a valuable right, which is the whole question of if I were a buyer agent, I would resist very strongly ever agreeing to pay additional option fee on the back end on a backup contract, maybe additional earnest money, but it's so dangerous that somebody's gonna forget and they're gonna lose their unrestricted right to terminate.
The option, if it was mandatory to avoid the issues that contractually can say you have to send this notice, the seller, right? You have to use this form. And so there it's in effect, okay, you have a mandatory in the agent and you have a mandatory in the parties by the contractual agreement. That would be the way for me to marry that up, but then it leaves open not being able to send that quick text to get it done.
I think it should be a tool. They haven't had it before. this is better than what we've got right now.
Mhm.
And they're not gonna know if it's voluntary or mandatory unless it's printed on the page.
Well, it is.
So
They are when they're mandatory. It says mandatory, like the non-realty item, it says mandatory.
This is a unique question. Does the commission or this committee make the decision on mandatory versus voluntary?
Well, we certainly take your recommendation.
Opinion.
Ultimately, so if we wanted to change, if we started voluntary and we've noticed issues, could we, it would be from us to then
Yes,
say?
yeah,
that?
it would be a recommendation. It's technically found in rules, but the rules that are tied to each form, so.
Well, then, starting off as voluntary is a great piece, and then I do think that our addition of the option and earnest money receipts on here will make this a much better form than what the
agree.
Texas Realtors form is, and will make this the one that people want to use and brokerages will want to use. I know for me, having those receipts on there is a great reminder to not have the buyer fail in depositing more money.
I agree with that, Chris. I think it's a good form. I like it. I just wonder, and maybe I wasn't tracking good with you and Brian down there. What were you thinking was the unauthorized practice of the law?
Nothing in this
Okay.
sense. My concern was the mandatory form. If an agent doesn't use it in a particular situation, it operates functionally like the restriction about not practicing law. The rule says you have to use that form unless your client or your client's
I
attorney
got you
says
now.
something.
Okay,
So
okay.
it's kind of similar restriction, but separate.
I got you. Okay.
In
I
the
think
past-
I think we start voluntary.
Have we gone from like starting something voluntary and then flipped it to, I mean, so may, I
We have done that.
look at it and see, okay,
Yeah, we've done stuff like that.
It's a good start.
Okay.
I like that. I'm good with that.
Doesn't happen all that often.
Yeah,
but yeah.
but it can happen.
Okay, so is everybody good with the language? And then we can move to the next.
Good job.
On F, that's up on the screen, we added 2 buyer.
Yeah.
Is there?
That was what we wanted to do.
Mhm.
Okay, just making sure.
It was before seller delivers notice to buyer of termination first contract, but everywhere else in the contract, we have it notice of whatever it is and then to buyer. Or to seller in the contract.
Oh, I don't remember, I lost my page.
Okay.
So addendum for backup contract, do we need to put quotes around that?
That is the title of the whole thing right here.
Right, and so when
Oh,
we track
you're saying-
that, then it's,
Should I put a single one here?
well, no, I mean, the ultimate title needs to be.
Be a quote, you're saying?
Yeah, I mean,
Okay.
you did it right, technically speaking, but it's,
My grammarians are gonna get after me.
okay. I take one last look at the
Okay.
form and.
And then this was just a summary of Aaron's, but here's his recommendation. So I'm assuming that the committee adopts his recommendation to strike that language.
Well, I do want to revisit that.
Any change.
Yeah, we're striking that escrow third-party charges. So now we'll read any charges if we strike that in the sentence.
Where is that paragraph
In
20?
paragraph 20, so
Yeah,
if you just strike that.
It's not strike, it was
any
Change.
Any
charges
charges for
for
gathering.
gathering and reporting information to go, I mean, yeah,
any charges.
So
I
really
don't-
just drop the charges from the quoted language.
Well, but you have the word.
Have charges in there?
Yeah, just drop the charges.
Okay.
There we go.
Drop the charges.
yeah.
This
I
says
think that's-
seller shall pay.
So that's,
The fourth, third line down, buyer shall pay any escrow agent, and he was talking like there's going to be buyer and seller charges. Is it just buyer here?
just buyer.
we're making it, I think when you look at that additional issue in the first escrow agent. Requesting the information. And
What if
so if we go back to.
Yeah, what if we said requested by escrow agent or other responsible party?
Well, what if it's a service, it's not a responsible party?
You know, if I'm an escrow agent and I hire somebody to do a task for me, they're acting on my behalf and their requests are my requests. Well,
On the settlement statement, and it's more providing them information, right? Not just paying, but providing information too.
And XYZ company says, hey, I'm helping First American Title with the FinCEN reporting. Here's the information we need to be able to complete that. Aren't I asking on behalf of First American Title? Because they've been engaged by my title company to gather that information.
I mean, that's from a practical perspective on this. If you have a client who's very upset, I have to provide my 8-year-old social security number to run with that. That's going to rile up a lot of people. And the request comes in from this third party that's not the title company. Does what we're talking about even matter? My concern being right now it says you have to provide the information to the escrow agent. And here's a third party that's XYZ help you report FinCEN, LLC. So that company's calling and not the escrow agent, is that not having that language say, be brought up to include that person? Is that a concern? I'm not saying that very eloquently, but basically, will any contract language help in that situation, or is it they're going to be upset and escrow agent as we have it is just fine to address it?
I think if they have to provide information they don't want to provide, they'll be upset regardless of what the language in the contract says.
Yeah. Okay. Do you think that the title companies are y'all, now with all the wire fraud, every time you get an email, it's big fraud information. Are y'all going to do the same thing, you think, with FinCEN and say only information to this company?
I can't speak for other title companies, but we have been building out a separate secure portal for people to sign in, password protected, et cetera, for exactly that reason.
What does FinCEN mean?
Financial crimes enforcement.
And just back to what he was saying, speaking to us, the second sentence in this paragraph is only talking about the buyer paying third-party charges. He was talking about sellers as an entity selling something, and they being the ones investigated. I just wanted to be sure that we don't have to change something because we got it wrong.
No, and by the way, if you ask me, it makes sense to say buyer because this whole reporting requirement is a function of the buyer's identity, that they are an entity, they are paying cash, and because of what they choose to do, the long arm of the law is coming in and requiring all these things. Okay, because they're wanting to shield their personal identity by going through another liability.
But I think.
But you don't. Hey, parties can contract between themselves as to pay, and there's nothing wrong with saying seller and buyer will equally split it. I think the title company needs to know who's responsible. And this proposed language says buyer, but if parties wanted to say seller and buyer will split the cost equally, just like the escrow thing.
I'm pretty strong on it being buyer in this case. Seller might have to provide information, but to Brian's point, it's the buyer's status that determines whether it's required or not. And because the fee can be incurred without closing, then it's, to me, the buyer is requiring the seller to maybe pay some fee. And I do have a concern about any I want to bring up, but about these any fees related to it. And if the buyer purchased it a different way and, whatever it might be, it's really their status that would determine.
What would stop someone from just doing it as an individual and then moving it into an LLC at a later date?
Do on sale clauses and more
Well,
like
it's a cash
cash
deal.
deals. Cash deal, no, they could.
They could go right into a fee simple.
You have to look at
I mean,
liabilities and stuff like that. I mean, it would be different for that short period of time. And different
People put property into an LLC or a trust for a variety of reasons. It may be to shield them from personal liability.
Right, but I'm just saying,
Falls.
if people wanted to get around this,
Oh, yeah.
they could do that and just do a quick claim deed later and move it over.
Not quick claim, but
There's a lot of ways around this.
Alexei Dimitrov is the buyer. Well, boom, he just got on the radar screen for FinCEN, okay? Because they'll see that. The whole reason they form an LLC is Dimitri's name doesn't appear anywhere in the
Right,
record.
I get
And
that.
That's why they want to do that. So putting it into his name individually is going to shine a light on it.
Well,
The
Dimitri's-
title company, we have to investigate names. And if Dimitri is on the OFAC list, then we're going to catch him that way.
But that may not matter for the content of this or drafting, but an LLC didn't hide all your names. I go to public record search. I see every single member that's there. I have to sign on your form. I have to say managing member.
not necessarily. You're not required to do certificates of amendment to reflect new owners.
You
Does
can
that
have a
matter? Of course.
manager. You can have a manager. of the
You know what,
LLC.
share owners or the managers? and
Manager of the
members?
members itself, right? There's no duty to update the records after filing. Now you can for various
Well, yeah,
purposes.
you have to file a public information report every year.
But those aren't public anymore. Unless there's a substantial change, they don't make them all public.
I know, but I mean, we keep talking about like it's oligarchs. I mean, I got one, I buy rent houses. Every person I know in little Podunk, Beaumont uses an LLC or a family limited partnership to buy their rent houses. I mean, this is going to affect a lot of people.
Let's look at an offer, exact same terms, except LLC versus individual. It's going to cost that seller $500 more, $250 if you split it more, just because the name of the buyer. And that's where personally, it's the buyer that's their status that's determining that, and that's why I should do that.
I agree with that. I think it belongs to the buyer. I just don't like any fee. What if you're a third party person, you decided you love to use this one company that called Special Provisions that John George set up and they charge $3,600
That was the point.
instead of $400.
That concerns me. Or you have this unscrupulous title company that's the only shop in town, and they're charging some outrageous fee that's not limited by any reasonable fee or anything.
And I had no way to
I don't feel
negotiate
that's
that as a buyer. I'm like, just buying a rent house. All of a sudden, I thought it was gonna be $400. Why is my closing statement showing $3,600 to Christie's husband's company?
Well, so we had a little different concerns about the ante there. So I still think it should fall kind of like the risk of the fees, transfer fees. We set a cap for a buyer to pay, then the seller's responsible for everything else because they should be in a better position. The buyer here and their status should be in a better position to know what their status is and what it would trigger, arguably. But to me, the ante, just not having any ability to know what the charges are to a certain degree upfront, and not knowing data like we have with escrow fees. Escrow fees have same concern could arise there, but you don't have it and it hasn't presented itself. To me, that concern. But to your point, you're saying to have an ability to negotiate it or having split just to split it?
Almost a notice of it or some kind of idea of like, well, where am I going with this? Like the industry's not there yet. So we don't know are these going to be expensive? These going to be several $1,000s. If it's like several $1,000s and I'm buying a $25,000 rent house in my LLC, I don't want it. You know what? I don't want to spend $3,000 or I know he said 500. He said it might even be lighter. Aaron did, but we don't know what it will be. It could rise up to 1,800. I'm like, I don't even want this rent house. Like this has become a big pain.
Who selects the company at the end?
Sounds like Brian is going to be doing it.
Well, because the title's the one that has to be comfortable with the information.
105 data points I need you to fill out.
No, but I'm saying like it sounds like the title company's picking the third party. Now, if I'm picking it, that's different. But that's not what our
Yeah,
language.
it sounds like this title's the one that's going to be on the hook, so they're going to.
Yeah, it's, the way it's going, the big boys are doing it internally themselves. So we're building out a whole system to get the information and to be able to do it. The cost, don't hold me to this, but it's not gonna be anywhere near $500. It's gonna be well south of that, okay? The market is going to dictate how much you can fairly charge,
Sure.
okay?
I get
Like
that, but over
MLS fees.
time, not today, but over time, Christie, this goes into play and it starts March. She's got a client out there and it says any charges. Is she just gonna sit there and wax at you and say, there's a guy, Brian, he swears he's got this portal his company's created and he promises it's not gonna be anywhere near $200. Does that make that guy feel any better buying the rent houses in Waxahachie that some guy named Brian and some guy named Aaron 6 months ago in an office said that? No, the contract reads any.
Yeah, but your agent is gonna say, this has been something that's now implemented, we have a track record, this is what the going rate the title companies charge.
And the moment
Just
she's,
like escrow fees.
hang on, Captain, hold on, Captain. Brian,
Brian.
She just misrepresented, or he, when they just got that wrong. And it might only be $400, but you said that the industry says that it's only $400 and it was $800. I'll take my $400 right now.
Let me throw
How's
something
it
out.
any different from escrow fees?
No, what about excess expenses? An idea of a paragraph that's never used in the contract ever. If you had it, and I'm believing this as I'm saying it, but it ties into something we had for another vehicle we haven't discussed, of having a blank for fees up to X amount for the report. We have the excess expense paragraph that says if expenses are more than expressly stated in this contract, either side can terminate the contract.
Oh, jeez.
Well, then we gotta forecast
hard
people
work
they
of
could
the
be. Yeah.
Right, but I'm just saying, the concern you have of any charges, well, if we are concerned about any charges to be really high, but we don't want to split them, we think they should be higher.
Well, didn't last time we talk about this very paragraph using language, we're kind of tinkering around with not to exceed, exceeding, but not to exceed. Was that this paragraph or was that a different one? We were doing a whole lot of what is to exceed or not to exceed.
Well, if it's,
And Ron and
that was
Ron were-
with the agents and who paid the agents.
Okay,
That's when that was.
same logic. Thank you. You're right.
Paragraph
So
12, yeah.
is there something we can say, look, not to exceed this amount instead of any?
Well, but here's another thought too. If you're buying this rent house and this $1,800 fee is too much, what's stopping you from going, you know what, Melissa? Let's do an amendment and change the title company, and I want to go to this title company down the street.
I don't want to change title companies.
Well, and the other.
I've already got you locked in. You're past your option period. Sorry, you're gonna pay the $1,500. I haven't been able to get rid of this crappy house that I inherited forever. And so you're buying this thing now.
Well, and both parties would have to amend the contract and change title companies, and the other party may not agree to change.
That's
title
what he's
company.
saying. He
Yeah.
doesn't want, yeah, other party don't want to change.
We're trying to predict the future. I mean, do we have to do this right now?
No. O'Brien, this is coming.
I mean, we're
I-
putting
I
something in
wanna-
the
I
contract
got a
that we don't even know
contract.
is gonna
I'm gonna Put
happen.
your name in the contract, but before I do it, what's gonna be your fence-in charge? $125? Great, thanks.
That is exactly what I would do, but I'm not sure that all agents or their
they're
people
not.
would do that. But I would,
First of all,
I think
we're
they're just
not
gonna get
gonna know what
mad.
this-
at
They're not
me.
gonna know what
We're
it
gonna have
is.
no idea what this paragraph
There's
is.
history for this,
But that also.
and that's with escrow fees.
Yeah,
Right now, everybody is pretty close to the other guy as to what they charge on escrow fee. Why? Because I know the title company down the street charges this much, and if I go $100 higher than that, I'm gonna be very lonely. No one's gonna come visit me. They're gonna be going to the other title company,
true.
okay? So, it, you know.
I think in
the
2
market-
years, you're 100% right.
Yeah, and, you know, for title insurance rates, you don't play that game. Why? Because they're set. But with escrow fees, every title company can charge its own escrow fee, but the market is the governor, is the
Absolutely.
control to make sure that they don't get out of hand.
And 2 points to throw in that may be a benefit in the back of our minds. Brian shared this website that an entity that's on top of this with a lot of good videos on what it means, and it has the charges, which would be minimal, that these title companies, the smaller ones or title agencies, can go use, that would be minimal. Now that they can mark it up and stuff, but then you have other issues about charging different things. So maybe that's not an issue. I fear not doing anything. If we don't do anything, I want to have it at least an understanding in our minds of how the contract will handle that fee.
I think we need to do something.
Oh, yeah.
Listen, as much as I don't love any, I like what we have better than nothing.
Yeah. And so the issue be whether we keep it the same or change it to any.
Oh, but, and do let me say this to you guys, and this is just for informational purposes. What each title company is going to be doing is going to be different.
Mm-hmm.
We have our own system that we're doing it for our direct division files. My understanding is that we're going to make it available to our agents. Other large title companies may or may not be doing the same thing. There are probably some title companies that are really sweating bullets because March 1st is coming down really soon.
Darlene's hand is up.
Darlene?
Brian, correct me if I'm wrong, wasn't our intent when we had our subcommittee meeting was to put something in the contract to protect the parties, because nobody's going to close it if they don't pay the fee? And it's a required fee, and aren't there criminal charges if we don't do it? Am I remembering that incorrectly?
There are penalties if we don't do the reporting.
Correct. Which the effect of is your deals for the realtors is going to fall apart because the title company can say, good luck, I'm not doing it. And I thought that was our original thought, was to put something in there that just says, hey, this may be an obligation. Because you're right, the general public knows nothing. They don't know anything about it. And I would posit half the title companies don't know anything about it right now.
That was the main thing, was the first sentence.
Yeah.
Saying that the seller and the buyer have the responsibility to provide the information, because I could really see a seller and a buyer saying, I'm not giving you that security number. And somebody might, as a pretext to get out of the contract.
Could we keep the first sentence as it is and then roll those fees back up under paragraph 12 under buyer fees and call them whatever we're calling them, government reporting fees?
Well, that's an idea. I kind of like that. Can we talk it out? I mean, I think that might work, right?
I think we definitely need that first sentence.
I mean, you can do it either way, but putting them both together
just clues them in that there
sort
is
of clues them in, and it gives you the narrative of, well, why are you charging me this money? The reason is because we have these 105 data points that we're going to have to be collecting and reporting to the federal government, and that costs a lot of money.
There's one difference though, because if it's in 12, then if it's 12, then we include it in contributions. So a seller can contribute to pay for those expenses that the buyer's obligated to pay, or it'd be under that umbrella that the defined term.
Are we getting too deep into it too soon?
Well, that's a pretty big one though, because the seller, because sometimes you got excess that you're trying to figure out how to use. And if it's not in, buyer's expenses, again, is a defined term. So if it's not in that paragraph.
Well, it says other expenses payable by buyer under this contract.
Oh, it does.
I just soon keep them together, but.
With that, I'm kind of with Brian.
Yeah.
On that.
I mean, that whole reason they took
that, like,
change
if they
the
go,
name to
we don't
federal
want to go
requirements,
through
things
we'll
like
go
this.
on directly and do it.
I don't think so, because first of all, we have to gather information from both the seller and the buyer. And the way the rule is stated, they establish, in most cases, the settlement agent or the escrow agent is responsible for providing that information.
So, and I'm just thinking this is partly just for my own benefit as an attorney that prepares deeds. If it's not going through a title company,
That's a read.
Because, when we had the other fencing issue, we went in and filled in all the stuff. Is there a place to go in and fill in on all the stuff?
Why are
My
we-
understanding is that they are developing, they have not yet finalized a fillable form that you can do online.
So assuming that they get that, which may be a big assumption, but assuming that they do, if the buyer or seller doesn't like the fees, theoretically, they could go on, fill it in themselves directly and give y'all, I'm assuming it'll print out some kind of certificate saying they've done that.
That'd be acceptable to the escrow agent though, ultimately, right? Because then the parties would be
Ultimately
forcing.
responsible.
Yep.
Yeah, I mean, you'd have,
Yeah.
I'm just thinking of the
Okay,
divorce
guys,
and how they did that.
I'm sorry.
Go ahead, Darwin.
The problem is I had a closer, one of my branches, that went into the form and tried to do it. And as it stood back then, which was probably 2 months ago, you cannot go to the next field without filling in the information. So that's going to create huge amounts of frustration if the consumer's trying to do it themselves. I don't even want to do it, but that might be better. But I mean, there's 105 points and you got to have them all or you don't get to the end of the report is what she told me. And she said it was very frustrating, which is why I think we're trying to find a company to do it. But the consumer is likely not going to be able to handle this. They're not going to understand it and they're not going to understand how to do it. Now, their attorney might, certainly. That would be the reason you go to an attorney. But again, we're just shifting the burden because one of us is on the hook, the title company, the attorney. And I thought that the whole point of getting it in the contract was to give everybody a heads up before we start. And it's been said already that, people are, as a seller, they're going to choose contracts based on this. That's very true. And I think I don't know how it's going to play out, but it's a lot and it's going to disrupt the industry to a certain degree until we figure it all out and how it plays out. That's just my 2 cents.
Recentering us to, at last meeting, we decided it would go on the buyer side. And I think I feel like we're over there still. And the only change that is being asked of us today is limited from what we did last meeting of changing escrow agent or third party charges to just any charges.
Right.
But that's effectively still going to be escrow agent or a third party. We're not looking at anything else. It's just changing that. And the other issue about providing the information, we see if it becomes an issue or not. So we just do a requested change and see how it works. That's where we're arriving at to look at moving.
I think we're going to get I think there's more of these transactions than you think. I think that when Brian and the other people and Aaron and I were talking, they don't think it's very much, but I know what I see just in our 14 branches, and there's a lot of them. And I think it's going to cause some disruption. I want to retire before then because I don't want to deal with it, but we've got to deal with it for the consumer because they have no idea. And Tony's reaction is exactly, Brian can tell you, how I reacted when I found out that the seller had to give information. That felt very invasive to me. But so I understand, that's how sellers are going to react. Some of them, not all, but anyways.
So
I'm okay with what we changed. I'm okay with any way we want to do it. But I mean, I think it's important that we do something. And if we have to go back and change it later, we can.
So this is what we hear. We just stuck in based on the conversation requested by escrow agent. So buyer shall pay any charges requested by escrow agent for gathering. I thought that's what I heard.
We don't leave that
requested or required or
We had
Incurred?
in the original, we had shall pay
Did you
any
wanna-
escrow agent or third party charges.
she'll pay.
That's interesting. Brian, would y'all, I'm looking at that word you just put, would you have, let's say it's $300, will y'all mark it up to $350, or will you just pass it along at the $300? Because if you just pass it along, that's not bad, incurred.
It's
You
internal.
can't pass that along, right? And,
See,
or mark it up.
You're going, this Texas Department of Insurance would not be.
It's a tax certificate issue. All these title companies are forming separate entities and sending over, charging for tax certificates. certificates and marking up because they can't do it. They can't get in and do it directly. So everybody's got a third party entity that they have a tax certificate company.
So they can't mark it up. So encourage not a bad choice.
Mm-hmm. I would agree.
Yeah.
I mean, that's the reality of the.
Yeah.
And if they
It's all-
figure out another vehicle to do it, like tax certificates,
I hate to say it's like talking to our
Okay.
law clients, but it would give the brokers maybe something to say, like when I tell them out, look, this is what it cost me. Like I didn't mark, this is what it cost me. And then they can tell their buyer, you're just getting it at whatever it costs the title company. Like it is what it is.
So and they do it internally.
Oh.
So that'd be the only gap I see of we do it completely in-house. We don't hire anybody.
I got you.
I don't think, Ron, we agreed to that incurred by escrow agent.
Okay, what would you want to put? Just say any
It's just
charges?
buyer shall pay any charges for the cost of gathering.
I like that. Or we can tweak it, but
Cost of gathering and reporting information to governmental agencies.
Is charges for the cost redundant? Pay any charges
So
for
any
gathering?
charges for gathering?
Yeah.
Yeah, that probably works too.
You know, we're not saying why in paragraph B, why this is
Yeah.
happening, what it's
Just call it what it
connected
is.
to.
So you're gonna have to teach all your people to know what it is.
Whereas before, when we talk about in paragraph A, it's talking about foreign persons and it's IRS. This is just hanging out there like a statement is, you're gonna have to pay whatever the escrow agent asks you for what? And they're gonna ask us
Well,
as the
such
agent,
as-
what's it for?
We had a far more robust paragraph the initial time that this was submitted with a introductory sentence.
We don't even
doing
say fins
exactly
in.
that. I
Why
know.
don't we say
And-
fins
and-
in?
And that was, at our last meeting, it was decided to take that out.
We decided to make it broad, but to the point of now,
The-
we want it to be everlasting, but that, for example, wouldn't necessarily be a bad idea to highlight what we're intending by this. Because let's say somebody doesn't have a FinCEN transaction and they're looking at this, what does this mean for the governmental reporting?
Yeah,
And the transaction, again, not having anything to do with FinCEN, if it's being confused on what that means.
they're gonna think it's got to do with immigration. They're gonna think all kinds of
that's
things.
probably true.
So I wouldn't be opposed to adding a for example, like we did for the notices, the taxing notices.
I do think Diane makes a good point, because we're looking at this because we know what we're crafting this around, but yet someone reading the contract would not understand. And yes, we can help interpret that, but at the same time, they should be able to understand what it
They're gonna
refers
ask
to.
their agent, what does that refer to?
Mhm.
Well, the paragraph right up above says, if the seller is this, then we might have some fees. So maybe it should say, if the buyer is this, we might have some fees.
Or should it even
Or if
just be?
if the buyer is,
It's hard to say.
will
buyer,
be,
'cause it's
will
so
be
many
impacted by the FinCEN
Well, it's got to
regulation
do with a
of it.
cash transaction, so why isn't that four-letter word mentioned? I mean, without being.
Well, there's more than cash, Diane. There's more. A third-party lender, so if I was loaning money, I have to report it because I'm not under federal money laundering statutes like institutional lenders are. So it could include hard money loans. It's not as well as cash. Right, Brian?
Yeah.
Yes.
Yes.
They treat cash as anything that is not an institutional lender. And the reason being, institutional lenders already have anti-money laundering
Yeah.
protections to catch the bad guys, okay?
Well, help us identify this to the consumer. The agent should not have to explain this.
Can you put it after governmental reporting requirements, comma, and then like John said, either for example, or including FinCEN, so we get the word FinCEN in there.
Let me send you the original email that was, or the original letter by TLTA prior to the October meeting. And it has the more robust version. Okay.
But I think, Brian, one of the rationales is it had been postponed at that last meeting. And so we decided to keep it more generic. So we weren't constantly going back and changing the contract. Am I remembering that correct, Ron? We were trying to make it pretty neutral in case it didn't come into play, but we could capture it if it did.
And that's where that, for example, will be the middle ground.
Mm-hmm. Exactly.
It's not the network. They're not the government agency, are they?
I think they are. Hold on.
What's your pension sheet say? Is it
I think I'm still good. I'm still good. I think I'm still good.
okay? So it's out of the U.S. Treasury.
Yes, FinCEN is a government agency. It's under the Department of Treasury.
Financial Crimes Enforcement Network.
Mm-hmm.
Trying to pull it up, I'm sorry. U.S. Department of Treasury Financial Crimes Enforcement Network.
Mm-hmm.
Ron, I am sending you the letter that we sent, that the TLTA sent prior to the October meeting. And you can pull up the language that was suggested then. And if you ask me, I kind of like it being limited to the FinCEN scenario, because what if there's a different reporting requirement 5 years from now? But maybe in that situation, it wouldn't be appropriate for the buyer to be responsible for it.
Good point.
Yeah.
So I have here, for example, hadn't got it yet, reporting to the U.S. Treasuries. I don't know if it's reporting to the U.S. Treasury related to something like that, the Financial Crimes Enforcement Network. I don't know if that's correct. What do you say?
Just hope.
I'm not gonna be able to see that. Let's see. Here's Brian's stuff.
It's on the second page of the attachment.
Here's what they.
The director, okay, is a bureau of the U.S. Department of Treasury. Okay, FinCEN is a bureau. So maybe what we can do here is just make it simple. Where am I?
Is it about 7 at night now, or is that just me?
This is a long
That
way.
lunch got
I
you?
just needed a 20-minute nap is what I need.
Lunch got you.
Cocktails coming.
Ooh, really?
They didn't tell us that was included.
No, they didn't.
It may just only put it. Why don't we just do this?
I still had hopes we were.
We haven't
gonna
even
stay.
hit paragraph 12 yet, guys.
How much of that's going to?
Yeah, we have a lot more to do.
Yeah, but your goal was
Yeah,
to
we
get this,
do.
so we only had to do one edit.
Yeah. Well, I think we'll get there. This is big news.
One of my first jobs when I was doing this typing there, the managing partner always made us other lawyers kind of sitting there and watch him type his emails and get his work done, and tinker with the formatting and the font and the verbiage. I'm like, can we go be doing something else while you? I'm not saying this is bringing flashbacks, but I did bring it up.
Yeah, they had the exact same thing with whether it's actual partner, me sitting down as a baby associate watching, and the other partner would like walk out and the guy still be talking to him and never turn around to continue typing and come back in. Never realized that he had gotten up and left. Just that's on Christmas Day one time.
Oh, really? He did that?
Yeah.
So
So we had a
Tested now.
Mr. Sledge wants it.
Uh-oh.
Well, I think that's an improvement being specific. I feel much more.
That's a good,
Yeah, yeah.
it ties it in.
Yeah, it
And-
pulls to what we're talking about.
Really ties.
And assuming as he's working on that still, are we good with the other language?
What's that tower you got next to you, dude?
What's
Is that
This
that?
guy.
Oh, is that where he's storing all the 105 data points? Is that the new company portal you're carrying around with you?
Gotta laugh these
So
days.
do you want,
Oh, that's
If
not
I-
the record, is it?
so TLTA first said, if this sale is subject to U.S. Department of Treasury's Financial Crimes Enforcement Network FinCEN reporting requirements, seller and buyer will provide to escrow documents and information to comply, blah, blah, blah. Any charge for gathering will be a buyer's expense. And then you can expect delays, is what they say. So let me see if I can get this shared.
It's probably not a bad idea to say there may be a delay,
To what?
to say that they would expect delays.
That's what I'm afraid it's gonna be.
Yeah,
after.
what happens from the time of the situation when it's a third party delay like that?
Times of
The
the essence.
delay, I mean, once you have the information, you can instantaneously put it into the form. The delay is gonna be that sellers and buyers don't give you, they give you 3 of the 4 social security numbers. Oh, I didn't have that other one, sorry.
So this is the paragraph that they were recommending.
That's pretty good.
So I can take this, we can put it in the minutes and see if it's something we want to work on. If we like that.
Yeah, Tony has me paranoid look over my shoulder that he's still here.
So if we like this, we can work on it.
Tomorrow at 1:30, because I gotta get to Fredericksburg, Texas before 5. You might be looking over going,
Goldie,
Tony, there's no
Right.
problem going west from Austin in the afternoon on a Friday.
So we
It'll only take an hour or so.
can take this lead in and put it up here with regard to the first sentence.
Okay, hang on, let me get,
but did we want to make it specific as opposed to just providing an example? I thought we were looking.
Yeah, so here's the example in the parenthetical that we added.
So I like making it live for other things. I think this is the first of probably others to come with reporting.
Well, in looking at this wording again, I was involved in the initial drafting. I don't like that first sentence because then you're going to raise all these questions. Well, what do I have to do to make it not subject to that? That if is kind of problematic. I kind of like more where we've got it now as an example.
I'm good with how you've modified it there.
Yeah, I'm good with this right here.
Yeah,
Mm-hmm.
less is more.
Okay, then I'm gonna strike this. And say.
that an additional sentence for paragraph 20?
It's B, so in our current draft, that's,
Okay.
it's
It will be a new paragraph 20B, existing paragraph 20.
it replaces what you see in blue.
Be replaced with. Okay.
Okay. Moving right along.
So I would like to tackle one other issue, then take a short break. So we all probably need one, but this can be quick. I think to wrap up the backup addendum working group, option fee. If you can go to that
Is
paragraph.
this agenda item number 1 we're still on?
Still on number one. No, it's actually four. Option fee, I think, should be made lowercase in the contract. Right, or the option fee. Right now, it's capitalized in it. Earnest money's not capitalized, and there's no reason but how we use option fee to capitalize it. And it creates an issue later on with how we use that term in the contract. So I would do it in the contract and in the addendum.
Okay, I was gonna say everywhere. Okay.
But we can look at it how it is in the contract, and if we change it there, then we know we can change it everywhere else, because we only do additional option fee there, and I guess we'd look at the amendment.
Yeah,
We'll just double check the amendment.
That's easy, Ron.
Yeah.
That's easy.
So, but for everybody, everybody can look in 5 where it's originally, it's not really ever defined. When we define terms in the contract, we put them in parentheses and say this is a defined term. We just come right out and capitalize option fee for the first time without a real reason to. If we do by analogy to the earnest money, we're not capitalizing earnest money. We're not capitalizing
Options
money.
lower in 5.
Oh, it's changed in okay, those are the updated forms. Okay,
Right.
so then we need to do the same in the backup.
Right,
Do that.
because this is all done except up at the top.
Okay. And I'm looking at our existing
We'll
forms.
consider this a global instruction to staff to not capitalize. Okay.
I wonder if we take a 10-minute break here and come back and try to march through to get out for tomorrow to be able to get out time.
Oh, we're not going? I thought we were going to 8.
Oh, man, all night.
Tony doesn't have anything better to do.
In my last meeting, probably.
I have Bunko at 7, just so I can get out of here to go play Bunko.
All right, 10-minute break. We'll come back. What time is it? 3:38. All right, so we're back on the record.
Yes, sir.
And we'll march forward with our next one. So we're going to, all right, if I just figure out where I stuck my agenda. I think with the backup, we're finishing up, actually, agenda item number 5, report by the working groups. And I believe we concluded our discussion with the backup addendum working group. Anybody else on our working group have anything else to add to that? Anything else from our committee, Diane?
I'm sorry, would you restate that question?
From our working group, any
Yes.
additional things you would like to go over before we move on to the next agenda?
No, I think we covered it very well.
Great job. We are an awesome working group.
Yes.
All right, so we'll move on to agenda item number 6, deferred items from committee members, recommendations. I had a couple in when I went back and looked, contingency about a buyer lease of another property owned by buyer.
Oh, let's move
I think
on
we
for
can
now. We
Put
can
that to the next.
continue pushing that one forward, yes.
And I think we can do the same for this one, the reinstatement of contract. We had that as a deferred comment of a provision allowing the parties to reinstate their current contract.
And I guess the question would be, is that something we do want to address at some point? Is it something we even could address? And the issue, just quickly, is that when the buyer and the seller decide tomorrow, when they didn't close today, that they want to go forward, we know in practice, it just happens. And then depending on which attorney you talk to, well, it's the intention of parties to move forward, so the contract isn't really dead. But what are we supposed to do as practitioners when we're not allowed to create any wording? So the suggestions that have come to us is that there be a form that at least to be considered, that it could be filled in with the agreement of parties to move forward and extend the closing date.
You can
Is that
use a
even
contract
something out
amendment just to reset the closing date.
No, we're
No.
told not to.
Once it's dead, it's dead. Then you have to
It's dead.
revise it or revive it to come back into being. So
And I-
Yes.
You're talking about after the time's lapsed.
Yes, sir.
And I
Yeah.
think another scenario is when the parties, someone terminates the contract because it's right at 4:59 PM in the option period, and then all of a sudden they come and agree, and then they're like, well, we're ready, we agree now.
And I want to circle back to Tony's comment. I see the wavelength you were on. If you missed the closing date, right now, the contract doesn't automatically terminate. It's whether it's one party elects to exercise their remedies to terminate the contract.
You
It's not-
could say, I'm going off, I think what you're about to say, you could say, no, I'll go ahead and close tomorrow and keep going. Or you can elect your remedy and say, no, I want specific performance, or I want to sue you, or I want my money.
Which is a separate issue from what we're talking about
okay.
here. And on that, I would just caution, because I'd like to put this book in there, of you don't have to agree to an amendment of the closing date. In title companies, in lenders that require an amendment at the closing date, to me is wrong. They are inserting themselves, and it changes up the parties' rights, because all of a sudden this buyer can have more time to terminate the contract under the third-party financing addendum if they move it to more than
That's
3
interesting
days
to
after.
say that. We can park that for later but I've had that happen to me personally on transactions at least a dozen times. The title company's like, y'all need to sign this amendment to get this to work out.
And it's not required. You have you can terminate. If you don't want to terminate, you just go forward. And if you are forced to change it, it's changing at the party's legal rights. But that kind of dovetails into the reviving of it's more of the situation Christy said of getting close to 5, not getting a response. I want to make sure I'm either going to get this amendment I want or terminate.
Sure.
I haven't heard back. I have 4:59. I send my termination. Oh, they respond at 5:30. We're good to go. I'll sign that amendment right now. And that's a dead contract in that situation. And you can't just by amendment amend a dead contract like that. You have to have additional language to bring it back to life. And so that's the provision I believe other states might have some clauses like that. It's not as easy as just saying the contract's revived, because it comes up with timing, and how do you put it back in place with all these things that have already happened that you may need to account for.
I advise my brokers that I represent, it's got about 200 agents, you just need to do another contract. Just, and you know what, it's even cleaner for you anyways.
The problem with that, though, if you want to be put back in the exact same position you were, if you do a new contract without attorney involvement, or you have a new effective date, you have new time to deliver money, you may have had the expiration of time that has done away with rights parties would have had, the option period, the other things that might be there. Now you can put no option period, new contract and stuff like that. But there's other deadlines that
Same
run.
closing date, Gil, your option,
Title objections. Oh, now we're gonna have a whole new period for title objections. That comes in. There's a lot more that you can't, to get it done right to the exact position the parties were in will take legal drafting by the parties or their lawyers to do that agents can't. And so I think the question is, do we have a form that can do that? And to me, it's always been difficult to have any one-off. And I'm always the leery side of there's a lot to address without
fact intensive.
being fully thought out and to put them there. Now, title companies all the time close deals on contract. I'll just do an amendment. They close it. To me, that's not proper. And if it's legally challenged, there's issues.
If I have a settlement statement.
I'd say once you close, you're done.
After it's closed, yeah, after it's done, but it's saying we'll just continue on, but then the parties. So what I think is maybe we form a working group on that, because we've had that request over and over. If there's enough interest today, I am personally on the side of where I don't think it's needed because of all these complex issues. And if they want to do that, they should really get with counsel. But I'm not opposed to exploring it to see if we can see what else is out there, because there hasn't been a full study of it. See how simple it is at the end to do that. But having it fully thought out more than we can do in a meeting, so we can take this long of, if we want to Diane's point, let's see if there's interest, and then see if we can form a working group from it. Is that summarizing kind of the?
Yes, perfect.
I'm curious if there's other interest or a feel of a need for something like that.
I mean, it does happen, but I'm with Tony. I just tell them that we make a new contract.
That's what we do
Contract's
too.
over. You just got to start over. And bummer that your timeline's messed up. Y'all should have
gotten together before 5 o'clock. I mean,
No, I think that's the best word.
Yeah.
Bummer.
bummer for you.
Y'all
You
should've
should have got it
figured-
done earlier.
That's
You're
your
right.
penalty. You get to relive, if you get to relive it, that's your penalty.
Yeah.
You're, everything's messed up because y'all couldn't coordinate or because,
Hey, Ron,
Does it
I
affect
just sent you
lenders at all?
something that I did many, many years ago.
no, it actually gives lenders more time to get ready.
I mean,
This
is
is
it, well,
great.
And
mess up-
sometimes they're the holdup.
so if you have approval that say lapses in 3 days and you go, ooh, we should have gone ahead and
Well,
gone forward.
Because you can keep your closing date the same, right? Like if your rate lock is gonna end, is that kind of what you're getting at?
Yeah, I'm just wondering if a new contract messes that lock up at all.
Just by the sheer fact of having the contract doesn't, but if you
They-
changed your closing date, it could.
Yeah, I would think
Yeah.
the close date stays the same. Otherwise,
Yeah.
the lender is just underwriting you and the property.
Yeah.
It's gonna hurt just reading
Well, I
it.
think there's more than one aspect
allowed to.
that could cause the situation. And I think it's worth having a subcommittee look at it, spending the time on it, maybe like, this is just not gonna work. Or I think this could work. There have been enough requests to consider it so that agents aren't practicing law. They don't make more mistakes by trying to rewrite a new one. And it's always happening at the 11th hour. They would just like to see if there's something we can come up with. And if we can't, we can't.
What if we tie this into a discussion we can get to a little more fulsome here, but will fit in nicely with that is the expiration clauses. We've had a request to add an expiration of contract clause and on counteroffers and pulled from prior meetings when others have sent in. I think it's a California form from a couple years back somebody sent in and some other things. But if we're doing a state study on these issues on reviving and expiration and clauses, maybe that's,
Doesn't
we can broaden the,
Doesn't commercial have an expiration clause?
I believe.
I think they do. I think they have an
standard
expiration
form.
clause.
Yeah,
Sure.
I don't like it.
Yeah, and I'm.
I think
that's
I'm
one
one.
too, and with how, especially how California does it with their numbering and how it does, it's the most confusing thing in the contract itself. It's a little better in the counteroffer, I think, but we could explore both those together to see if it's a dead end or not, because we do consistently get those requests.
Are you talking about now or are you talking about subcommittee?
Subcommittee, and looking ahead to going ahead and thinking a subcommittee be more than just the issue of the
Reinstatement.
The reinstatement would be the expiration clause too, because they dovetail good.
This is right up your alley.
I'm in. I'm on
All
that one.
right.
All right, got the attorney involvement on there.
I got one.
I'll help.
Oh, that'll help.
Okay, so we got Tony, Diane. Andy. And so we'll call that the expiration, or what do you want to title your subcommittee? You get to, we ran into the backup.
Oh, is it your
subcommittee.
No, I don't think so.
He's
I
looking at
thought it was
you.
Well, we have
Diane,
reinstatement of a
good idea.
terminated contract.
Name and you get
The
name.
reinstatement committee.
Reinstatement committee.
I like
Big
that.
There you go.
The
Tony's
old Tony,
reinstatement. Nice,
Big
Brian.
Tony.
Nice,
Big
big Tony.
Tonys.
Big Tony.
Okay, so I better put those down here.
So who's all on the committee?
So it's you, Tony, and King.
You're getting out a lot of them.
Yeah.
She's bored. She has nothing else to do.
Yeah, right.
Christie didn't want this one.
I think I like the design one. We're on the design one together.
The what one?
And, well, I don't know
So
what
the
the word is
formatting or
called, the
design.
formatting or form
Yeah.
design or whatever.
The pretty contract. The pretty-
Yes.
Yeah, we'll make
The
it
Big
pretty.
Tony
We'll make it
committee.
Each contract will be a different color.
They might be pink when we're done.
Oh, Candy and
I am kind of
Diane.
partial to that color.
I can never spell Candy's name.
It would be funny if it was all color coordinated, depending on what it was.
Everything in my life is very color coordinated.
Pick the pink one, pick the green one, pick the light blue one.
When going through the contract for other purposes, you'll laugh. I forgot how many highlighted colors I have, but we have about 110 distinct concepts in the contract that I picked out to to break out into little subparts, or maybe up to 120 something, just in the 1 to 4 contract itself.
You should send
It's all color coded in different ones.
Oh, my God.
Oh my God, once we change these language, you're gonna have to flip out and redo all your colors.
It's scary adding new concepts to the amount of colors.
Wow.
I borrowed my daughter's set. Okay, so we got that. So we'll pocket those. The reinstatement will go to the subcommittee. We can tee up, well, I guess we can go and say now, if you can, the materials I'll give to the subcommittee as well, that from the prior meeting. We had somebody send in, I think it was California form, maybe some others for the expiration clause. So I'll send what I have there to you.
Colorado has one.
Excuse me?
Colorado has one. And
For the
Utah has
expiration
one.
clause.
Mhm.
So yeah, it's come up a few times in our past meetings. So maybe I'll find
I think our
some.
subcommittee should take a trip to Utah to
Oh.
investigate, don't you?
You're ready. I'll give you the keys. I got houses over there.
Oh,
So,
got a witness. This is off record, you know.
Well,
Yeah, I don't care.
I think we can get into the comments next. If nobody else has any deferred comments or.
Well, what is paragraph 12? In comments?
Yeah, so paragraph 12 and water disclosure and Brian's issue, we're going to reserve probably for tomorrow.
Tomorrow.
Maybe
Okay.
start paragraph 12. Now, how much debate, let me tee this up. How much debate do we think we're going to have on paragraph 12? I'm not anticipating as much as we originally.
I'm not anticipating anything big with paragraph.
No, I was probably the
I
biggest
thought we
disruptor
were-
there, and I don't think we're gonna have as big a debate.
Oh, you're changing your mind?
I'm not necessarily changing my mind, I'm just reading the room and thoughts and
Okay.
stuff.
To make sure I'm understanding on paragraph 12, it's just really tweaking, looking at what we had originally tweaked.
Well, I was introducing the concept of farm and ranch again.
Oh, that's right. Okay,
Okay.
that's right.
Different ways.
That'll be a good wake up in the morning.
But I don't think it's going to be as drawn out as we
Okay.
thought, because and we may do it, and if so, then I'm winning more people than I thought. So, I think that will be more punctual, and we can probably start on it today. I think the comments we can get through fairly quickly, and so maybe.
First one's Melissa.
So let's jump
I
in.
just forwarded something somebody sent me.
Well, I think it's a good one. I mean, if you really think about it, because it's termination on a condo and it's not for the HOA on a condo, and there is no line for that.
What PDF page? is that?
So what's the issue
Page
too,
2.
though? Because paragraph 4,
I was around 180.
Page 2.
The comments are usually at the end, so.
Page 2.
so the solution, clearly, 4 is not meant for condo termination. You don't use
Correct.
the POA. You wouldn't be in the Property Owners Association addendum if you have a condo.
Right.
And so if I'm not sure I fully understood exactly the position they were in here, but you shouldn't use it, and it's wrong if you have that in there to begin with. Is the issue more of we need something for the condo terminations, or what's the?
That's what I'm seeing, is that they're,
Well, I mean, or maybe they should have used paragraph 8 and written it in, right? Because her comment when she sent it to me was, we can't use box number 4 because box number 4, although it is for mandatory membership in a property owner association, it's talking about paragraph A of the addendum, right? And which we don't have. And then she mentioned in there that you also can't use 7. You can see on line 7, it does mention a different section for condos, but the section for condos says buyer elects to terminate under paragraph 6D of the contract or 6C for residential condominium contract because timely objections were not cured by the end of the cure period. So if somebody wanted to terminate because they didn't like something in their HOA documents on a condo, would they just use checkbox 8 and write in the paragraph in the condo contract?
Yeah.
I believe that would have been the right answer.
Assuming they did, or that's why they're terminating. To me, it sounded like they actually had the POA addendum for some reason, and we're trying to fit it in. But no, that would be the answer properly if they were terminating under that.
Yeah, well, she put on there that they saw the condo docs and decided to terminate over HOA. That was bullet point number 2. So something in the rules and regulations or whatever in the HOA documents, they were like, we're out. And they should have put it in
paragraph 8 under other and just typed it in.
Right, so does anybody feel like we need to add based upon this?
I'm also saying in here, though, it looks like part of her comments was that maybe we should state something on the POA addendum that it's not for condominium use.
Well, and that's where that's right up from the beginning, right? It sounds like they use that form and it's not, shouldn't have been used, so that's.
No, I think they're saying because it's in the condo contract, they're saying the termination form here we have does not allude to the condo contract.
It's not in the condo contract.
Right.
She tried to shoehorn paragraph 4 as a way of communicating termination.
Because of HOA.
Because of HOA. Yeah.
Right.
Right. But I mean, this says that they terminate the contract. So
Well,
they may have checked the wrong box.
Well,
and she did put in here, I don't think we want agents writing language into other, but I see no other place to terminate. To accomplish what this goal was, would have been to write into the other
two
paragraph, right?
It's in paragraph. There's 2 subparagraph 2s.
B and C. Yeah. B is for documents and C is for the certificate. So we have 2 termination rights there that are both statutory and included differently.
So I think the question is there enough terminations under paragraph 2 in the condo to add that into the amendment form? I don't know if there's a real need for it because it's the first time we've received a request for it.
Because if you look at the condo contract, okay, what it's saying is they have so many days to agree, get the copies, and buyer may terminate if there's something they see. And what I read this was, okay, I now want to terminate, but I don't have a form to terminate.
Right. You're correct. That's the way I read this.
Okay, so.
So she then checks 4, thinking that that's effective enough to terminate. Frankly, it may have been, but it doesn't. So I think the ultimate question is, do we add paragraph 2 of the contract form of the condo forms into the list of the amendment reasons to terminate? I'm sorry.
Number 8.
Or check 8.
A lot of condos in here. No, it's.
Yeah, there's a lot.
You do a lot of condos. You do a lot of condos.
Our area has like condos in the Houston area, yes.
And has that presented itself as an issue about not having a form to terminate under that?
We would just use other and it's not that you're not writing language or law, like you're just citing the paragraph, just like it is right now. And it's just, they're out. The buyer's finding whatever out, paragraph A, E, B, C, and just type.
So you've been writing it in number 8. Okay.
So maybe we just monitor this being the first time we receive this to see if it presents itself to be more of an issue.
So she's right because it just says buyer and seller terminate, or
you're just citing
buyer notifies seller that the contracts terminate because of whatever.
I just think it's interesting. The other agent wouldn't accept number 4 because I think that's being a little picky, but that's
a gotcha move.
Okay, so we'll monitor and see if that presents itself more. Comment there. So we'll move on to pages jump here. Got out of order. So we were on page 2 there. Our next page.
Brian talked about the as is and stuff.
Yes, I think we're going to hold the next.
Okay.
My computer is working.
The as is and everything.
So this is a good discussion, and this preview, Brian has come up with the first viable solution to at least discuss the problem that's been my soapbox issue for a long time.
Okay.
On closing date.
We just did.
Going to channel other people vigorously.
Yes.
So now page 27.
I'm bringing SJ in.
So 27, we start with
Colorado right now.
let's see, Dale Lucaba's comment. He wants more than just all or nothing option on the sale of other property addendum. He wants to add 27. He wants to add an option for contract to terminate if other property is not under contract by a certain date. So right now, it's the contingency is receipt of the funds from the sale of the other property. You would like to add a trigger point for, well, not only receive the funds, but you got to get it under contract by X date. I've had that request before, and I'm sure if we received it on the committee before, but we suggest some possible, there's that my language, some possible language on what to do about triggering it. So let me phrase it first. Is this something that you've felt like you've needed before? Have you heard requests for this before? Do you think it's a good idea?
I always ask that question. And if they don't have it, if they don't even have it under contract.
Yeah, we asked the question on when do you plan to get it on the market? What are you planning to list it at? What are your...
Send me your comps.
Yes, we do all that, looking at the average days on market. And then you set the date. I know they have to have proceeds, but if you're taking the chance on going into an addendum for sale of the property, you look at the timelines based upon the comps and the data, if it's not already under contract, to then determine how much time you're going to give them. I don't know that I've had this request or seen this request before. It's interesting because we just do more research up front to determine if our seller wants to do that after they have all the
We're
data.
gonna accept it. I mean, that's what,
Yeah,
Because
a
it's
lot
the
of sellers
seller-
don't want to take it unless you're already
Already
under
under contract.
contract, and some of them want you all the way through the option period, and so,
Mm-hmm.
but as the market shifts from one direction to the other, right, some sellers might be like, you know what, just anybody, let somebody buy this house.
Yeah.
and that's the whole scenario, that if we're gonna go longer on the market, are they willing to go into a contingency with a
They
house
just
not
need to
even
know
being
their risks.
on the market?
Yeah.
I mean, it's giving the seller an extra right to terminate is what the request is gonna do.
Mm-hmm.
Right.
The
It's going
seller
to
and
move it up earlier.
Which we don't have very many rights for the seller to terminate under the contract. So do we want to give the seller another rights, really the question?
And I look at this as somewhat what we did for the backup addendum and having stage earnest and option money to a certain degree, right? It's completely different, but same concept of having stages of termination. Or you have to be under contract by this date, then you have to get the proceeds by this date. And so if we added a simple thing in of just saying these conditions must be met, you don't have to fill it in. You don't have to say it has to be under contract by a certain date. It gives some, from a seller's perspective, they can go back on market quicker, right? They don't have to be burdened by this contract quicker. They can say, you have to have it under contract in 2 weeks. If not, I'm not going to be bound for another, give you another 2 weeks to close, or, 30 total days. It allows them to chop it down a little bit to say an earlier reasonable date that's black and white.
So, but with it still being a kick out, they can still kick out the other contract, which is my other thought process on that. Of course, some people are leaving the kick out days and all of that blank as a remedy on the buyer side for that. But it's still a kick out. So they can still kick this contract out if another buyer comes along, and if that agent is still showing the property, marketing the property, doing all of the things, which is what we do, continue to hold open houses on the property, even while it's under an addendum for sale of other property.
That's a great point, because we already have a separate kick out that could be
Yeah.
used.
There's already that, remedy there.
I'm not opposed to it. At the same time, I'm saying that I do think that there's some different conversations around the seller's expectations and how long are they really doing a lot of due diligence around looking at CMAs and comps and all of that on the property that is listed on the sale of the property that they need the proceeds from.
Let me throw it out a little differently to talk through the perspective from a seller trying to sell the property to another buyer. When it's burdened by a contract already, how much does that turn away buyers from
A lot.
making it? So having
A
a
lot.
kick-out provision maybe mitigate it by, it's not as marketable as it otherwise would be if they could just toss it out.
I mean, unless you're under contract, my guys won't take it because why? It's taking them off the market. There's a
Even though
contingency.
it's in a kick out sort of status,
A lot of people
buyers
don't.
have a bajillion choices, which is where sellers are gonna be like, I'm trying to get this done. Buyers are gonna have a lot of choices. They're not digging deep enough. They're gonna be like, what's the easy low hanging active properties, not what's already under contract that I can go maybe scoop in and get. And agents aren't giving them that much information, you know what I mean? I mean, generally, it should be still on
Zillow or Realtor.com or
Should
whatever
be.
the portals
They should still be
are.
marketing the property unless the
Mhm.
sellers advise them not to. Other pieces is though, if there's this provision, what does it do to people? I mean, I know it should hopefully encourage them to sell faster or price in a capacity to sell faster if they really want the home. But does that dissuade people from even doing an addendum for sale of the property? So I'm just looking at all sides.
And I've personally experienced this with one of my wife's transactions here recently, and they were trying to put this exact provision in there. And that, I always keep a distance here, not to get involved, but they were trying to do that and put down counsel to get done, and that was a problem.
Yeah.
So I haven't seen this personally, and having a request, I don't think it's a bad idea. I think it's.
I don't think it's bad.
Market, right?
I think they need a law firm that helps draft special.
Self-help. So.
I do have a client that would have wished that we would have had something like that last year. She was stuck under contract forever while those people couldn't get their house under contract in Montana or wherever they were moving from.
Well, you also accept a term.
Yeah.
So I mean, if they accepted a 6-month term, that's her accepting a
She did.
6-month term.
She did.
Yeah.
And
I
then
mean-
she wished she hadn't halfway through it. And I was like, that's what you decided you.
And I mean, the seller could do it
it.
30-day term
Yeah.
and extend it if they had to.
Yeah.
But I mean, the seller could control.
So how
Yeah.
would
The
this
amount.
option actually work though? What do they mean by an option?
So the seller being able to say, right now the seller either has to get another contract in and execute it to do the knockout provision, or they have to wait until this date that the buyer receives the proceeds. What would be done would be to add another option, a third one, saying you have to get this under contract by X date. And so it adds that extra contingency for them to be able to say, I'm terminating this contract with you because you did not get the other property under contract by now.
Yeah,
And
they
maybe
call
they-
their friend and say, write a contract, so,
That's it.
yeah.
And then when I,
Proceeds means something to the seller. Okay, I'm gonna get the money. They can extend it. That's their option. You can renegotiate because I didn't get a backup offer. So you want to extend your option because there's a date in there, how long it's gonna last. So that already is an option.
it's a,
And then what happens if that first contract
Falls apart.
out?
I just thought that same thing. When she said, my friend's just gonna make an offer, I'm
Yeah,
like,
that's-
oh no.
well, you
Yeah.
still had the backup of not receiving the proceeds. So
Well,
yeah, it would be
sure,
the
but
double
then
trigger
you're-
point.
But
But
then there's
you-
still the further, if there's a different timeline for the receipt of the proceeds, or
Which
does
would
it
be-
automatically, if that contract falls out, then the seller automatic, there's a lot of pieces to that.
What if I take
And then
this
what are you gonna do
on,
with the earnest
I'm not
money?
sure if we need a subcommittee unless somebody wants to join me on it and we can put a bucket together of getting some language we can consider for the next meeting on this.
I'm
of
open
it
to that.
Having something where we can see what it would look like to continue it that way. But I do think it's an interesting concept, and
It
having
is.
lived it here recently would be good.
And it
then-
could be interesting to look at something and how that would lay out.
And with the market changing, it could, I mean, we don't know what's gonna
We're
happen.
doing a lot more contingencies, that's for sure.
Right,
We see a
more
lot of-
contingencies are happening.
Ever since the pandemic, that form that had not been touched by anybody is out there all the time, even during the pandemic. I could never understand why.
Okay, I'm not gonna get down the bunny trail. I was about to say, bring up, there's two other related concepts that we've been requested to this. but
Well,
I'll reserve
that
for
goes
next
down
list.
the provision for the lease, the contingency of release of other property, which we have seen because some people do need to lease another property or show proof to a mortgage company that they have at least in order to buy. That is part of that too, yeah.
And once we get down to there, it's almost like, do we want a subcommittee to group it, but because it adds that, it adds the leasing one, then it adds the finding another property by seller. The seller needs to go find another property in the old market that we were in. And so those three concepts kind of overlap.
All kind of come together.
Yeah, for sure.
Um,
Agree.
Good old 7D.
and seller. So I'm gonna put those three kind of as a group, and if anybody by the end of the meeting decides they want to join me, I'll be glad to take y'all on. Okay, so we'll go to the next one, Mark Inman. It discusses the as-is language. And he says paragraph 7, the real estate contract clearly states that as is does not mean as is. And I don't know if I agree with how broadly he interprets that statement. I agree our as is statement is not, there's a lot of holes in it compared to the common understanding of as is. Direct misrepresentations get around the as is clause in many cases. The sophistication of the parties get around some of these issues. And, you know, for us, he wants us to add some more color bounds around it, and describe it as is, as visually observable, right? Some of the other options. And he says it's like buying a pickup truck when or saying it's a pickup truck and environmentally is buying a sedan, right? That to me, there's already remedies in the law for it, right? That's a misrepresentation. He has his clause, you can go after him for that. That's that bad of a representation. In wanting to stick with our statutory directive on this, though, of minimizing controversy and, you know, expediting real estate transactions in particular, and bringing one thing that's not expressly mentioned, but is kind of subsumed in those, is bringing finality to contracts and finality to closings. I'm not in favor of making a change here. I think the contract, if we were to qualify it anymore, would just open more controversy, open more disputes when there's already these other remedies that are available in the situations like he's describing.
Because he's also talking about for 7D2, and if you have a main issue, I don't care if it's electrical or whatever, and you don't have to wait for you don't want to wait for your inspection, you can put that condition in 7D2, right? With no problem. And that's how I always teach it. These are conditions. If the buyer wants this done, do it here. Don't wait for the amendment. And that will get over that.
And we'll have a case later to discuss the Primavera case that goes into disclaimers and the ability to disclaim different items out of the Court of Appeals of the 14th District. But I'll go ahead and tackle this one since it's part of the materials. It analyzed some of these exact issues. This was a case as a commercial sale, but the buyers claimed the seller promised that a hotel will be built on this development. Right. And the issue with the hotel being built, there's other tenants. And one of the tenants' lease is an Outback Steakhouse, I think. Their lease said, well, you can pay 50% of the lease payment if we go ahead and build and lease until this hotel is built. And ultimately the hotel wasn't built, and the buyer said, well, hey, you said it would be built. I bought this thinking the economics of a fully paid lease. And so to adjust it, you know, I wouldn't have done this otherwise. There was a beefed up as is non-reliance clause that wasn't just the boilerplate language of the contract. It went into more detail. What's great about this case, and ultimately at the end, the court held the waiver of reliance clause was effective. That the buyer, because of, you have to look at the facts of each case, but based upon the facts of these cases and some of the issues I'll bring up here, we're finding it is enforceable, and the buyer couldn't have reasonably relied upon any statement made about the hotel. And they looked at how the parties were talking about it, the fact that the issue actually came up, and they talked about the lease payments and how to address it, amendments in the contract. But the court noted too that has to be examined alongside the facts to determine the case. And some of the big ticket items, which they list out, great case if you haven't read it, to go read, because it really is good to understand these as is clauses. They outline some of the factors, and I believe there's 5 factors they outlined. The terms of the contract were negotiated rather than boilerplate. And this one, they added stuff in. The parties specifically discussed the issue that became the topic of the subsequent dispute during negotiations. That happened here. The complaining party was represented by counsel. Right, this one in residential was, we're looking at this, right? We have boilerplate language, not represented by counsel. We can dig in a little bit. Or the complainant, the fourth one, parties dealt with each other at arm's length transaction. And the last one, the parties were knowledgeable in business matters. It's kind of a general thing on enforceability of a disclaimer. A little different context than as is. But once we start adding qualifications in language, it invites more disputes. It's already some remedies to go against with direct misrepresentations or potentially otherwise to get out of it. And so all that being said, I don't think we need to make any change.
I wouldn't.
Any other comments, or Tony, you want to jump and ask that and then?
No. I'm saving all barrels for Brian.
All right. I'll take that and run then for the next one. Next one from Matthew McKeithen, about the mineral reservation, referred by Kirsten Crawford, who's here today. Would love to see an option to reserve minerals on the actual contracts and not as an addendum. And even I'm not in favor of sticking it in every deal because it's not many deals that actually have it. It wasn't Kirsten that requested it, she forwarded it on.
Oh, yeah, but it's just a whole, as we've talked about, as SJ yelled at me last time I brought up oil and gas addendum. It's so complicated, oil and gas. We've got it and as some kind of format to work with. We're never going to be able to convert the volume of law, the complexities of it to an so that y'all can practice law essentially using form in a single page where you don't have to, I mean, it's just, we're probably as good as it's going to get.
He wants an on-off, basically. They are or are not in every contract, and that to me invites controversy. The default rule in Texas, if you don't say anything, they can pay. And so I think we can move on from that one there. Thank you for sending it in, though. It was based upon Kirsten saying, send comments in during the process. Jeremy Reed, price adjustment paragraph based upon an appraiser's measurements. I've actually had lawsuits on this, but I don't think we want to do anything like this.
Appraiser measurements?
So saying the contract price will be adjusted on this what he wants, but I've had the appraiser measurement things come up and both suits against the person's own agent, the seller's agent, listing agent, saying you didn't tell me about these other things, or you had knowledge about a past appraisal when you listed this property with somebody else. And you're listing it with me now, and you'd still listed the county appraisal districts, not the appraisers, or it's come up in a couple different ways, but it's actually touch it. But yeah, so I wouldn't touch that. I think that's inviting controversy there.
How'd it come out?
Good for us, but it wasn't litigated through to test the issue.
Yeah, there's a court case where the square footage came in low, but the appraised value was over the sales price. So it depends on whether you're making a breach of contract claim or a misrepresentation fraud claim. So the facts would be all over the place, and to try to draft a remedy for that situation, that's pretty much impossible because it's so fact specific.
Yep. Okay, so next we have Jing Harlan. Request relates to seller's disclosure notice to add a generator next to AC on page 1. I think this actually is a good thing to bring up, though, for our accessories part or the fixture part to look at adding this, because it is very common now to have a generator.
Definitely in Hurricane Alley.
And if we can list it somehow in there, it's so common. I think it makes sense to include it.
I think it's a great idea to put it in. I don't think we can put it in the seller's disclosure, and I think technically it's an improvement to property anyways. It's usually put on a pad, it's attached. I don't see how they can take it with them any more than they can take the air conditioner unit, but it doesn't hurt to put it as an accessory.
Or the water softener.
I actually like the improvement because the accessory, my concern was I have a couple generators at the house that are on wheels and I can move them. And so going back to accessory, when my first was going, I thought, oh, it's really improvement because we're talking about the ones that are built in. I want to talk about what's in my garage that I will allow.
Two things. Number one, we follow whatever the legislature does. And if the legislature wants to put something in, the seller's disclosure.
We sure tried to, at least.
But number two, I don't know the facts of this case, obviously, but it's a patio home, and she said it's the next door neighbor's generator, but it looks like it belongs to sellers. And this is probably one of those zero lot line situations where the next door neighbor has the exclusive easement for the entire strip of land between the two properties.
Yeah, I think John and I's comments went probably beyond what the comment.
Exactly, yeah, we took her idea and spun it to something that actually.
So
I understand where she's coming from. For other reasons, we don't think that's a good idea.
are we adding that then in a specific place, the word generator?
I think 2B, if you look at adding that in.
Is that where water softeners are?
It is, yeah, right here is water softeners.
Okay, yeah, it needs to be in the same place as water softeners.
Well, we're,
To
I
be,
guess for the minutes, do we want to specify where?
Yes,
to be.
we're in the list of things. Maybe next to the heating and air conditioning units. We're down outdoor cooking equipment and outdoor, I'm not sure it really matters. This is, as long as it's listed.
Oh, you want to just then leave it up to Abby? Okay.
Well, improvement seems like the place because it's in bold, permanently installed and built-in
Yeah.
items.
I mean, it's the same thing as outdoor cooking equipment or cleaning equipment. I mean. And maybe an agent would see it. I had one that didn't even put it on the non-realty item. They had no idea that it was, even though all over the MLS it said, house has it.
Have there been problems at all with generators being disconnected or anything?
No, I don't, I mean, mine have just been, they weren't identified, so I had to have them identified that they were going with the house. But if they're in 2B, I don't have to identify them.
I've seen it on non-realty before when really it's with how those particular generators
Correct,
were.
that's what I'm
they show
No,
up.
the seller wanted to take it because it was so expensive.
So then
Well,
if
then
it
they
was
can
in there,
exclude it.
then they exclude it. And so they can
They can
do it
exclude
properly.
it, yeah. I think it's important.
All right.
It's commonplace enough.
Yes.
Yeah.
Okay, let's go to. What do you want? Is it the- I'm not sneaking that in.
Somewhere else. Put it elsewhere, right.
See where we're at here.
Well, 31's 12A, so it's talking about 12.
Okay, so we got these. Keep in order.
So that's tomorrow. Yeah, because that's all.
Oh, was it Tracy Hammond's comment?
Yeah.
Yeah, page 34.
So Tracy sent in a comment that's coming from a really good place on compliance with FHA and bringing up the title of our 1 to 4 family resale contract and brings up the use of the term family. And he has a thought out rationale here of familial status being a protected class within the FHA, in mere exclusion of having family in there to be weaponized. About the training, clarifying what family refers to in the title, perception of bias on its face, and is no longer a universally descriptive home of a household composition. And provides a proposal to change it to unit. He's we strongly recommend revising the forms of 1 to 4 family residential, 1 to 4 unit residential contract resale. I do have concerns with this from a couple of different angles. I know it's coming from a good place, but with how we have right now, I went to look on how it's used. The house of family used in the FHA, how's it used in TRELA and TREC rules. We have a couple places family appears in TRELA. The definition of a broker contains in 1101.002. It talks about that in the new 563, the new Senate Bill 1968 uses the term family in the definition of residential real property under the brand new statute. We had a couple check rules about when a license is required, 535.4, and then we have 535.56 with experience requirements. It, I think, kind of ties in, but there's other places within the TREC ecosystem that we haven't mentioned. The FHA also itself uses family. FHA has a definition of dwelling, and a dwelling means any building structure which is occupied as or designated or intended to be occupied as a residence by one or more families. Family, it has it then specifically says family includes a single individual. So the FHA addresses the concern by saying a family includes one person. And then there's FHA exemptions that refer to single family houses as well. Go a little past that, a lot of the zoning laws and zoning things refer to single family residential. And so all that being said, to tee it up, I do think it's a noble request. And brings up some issues that are misunderstandings. I think misunderstandings go from what the underlying concerns are. And with changing it to unit, what so there's a condo unit, right? Of it being connected with condos. So I wouldn't recommend a change at this time, but I do get where he's generally coming from.
Well, I think it's a really interesting observation on his part. And my question might be, why can't we just call it residential contract resale or residential resale contract? What is the reason for the 1 to 4?
So the 1 to 4 is tied to several of these legal provisions that trigger certain requirements. And having the 1 to 4 unit, for example, the new Senate Bill 1968, you have to follow these things with these type of things. And this is what the contract you have to use for those circumstances that have built-in protections related to those type of transactions. And when does it become something just more than 1 to 4 units? You have to, not only for our contract, you use something else, but there's other issues that apply or may not apply anymore once it gets past that. So it's a threshold that could be changed lightly because it can only be used in those situations, some of which specifically mention family. So that's where the issue comes in of having these other things that define what residential is and whether it's zoning in particular places that mention family. If we make a change here, does it complicate things more than it would help solve? And so I think if we were to make a change like that, we really have to dive into what will this be impacting beyond just the titling of it? Does it confuse things more and not align with how the general practice has been to use family in this context? And again, with the FHA not having even changed their wording, FHA still use family. They just say family can be a person. So it's been more of an identifier than it has been a descriptor, I guess.
And maybe it's old fashioned or maybe it's time to consider. I mean, I think it's a very interesting point because the use of the word family has a lot of connotations and it, for a single person, they're not a family. Is that
Are they?
FHA.
A single person is
According to
under the
FHA, they are.
That's where the definitions can be coming to concern. And I like it says why we should be the leader, right? There's no reason TREC shouldn't be the leader in changing it. And just because everybody else does it. And that's where, because of the lane that it fits in with these laws that without having done a detailed analysis saying this provision's tied to this provision's tied to that. Some of them talk about dwellings. Some of them talk about, single family residential houses. Some of them talk about these different ways that the title we use fits within the system. If we were to change the title, does it not fit tied directly within the system? It would still be used for that purpose, 1 to 4, whatever. These units is the one thing that concerns me, in particular with the condos. But I don't know. I think it's a great request, and God, it's something I think we have to be careful going into.
I think this is a work group really in-depth study because whatever we decide to do, it's going.
And
I'd like to defer this one actually, because I don't think there's any immediate need for it. And then maybe once we get through these couple big revisions dealing with paragraph 12 and the water disclosure, is look at renaming all the forms at one time.
And I know Tracy's very passionate about this, and we were going to try to talk before this meeting, and because of schedules and trips, we weren't able to. So I'm sure he would be there excited to help tie those provisions together to help me get over my concerns about we change it here.
Yeah, I don't think this is going to be as monumental of a concern, but I do think it needs to be a diligent thought, which I think this is at this point in time, this is I think going to take us away from some other things that need to be addressed.
Right, I agree.
So I'll get with Tracy between now and next meeting and pick this back up. Okay.
Militia.
Okay, this is the offer expiration clauses. And so I think we can put this in the subcommittee and this comment, again, I'll send those prior materials that I have that can add to this in the earlier meetings.
And she had some other comments in there that don't pertain to broker lawyer, and I'm gonna just assume that Trek staff has submitted that information to broker responsibility working group or whatever, right? Yeah.
Okay, so that goes to 30. Where's our next one? Okay, so that goes to the contracts, and then I believe it's just the case law. After, I don't believe there's any comments after the.
So I was looking, is there anything at the bottom?
So I think it went into case law.
Yeah.
So we're just deferring Ms. Rochelle's.
Yes,
To the
it's a
subcommittee.
subcommittee.
On which
The working group.
working group? Okay.
This one, what do you call it? Termination.
Or the termination group?
Expiration.
Reinstatement.
Reinstatement committee. Okay, got it.
Okay. So that concludes our discussion possible action regarding comments received on contract forms since the last meeting. And so we had the recent court cases. And we've already talked about Primavera. The first one we have on page 119, the Endeavor case. The takeaway from this case is when a right is conditioned upon a mutual agreement by the parties to a certain act. Here, let's get what the case was here. Neither side is under an obligation to agree to that condition. This was a seismic condition. Parties said what certain actions were contingent upon doing these seismic operations, contingent upon agreeing to a permit for those seismic operations. So they had this big contract about the seismic operations, so we had to agree to the permit first. One side said, I'm not agreeing to the language. And the other side said, well, you have to agree to something. We said here, we got this big contract, it's conditioned upon this. You can't say you won't agree to this language. The court said, well, yes, they can do that. That they didn't say you had to agree. It's conditioned upon agreeing to it. And if you can't agree, then you can't agree. And the contract effectively can be terminated. You can't conduct these seismic operations until you do. And no party is forced to here. What was used here in particular was only after language. So the right to conduct the seismic operations arose only after mutually agreeing to the seismic permit. And the court held only after it was not ambiguous. And it pointed to other words, and where it's instructed to us is we're looking at how we use words of terms such as if, provided that, on the condition that, normally indicate conditions. And the use of the term here, mutually agreed, did not require either side to agree. So if we're using if, or if we're using these conditional words, they have an impact and they're analyzed. And it's a great case to look at how, in this particular case, they do.
You better put a clause that says if you cannot mutually agree.
Exactly. But lawyers like to fight, and words matter at the end of the day. It's a good one. Let's see, the next one, 143, we already talked about that. This is the Primavera case. The next one was an interesting one. I had a little bit of personal connection to discussing this case. It involved the Texas Realtors buyer representation agreement. There's a dispute over this, and this is a good one for all the brokers here to pay attention to and to understand the issues. And some of the issues could have been easily addressed, but it's a common one that we see. This was a case in which the buyer's representation agreement left the the market area blank. And the intention was for it to be the entire state of Texas. But in testimony, and it came out in the evidence in the case, was the market area was in Austin for the original buyer rep, the people that were involved in this. And it was a case assumed over a commission. What happened, the buyer signed his buyer rep without the market area filled in, put an offering on the house, and ended up terminating that contract. In the meantime, they hired another agent down in San Marcos, put offer in, and ended up closing on the San Marcos house. And the first agent said, wait a minute, it's going to be the entire state of Texas. Even the testimony said Austin. So the court said, you testified that it was Austin, and so the market area is Austin. So at that point, the court said, well, how are you entitled to a commission? They had first argued in the case, well, I'm entitled to the commission down on the San Marcos property. That's my damage. And the court said, well, no, there's no causation there. If you don't get that, it'd be what you would have earned over here to begin with. But there's issues over here in Austin because they had the right to terminate that contract. They were in the option period. They didn't have to close on. There was no obligation for them to close. So there's no causation there either, right? You can't, if let's say never purchased anything, you would be entitled to commission. And they were able and allowed to terminate this contract. So the court found, analyzed it from a couple different angles there, and I may be ad-libbing a little bit, knowing more of the facts of the case. But what's really important here is the language. The language has since changed a little bit in terms of market area. In this case, this was 4 years ago or so, but it didn't change in the fact that the market area is still blank and doesn't have a default. It says market area defined within these terms, or in this case, for a person acquiring property in the market area, which is defined as that area in the state of Texas within the perimeter boundaries of the following area. Now it has, identified by street address, city, whatever the language is now. So leaving it blank leaves it ambiguous, and will leave a court to later on determine, one, if it's enforceable, but two, to determine what the market area is. So it's a risk management thing of why that always needs to be filled in. And when you intend it to be all state Texas, that's gets into other issues about geographic competency and fiduciary duty issues, but just easily could have been addressed here by having it filled in. And that didn't happen. The other causation issues are interesting, but a little more detailed and not as simply a blinking light as that. And so I think I covered all the items. Have anything to add on that one?
That was a case that was like, fill in the blanks.
Fill in the
Well,
blanks.
and the new buyer's rep says that. It says basically property address, subdivision, city, county, do not use it as state.
Yeah, but let's say you don't fill anything, just skip it.
Okay.
That's the issue here, and that's the same. The new language is the same as the old in that regard. If it's blank, you're still subject. There's no if blank, then it's the state of Texas, or if blank, it's within this many miles of your office, and so then it's an issue of a court determining later on what that market area is, and they could find it's within the neighborhood. You just talked about the neighborhood, so we're only enforcing it there, or the city, or the region. If somebody later on be telling you how broad or narrow your buyer's rep is if it's blank. And I know there's been other suggestions made to Texas realtors about the language and stuff, but for now it's still the same that way. And that's all the cases I believe we have. There's any other ones that are related of interest to bring up? Okay, and then we have, we'll tee up. Do you want to go for another 20 minutes and stop at 5 and start teeing up another one of these issues?
What are you gonna tee up, 12?
We can tee up 12.
Let's tee it up. You were very optimistic that it might. I'd rather go 20 more, 30 more minutes here than tomorrow.
Let's do, well, maybe I'll address it today. We want to pull the 12 language that we have revised right now.
Okay.
So while he's pulling that up,
You might shock me here.
Maybe.
I go back to the very first content. I believe that was the real contentious meeting. When we made this change, right? We went on paragraph 12 And it was at a point where we first were discussing Army Ranch language, style language. The vast majority of the comments, I say vast majority, we had the majority of comments we received were more in favor of farm and ranch than other language. And at the time, we were one vote away, it was 6-7, I believe, at the time, that we weren't there yet to consider it, and we had to do something. So we moved on to what ultimately became paragraph 12. I think the reaction we first got to paragraph 12 to now has come a very long way. We had a lot of pushback. The industry was still changing. I think as it's been in use and as discussions have happened about how maybe the industry restructures and how they're offering compensation, both, between brokers and the discussions with buyers and sellers, that has changed as well. That votes more in favor of this paragraph 12 style agreement. But we would be doing a disservice if we didn't revisit, like we talked about at that meeting when we were 6-7, saying we had to take a first step, knowing there'll be more steps to come. And we still do have a fair number of people, agents and consumers, requesting farm and ranch style language from a couple different angles. One that I come from is freedom of contract, and that is spurred in a couple different ways in comments we receive. Right now, we have just an ability to contribute to a buyer agent's compensation. It's meant to be a contribution from the seller, not to the buyer agent to pay the buyer agent directly, but a contribution to pay the expense that the buyer pays to the buyer's agent. There's nothing for the seller on the seller side to contribute or pay anything, or excuse me, the buyer to pay any part of the seller's expense for paying their agent. So some of the requests that we come in is there's deals, whether it's a short sale, whether it's a factor may not be as prominent as buyer risk, or as the buyer side needing that compensation or wanting that compensation. So why are we limiting it to just buyers? Why aren't our contracts fair? If we stick to the contribution side, I don't necessarily subscribe to go that far to think we need to make everything absolutely fair, but I am big on freedom of contract. And I think the farm and ranch language allows the parties to agree one way or the other. And I say farm and ranch, not following it word for word, but having it to where the buyer can offer to pay this certain amount and the seller can offer to pay this certain amount. You go a step further in commercial, which I don't think we need to go to, is you have sometimes, depending on where we go, direct payments not only to contribute to the expense, and farm and ranch incorporates this too, but to pay directly, right? It's contractual obligation for the buyer to pay the listing broker directly, or for the buyer to pay the listing, or vice versa, buyer to listing broker, seller to the buyer's agent, to pay those commissions in there. And it's a very simple one paragraph that buyer agrees to pay listing agent X from here, and seller agrees to pay agent Y. It's there in a way that's worked functionally in commercial deals for a very long time. It's worked in farm and ranch context for a very long time. I think we're going to come to a point in the industry in the very near future that we're getting away from buyer's comp and in getting away from not just a majority or a lot, but almost exclusively getting away of where the forums will lead and what the discussion is. And it's going to leave the parties having to draft their own forms in different ways. Nothing's set in stone, but it seems sure that's where everything's going. And anticipating that, we're looking at it being even more important for us to either use paragraph 12, stick with that and really revise it, or look at this additional language in farm and ranch to provide the opportunity to make those agreements between sides. It would be a big sea change, I think, in general practice, but it's one that I think is understandable. That is not language like we have in paragraph 12 that I think everybody's getting educated on and learning more, and it's fairly easy to use, but it's pretty black and white when one side agrees to pay the other side X amount. And it's stated in those simple terms. So that's where I teed up of, this is one I'm not really firmly on it. I'm swayable, but I really like the ability of that freedom of contract to make those agreements completely. And I get the understanding and seeing it on the, I haven't seen it much, but I'm actually dealing with one right now in a short sale. It'd be really great if there's a form in that transaction before they did it to have the ability for the buyer to pay some to the fees that were going there. Now the agents are the ones losing out because they're just trying to help them get the deal done. So that's where I'm at, to tee it up the thought of having that, to see if anybody, because I know it was 6 to 7 at the beginning, has changed course as we've lived now with paragraph 12 for a while. And I would say my position is probably softer now than it was originally. I was pretty firm farm and ranch. I liked it. I was in favor of it. Seeing how paragraph 12 has worked out has softened my thoughts on that, but I still like it for the reasons I just stated.
I think the biggest thing here is, I mean, I could go either way. I mean, I like 12, but just get rid of the 2402 and just put it in the contract. I don't care if we put the wording of farm and ranch or if they learn how to negotiate, but it's driving me nuts that agents are so lazy and call you and ask your compensation before they show the house and they want the 2402 signed. It just drives me nuts. It's like, didn't you hear we're all negotiable? And we're not negotiating right now. I'm just saying, hey, Candy, what is it? Oh, I don't like it. Okay, we'll go show this house. I mean, you know it's happening all day long. So, I mean, I like what we have, but I also, if that would appease that stupid form, I'd be okay with it, because the 2402 drives me nuts, because you have brokers saying, don't go forward until you have a 2402.
Well, and that's not a trick form, as we all know. What they're asking for is having something in writing, and that's what they're not getting. And I was on that initial vote on the farm and ranch side because of the signatures from the buyer and the seller and the signatures of the agents, which we didn't have anyplace else. And it is still there in farm and ranch. It's worked for farm and ranch. There's got to be a reason that it has. And maybe we're kind of circling back, because I could go either way, but I am leaning more toward the documentation that what's in farm and ranch provides, because there is still confusion in paragraph 12. The agents, even once, if we do take off the bottom of page 10, they still don't know how to use it. And this would be a lot easier, and it would be better for, in my opinion, the buyer and the seller and the agents to have in one place, no 2402, no anything else, no, I refuse to sign it, and the agent writes the offer and don't know what the compensation is, if the offer includes in the ratification fee and in here what the compensation from who is going to be. I mean, I could vote that way very easily.
I'm just gonna ask, because I don't do a ton of farm and ranch. It says ratification of fee, listing broker has agreed to pay other broker. And in paragraph 12, we're not paying broker to broker compensation.
So if you go down below, the second one is the.
You'd have to take out the ratification and go to the bottom.
Say where?
Right there.
Oh, you're talking about this bottom part.
Yeah.
Okay, because I'm like, wait a minute, no.
Because they
We're
took
trying to
away.
Get away from that.
Yeah, because they took away ratification 3 years ago, 4 years ago.
This is on the,
It's
this is on the
it's
website
still there.
right now.
It's still on the ratification is still
No,
on
they
there.
took away the word ratification.
No,
And they
it's
only put
looking at it
broker,
right here.
not on farm and ranch. I'm saying on our residential.
No, we're only talking about
Yeah, it
farm.
never was on residential.
It was never.
It was about 5 years ago.
Mm,
It said ratification.
No,
But go to this, so that provision there, Melissa, allows either side to pay the other side's broker's fees.
What you were saying, John, there are more buyers that are wanting to contribute, and this puts it all right there. And like Diane said, everyone knows, is the seller paying part of this, the buyer paying this, who's paying what? And it's there.
So
Good.
Oh, I'm sorry. My question is when our, because 24.2 is not ours, is this on top of, because there's, even if the seller agrees up front to offer compensation to a buyer's agent, is that what is being put here, or this is what would be on top of? Because I see confusion from the agent side. Right now, they're clear that there are some fewer and fewer, but say a seller is offering 1% upfront to BAC. And then if a buyer's agent and their buyer come along and negotiate 2% more of the contract, then 2% is going in paragraph 12, and they're also getting the other 1%. So I need an understanding fully on how we transition where we've already gotten agents to see where we're at now with the use of 12 to transitioning to this and how we mesh all that together. I'm not opposed and I'm open-minded. I just need to understand where we bring everybody together.
So the thought about having this discussion at length now is if we're ever going to make a change, it's now, or it's going to be years down the road.
Yeah, right.
And so, because it would make sense to tweak 12, put these out there, and so looking at that, from my thought, 12 would go away if we did farm and ranch.
Okay.
And I believe the 2402 is going to be going away as well.
And I believe they
And
would
so-
also get rid of the 5A. It would strictly be a 5B listing if we did something like that.
And we have this new mandatory buyer rep requirement. We should have it already, but you have to set the amount you're charging. But the buyer reps have an offsetting position, if you try to go get it from the other side. And so if you establish the other side paying it, right, they're going to pay X amount of the contract. You have your separate agreement, and you can, just like with that, so you can, let's say the seller only agrees to pay, whatever percent, 5%, but you have a 10% buyer's rep. They're still going to be on the hook to pay that 10%. You're just getting that 5% contributed to it. So my view in the bigger picture is make it all live in farm and ranch style language outside of 12. And get rid of it. This would be a sea change. That's why it's bringing it up now. So make a change. Get rid of 12. Do farm and ranch.
So put 12 back to just closing costs. And then we're for sure assuming Texas Realtors is taking a listing agreement to take out 5A and because I do think there will be confusion around still having those pieces out there if we go this route.
Yeah, and I don't want to. One thing we don't have any authority over Texas Realtors on what they do. And they can always do a form in the future, or agents can develop their own form outside of this to do what they want. I don't want to speak for, I would invite, if you want to talk on this now, to say.
Look at her smile.
Yeah.
I'm ready. I've been sitting here all day.
If you want to comment on that, I would say, regardless of what they do now, promise to do or intend they want to do or not do, or whatever they say, we'll always be subject to concern about that changing because we don't have authority over, but what they do or intend to do maybe be instructive. So.
Yeah, for sure. So, thank you. And I'm a sad replacement for Lori, or a poor replacement for Lori. She really wanted to speak on this today. So, bear with me. So, she has given me her notes, and of course we've talked quite a lot about this, but kind of to Diane, what you said is this paragraph 12 is still a major issue for agents. This is still 20 to 30% of our hotline calls. We touch base with them and they let us know, and they're actually keeping track. We ask them to keep track of that. And so this is still a really big concern. And so Texas Realtors, a couple of things is, we're really interested in transparency. And I think the problem right now, and that has been, is that there's just not enough transparency and knowledge about what that, concession might be. And so that's where we're looking at how can this come about and be more transparent. So everybody, for the consumer, for the agents, for the title company, who is going to pay what compensation, whether it's the listing broker or the buyer's broker. So that is and so that's what we would be wanting to see is maybe just something that it makes it a little more clear, whether it's the farm and ranch, that is certainly an option, or whether or not it's another form. I know the 2406 was used in the past. We got a lot of positive feedback this is Texas Realtors forms, obviously, from title companies, but just improving and bringing more clarity to that. So that's what I want to go on record, just so we're in favor of that. And then also, just to answer that question that y'all brought up a minute ago, Texas Realtors has made the decision to take away the broker, to eliminate broker to broker compensation.
Thank God.
So I'm not.
Yay.
5A, we're talking about
5A, yeah.
5A,
No,
okay.
so I'm not, I don't have the authority or anything to say anything about any other forms, 24-2, or that y'all brought up or anything like that. But we are going to be moving forward with that. And so that is coming down the pipeline very soon. So anything that can be done to improve transparency and help alleviate the confusion that we're seeing from members would be great. Yes.
I appreciate you sharing that, Ron.
No,
So I have a concern if we're going to do, are you talking about placing something like the farm and ranch language within the contract form or leaving it in the broker information form? Because if we leave it in the broker information form, I think we have a potential problem dealing with acceptance of the contract where we don't have acceptance of the agreement.
Exactly.
There. So if this is built into the contract form, much like what we see in the commercial forms that TR has, then that's fine. I think it's really just a choice of the brokers. What do the brokers want to do here? But because we can draft it the way it needs to be drafted. But if it's separate, I got a problem with it.
And I think it does, in this case, would be part of the contract because there's a little bit of hair splitting with the transparency thing because this would be, again, buyer and seller agreeing to it. This isn't a signature line for the brokers. The transparency part that wouldn't be necessarily solved by doing that is that's not necessarily all either brokers being paid. We depend on how we draft it, right? It can or cannot. It can just be what one side's paying to the other side. And they could be made up by the gap in their own private party agreements. This is where the details of what we draft matter. One of the big concerns we had before with disclosure of everything, of how much either party is paying, the seller's paying their agent in the other side, and vice versa, is the confidentiality, the privacy of those deals. Let's say that deal blows up that you're trying to negotiate, but you're already on the contract, what you're paying your agent. The next guy's going to know how to negotiate better. If I know you're on the hook for this, and so it can be used in different ways. That I don't think it's appropriate having a complete full disclosure in the contract for that reason. I don't want to
If
be
it's
forced
work for
to.
farm and ranch, where would the problem be transitioning it over to 1 to 4?
Well, the farm and ranch placed this in because they had many arrangements where they had open listings or they didn't have listings at all. So they were essentially getting the agreement signed at the time of contracts for compensation.
And many were not part of
That's right.
Texas Association of Realtors
Right.
to use those forms,
right.
deliberately not part of it.
And still are not, so we have to have everything in the TREC form.
Well, so I'm not necessarily opposed to it. I think paragraph 12 works fine if, it's just a matter of understanding what I need to do. In my buyer rep agreement, if I'm the buyer's agent, I'm going to say, you're going to pay me, but don't worry, I'm going to go over there and negotiate the fee accordingly. And it works. And we all know it works because it's happening. So to me, it's a more simple approach if we leave paragraph 12 the way it is. And it uncouples this whole issue.
I'm switching. I was against the farmer ranch in the 1 to 4. I think farmer ranch is working marvelously. I don't get near the volume that TAR gets, but I am sort of a Southeast Texas hotline, and I represent a brokerage with, I think they're like 170 agents, and another one's like 130. And they can't, no one seems to be able to get paragraph 12 right. I mean, it is a regular, constant, never ending. Should I, I'm skipping it. I'm just gonna use a different form. I'm gonna put it, it's more than a 5%. They just can't. And even with, God, I'm raising some hands. And then even with
the tomatoes.
But it's even more education seems to be to get these agents to understand how to use 12 than the simple verbiage that we have in Farmer Ranch. However we put it embedded in the contract, like the commercial TAR form, I know what he's familiar with. I've used it too. I'm all for the Farmer Ranch. Now, I was on the other side in the past. Now I'm flopping.
So we'll go Mary, Melissa, and then Kristen.
I'm okay. I'm with Ron that it has to be in the contract, not on the last page. And I also think we need to change words because we got to get the word broker out of there. We got to have buyer and seller because we've got companies that will not pay brokers, period, end, because of the lawsuit. So we have to have it set up that it's all buyer and seller, and that's putting it in the contract. And I think this is taking this language and going into paragraph 12 and wordsmithing it and making it very simple, who's doing what. And I think that's the way to do it. I mean, but we do need to take off brokers and stuff because we have companies that do not pay brokers.
Paragraph 8, you could put it there.
Paragraph 8.
8B.
So I have several things. I feel like the hotline and your Southeast Texas hotline will be some level fixed. If we didn't do anything, but TXR changes that listing agreement.
Oh, yes.
The real estate population will figure out 12 because it won't be, well, and it won't be, wait, can I do it over here? Should I do it over there? Wait, I don't know about this one. And there won't be.
You're right.
And agents will stop
Right,
calling.
the confusion is
asking what
not,
being offered.
my point is the confusion is not paragraph 12. The confusion is that there's options in the listing agreement currently today that many real estate practitioners use.
And they have not.
That's the issue, right? But, and as much as I like what we already have, and I think we've done such good work, and I want to keep it in paragraph 12. So I think y'all are right on. Because it is a settlement and other expense. It's an expense paid at closing by the parties. But I really like the idea that now that I've read through and I'm on the right paragraph of Farm and Ranch, because I was like, what are y'all talking about? I like the idea of the buyer can pay some money, the seller can pay some money, or maybe both are paying some money to somebody. I mean, I don't know.
And this is where you'll blend it to, Christian, there, blended. The language can be done where either side can do it to the other, whether it's mutual contributions or some payments there that are done with this farm ranch style.
So where I'm going to go is I'm torn and I need to ponder overnight, but here's where I am. One, I do think Melissa's nailing it when the listing agreement takes that out. That solves a lot of issues. Agents will stop calling, they'll stop asking, and they'll get into the right century where they should be of where the industry's going. Two, I do think our tweaked wording on paragraph 12 is much better than what we had to take care of some of the ambiguity from agents who really didn't take time to read or understand the English language. Two, what I do like about the farm and ranch, one, I do like that it gives the offer of buyer to contribute to listing. Yes, thank you. I do think that is important because I do see that is going to be a trend, especially in certain transactions. My concern with it, even if we did something similar to the bold below, what I see happening is agents will not read that and understand that, oh, if I have a separate listing agreement, I don't need to also put it in here and then put what they're getting already in their listing agreement and not understand the fact that this is only here if it's additional outside of your separate written agreement. And so how does that work then? I know that even in buyer reps, they seek first to obtain from the other person, but I'm just saying that I see some levels that would need to be rewritten here in order for this not to create more confusion. And I also would want it in the contract because I think even though it has buyers and sellers signatures, it feels afterthought and not part of all the negotiations going on over here.
I agree. And I think we have to wordsmith that. We'd have to wordsmith that, but I think taking some of this and taking what we've done and making it so that everybody understands and it's not just a headache for everybody.
But it is very helpful, and thank you for sharing the Texas Realtors path on that, because that's great clarity and I think going in the right direction.
Can you imagine how many calls we're going to get when they find out that 5A is one? Oh my goodness.
So what does that leave us for fearless leader for tomorrow? Do you want to begin the day with a swap? It seems like might be a soft majority, but it seems like the majority is like, let's go ahead and plug in Farm and Ranch and see how we can make it work tomorrow. Is that what we want to
I
start
think
the morning?
tonight, let's look at this provision. Let's look at how we can marry it up with what we have, where to put it, and come prepared tomorrow with thoughts on it, on how to do that. And I do think we tackle that. The other items that we have left to talk about tomorrow, one is a potential change to the default paragraph in paragraph 9. And that is something that we, while important, it's not, we can have that in future meetings, I believe. My soapbox issue has been living for a long time, so I can live off for another day. And we also put, what is the other?
The water.
The water. The water thing. Now we did, there are quite a few changes that have been sent to us just now on the water issue for us to look at tomorrow. Ron, do you think that's perfect now because that's part of the kind of supplemental materials to have, or how was that communicated to you? Is that something we want everybody to study tonight and be prepared? Or?
Well, I don't think that there's no problem with taking what Brian sent over. I'm not sure you'll follow this really well unless you look really closely at what he's doing, because he's writing in some things, but I think they should take it and then just get familiar with it. Essentially what Brian would like to do is to make some changes in the water notice itself, because there's some definitional problems with water course. So he wants to take that definition out and just simply use the word ponds or lakes, and then to trigger certain kinds of information. He is simplifying it when you go through it, but it's kind of hard to piece together.
We're trying to read it now, and it's
You're saying is, I remember last time you wanted us to kind of pull it off the table, relook at it. You're saying this will be tabled again tomorrow, or he has done the?
No, he sent over something here. I thought he was going to send more of a draft over that you could take a look at and just compare the two drafts. But but what he sent over was some handwriting changes in there.
So we have some changes.
You have to kind of, it's like a puzzle you have to put together here. I could see if I can try to put some sort of draft based on what he's done fully in the current draft, and maybe bring that tomorrow and see.
So do we tell him that in the morning we could kick off with them, or did we?
No, we didn't say, but I think we probably, since he's an outside on this one, he probably should do that, because he give him an opportunity just to appear before the committee and go from there.
So maybe we start off with the presentation from Brian, set that issue aside, and then jump on 12.
Right.
Farm and Ranch, and then come back to that water issue. The third issue, I'm pretty sure probably pocketed to defer to the next meeting.
Right.
So we can have a decent time, but I think that'd be a good goal for tomorrow.
At the HOA addendum too, I noticed for some changes.
And
I think they're excellent changes, much needed. So.
And those are the ones we made at the last meeting.
Yes.
Yeah, and I think that's, to discuss. Did we say in our things to table it, or did we?
No, I think we wanted to move it forward, but we were waiting.
Yeah, okay, yeah.
I used the wrong term.
Yeah, so yeah, and we pulled back all the changes.
Right.
So we're, the goal tomorrow is to have a product that we can send up to the commission to publish, and then at the end of the process would be ultimately available for use if everything goes okay in June. And with the schedule with removal of 5A, we'll likely probably line up with that to have a uniform transfer over to whatever we come up with 12 however we decide to change it. But I think that's a good goal for tomorrow. It gets Brian in, we get his presentation, we circle back to this, and then we look at water. And quite honestly, water at the end is important, but I think this conversation issue is important, or more important.
And I think we're going to have really look at the timing question here. So Abby's probably going to need to outline for us the whole timing, because if we don't finish tomorrow, then we have to take some things off the table.
And yes, so when you talk about water, we're looking at water in particular.
Whatever,
that's really all we have left, right?
Because
is 12 and water to discuss.
Yeah, so whatever issues we're going to submit to the commission based on timing, if we have to make some choices, we may have to give or take. Now, we do have a directive from a statutory committee, legislative committee, to do the water forum. So I don't want to make that
Yeah, that's.
In other words, we're not leaving at noon tomorrow.
Well, and that's why we're thinking, well, I don't know, if we get prepared tonight, it sounds like we might be down a path that may be reasonable.
we
there.
could,
And
yeah,
these
it might be
changes-
one or two.
The changes to water may not be as confusing as they look right now, because they're handwritten and all over the place, so we might be able to get there.
And I think if we get a draft in, then we can get the comments
Well, I
from.
hate to say it, but so few of us, I'll include myself, so few of us know about water rights that there won't probably be a whole lot of comments based on, if Brian Sledge says that's what he likes and Yoda says he likes it, there's probably most of us are gonna go with it.
I can look at research tonight. My issues with some concerns in some language, I can research those tonight to be prepared to present on.
You know, it's similar to like the minerals. You're not gonna be able to get everything in there that the case law tells you.
No, yours
I
not.
mean, it's.
Yeah, I've written on
complicated.
water rights on 3 articles and it's hard to.
It's too complicated.
The section that is in every one of these contracts, including condos, which I have a question about high rises and the water underneath, if that's appropriate. Is this wording picked up from that 3-page water disclosure? You know, what is the connection here?
So that's the trigger to provide the form or not provide the form.
Okay.
So
And so the wording here, once looked at, does it have to be in every one of the contracts?
I think so. I think the intention.
Even a high-rise condominium one would have this there?
I'm not so sure condo would have to be in there, whether it would be the one, but I think all the ones where you're talking about land development. But I think you have.
I think condo does,
Condo
because we're
have
not
some
talking about
issue.
just high rises for use with the condo form, so we, can
Could be
be,
different kinds
especially
of
here in
condos.
Austin, it's very common.
We got condos right on the ground.
Well, we do too in Houston, but I'm just thinking in terms of condominiums in general, is the wording required, appropriate?
It's not required anywhere for any of the contracts. This was more from the sunsets management recommendations and the representatives that sent in their.
I do think that's a good question for Brian though tomorrow about the condos, how critical it is or not for the condos, because there might be reason not to do it, because a lot of those rights are going to be owned by the association and not by the individual.
But what about all these little lots that they're doing condos to get around the spacing restrictions and the, there's a lot of issues that arise in those that I think some of our utilities and around water that because of the prevalence of the use of the contract in that form, if we're saying it's good for.
Yeah, but what I'm just saying is that would be part of the association disclosures
The
as
general rule
opposed
of
to.
thumb is
Right.
the general common elements include the land underneath the condominium.
But
Right.
we're doing a lot of them where it does not. We're doing the
The
condo
horizontal.
units. Yeah.
Right.
Yeah, because you don't own the land underneath there, except in a percentage of, a shared
An
percentage of
undivided
ownership,
interest.
no lot and block.
Well, what we're also talking about is reserved rights that may or may not. So you're typically going to have the rights, the association is going to be grabbing the water rights and then providing that to their unit holders, is the way I see it. But we'll talk to Brian, I think, maybe, and see how important it is to put it in context.
Because I would like to, if we can, figure out a way where it's not relevant to not have it. We don't need it.
Yeah.
I'm
and I
really
think the
concerned about the centers
disclosure
being
from the
confused.
HOA makes a lot of sense, to Brian's point.
And where it comes in with some recent experience in Austin with disputes of these are formed and they don't know what they're doing, and especially with this one owner, there's a few online services that you can do to form these condos on these little lots, and it's lacking at best in terms of explanation how to operate, what to disclose, and forms themselves. So that's where it's pretty broad to.
So I am the bearer of bad news. So for open meeting purposes, since the building is closed, we do kind of. have to
okay.
wrap it up. I'm so sorry to.
Well,
I
thank
can
you,
see this
everybody.
government employee.
Yeah. Well, thank you, everybody, for staying through a long meeting.
So what's our
We'll circle with us. Look at paragraph 12 in Farm and Ranch.
Yes,
And
absolutely. There's actually.
Ron will circulate the water disclosure revisions we got from Brian.
That's actually.
So if you can look over
Tonight
those.
or tomorrow?
If you can just look over tonight, just to know what we're going to be discussing.
You mean, so he's gonna send us something?
Adjourn this meeting at,
You did send it.
Five, eight.
I have spiders.